You're watching Fox 35 News Plus, streaming on Fox Local.
Well, good morning to you. Welcome into Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us on this Tuesday morning, live on fox35orlando.com. We are joining you this morning because Carly Anderson is in court today. Her trial set to begin in Brevard County. Let's go ahead and get you inside the courtroom here, where you can see Carly Anderson there sitting at the defendant's table, or standing, as we get ready for the jury to file in here. Anderson is the Brevard County teacher who has been charged in connection with the large house party that involved a number of students, more than 100 students, according to police. She is charged with disorderly intoxication, a second-degree misdemeanor. She's also charged with resisting an officer without violence, a first-degree misdemeanor. We should note that the prosecutors yesterday dropped another charge. She had been previously charged with disorderly conduct, which is also a second-degree misdemeanor. Prosecutors dropped that charge yesterday. Yesterday was a full day of jury selection. We know there were several jurors, 7, I believe, who were dismissed because they had seen or knew too much about this case from the previous coverage of it. It is a case that has gotten a lot of attention here. Carly Anderson could face 60 days to a year in jail. Let's go ahead and listen in as things get underway inside the courthouse. This is Judge Kimberly Musselman welcoming in the jury here inside the courthouse in Viera as we get ready for this trial to get underway. Let's listen in. Obviously having some trouble with our feed there. So while we're waiting on that to kind of straighten back out, let's go ahead and I'm going to play for you Fox 35's Esther Bauer, who was in the courtroom yesterday for the first day of this trial, and she gets us up to speed.
She came to court facing 3 charges, but that was dropped to 2. The state decided to get rid of the disorderly conduct charge, which means she's only facing disorderly intoxication and resisting without violence. It took almost 8 hours to even find a jury because so many people had heard about this case or seen the body cam. From a classroom to a courtroom, a BPS school teacher on trial. It all started back in January when Carly Anderson approached Cocoa Beach police officers. Police say she was belligerent with law enforcement and EMTs on scene. They were trying to help a kid who had passed out on the front lawn, vomiting and shaking. Officers tried to investigate the alleged house party hosted by a school principal, but Anderson wouldn't cooperate or come in for questioning.
No, I was no part of it. None.
So she was arrested.
She knows what this is about. That's why she tried to leave work early.
Anderson never accepted a plea deal, so the teacher's taking her chances in court. Her attorney says his client isn't guilty of anything but free speech.
The jury needs to be instructed that everybody has constitutional right to free speech.
The state thinks she's done much more than that.
Carly Gail Anderson was then and there intoxicated and endangered the safety of another person. C.R. Carly Gail Anderson did unlawfully obstruct Demetrius Brown, an officer of the Cocoa Beach Police Department.
Several jurors already had an opinion about the case.
Are you basically equally balanced, or are you leaning one way or the other? Have no opinion.
7 jurors were dismissed because of what they already knew. And the state says 2 EMTs who were on scene at the alleged house party will testify in support of the state's case. We're still not sure if Anderson is going to take the stand to share her side of the story. Opening statements will start on Tuesday morning at 9 a.m. Reporting in
And we are waiting for opening statements to begin any moment now. This is, again, Judge Kimberly Musselman. Our feed is back up here as we get ready for opening statements in this trial. Let's listen in.
Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you to not communicate with anyone, including your fellow jurors, about this case. So no communication includes no emailing, texting, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules, please notify the court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her that you are on the jury trying the case and ask the person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All right, all cell phones, computers, tablets, and other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in silent or vibrating mode. You may use these devices during your recess, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved. Do not take any photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or your electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury room. You cannot have in the jury room any cell phones, computers, or electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. Now, the case must be tried by you on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. That applies whether you're in the courthouse, whether you're at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussion of any sort with friends or family members about the case or the people and places involved. So, do not even with the closest family members make any comments or have them make any comments or ask you questions about this trial. In the age of electronic communications, I want to stress again that just as you must not talk about the case face-to-face, you must not talk about the case by using any electronic device. You must not use phones, computers, or any other electronic devices to communicate. And I know that's about the 5th time I've told you that, but that's the way they ask us to do it. So do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for any advice by any means at all, including posting information on an internet website, chat room, or blog. All right, what are the reasons for these rules? The rules are imposed because jurors must decide the case without distraction and only on the evidence presented here in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or to challenge the accuracy of what you found. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect for that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail or paying a fine or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, and what a witness might have said had he or she been permitted to answer. Now, during the trial, it may be necessary to confer with the attorneys out of the hearing of the jury to discuss matters that require consideration by me alone. It is impossible to predict when a conference may be required and how long it will last. When such conferences occur, they will be conducted as to consume as little of your time as necessary for a fair and orderly trial of this case. So let me explain. You saw a little bit of that yesterday where I will use the white noise. I will bring the attorneys up there, and if it's something that we believe we could resolve within a few minutes or so, we will do that. However, I do want to advise you that there are some times where it may take longer. In that instance, I will have the deputy take you back to the jury room to recess so you can be comfortable while we are addressing that matter. All right, so what you have there in your hands is a notebook with some paper, and either have a pencil or a pen. I do have an instruction regarding note-taking. Okay, so if you'd listen to that, please. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with that notebook each time that you come in here. It will be there on the chair. And does everyone have a pen or a pencil that is in working order? Double check that. If not, we will certainly get you one. However, you should not take them with you from the courtroom. So each time that we recess, please just leave the notebook on your chair. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations in this matter, the court deputy will deliver the notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in the note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take the notes, you should rely on the memory of the evidence, and you should not unduly be influenced of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. All right, State, you may proceed.
Good morning. On January 19th, 2025, the Cocoa Beach Police Department received several calls, all of which were regarding a large open house party involving minors that was taking place at 44 Country Club Road in Cocoa Beach.
Opening statements underway in the trial of the Brevard County teacher Carly Anderson. Having some trouble with our feed here. Apologize for that, but looks like we're back in business
one
here.
final time just to make sure that everyone who had been in attendance at that party had dispersed. And that was when he saw CR hunched over in the front yard of that residence, in the grass, vomiting and spitting. When Corporal Brown began speaking with the minor child, he noticed that he was slurring his words and he was not able to answer the questions that Corporal Brown was trying to ask him. This caused Corporal Brown to become concerned for the child's safety and his well-being. So Corporal Brown contacted the local fire departments and requested that they send medics who could assess the minor child and possibly assist him if he was in need of medical attention. Corporal Brown was also able to contact the minor child's mother to inform her of the situation and what was going on. During this trial, you're also going to hear from one of the emergency medical technicians, or EMTs, who works with Brevard County Fire Rescue. His name is Andrew Rock, and he is going to tell you about his observations of the minor child and what his involvement was in this case. After the child was assessed by the medics and the fire department, and after Corporal Brown spoke with the child's mother, the decision was made that Corporal Brown was going to transport the minor child back to the police station where his mother would meet them, and she would then take care of him from there and determine what should be done with him. You're going to hear from both Corporal Brown and Andrew Rock about Corporal Brown then asked one of the EMTs, two of the EMTs, one of which was Andrew Rock, to assist him in moving the child from the front yard of 44 Country Club Road into Corporal Brown's patrol car so that the transport could take place. And you're going to hear from both Corporal Brown and Andrew Rock about how when they were in the process of moving the child into Corporal Brown's police car, they were interrupted and approached by the defendant, Ms. Carly Anderson. You're going to hear about how Ms. Anderson approached the EMTs, demanding to know why the child was being placed into a machine. When the EMTs told Ms. Anderson that they could not provide her with any information, and that, quite frankly, it was none of her business what was going on, and that she needed to go away, Ms. Anderson became angry, belligerent, and began yelling at the EMTs. Corporal Brown, who was still in the process of trying to place the minor child into the back of his car, heard this commotion and walked toward them in an attempt to figure out what was going on and to make sure that the situation was not going to escalate any further. Ms. Anderson then began yelling at Corporal Brown. You're going to hear from Corporal Brown about the interaction that he had with Ms. Anderson. He's going to tell you what he observed about Ms. Anderson. You're also going to see the interaction between Corporal Brown and Ms. Anderson for yourselves, as this interaction was captured on Corporal Brown's body-worn camera. When watching that video, it is going to become clear to you that Ms. Anderson was intoxicated. Corporal Brown is going to explain to you what impact this interaction with Ms. Anderson had on his ability to care for the minor child that was in the back of his patrol car at the time, that this hindered his ability to care for that sick and impaired child and delayed him in being able to transport the child to the station where he was to be reunited with his mother so that she could care for him. You see, this case is not about what Ms. Anderson was saying or the content of that speech. Rather, this case is about what effect Ms. Anderson's outburst and belligerent behavior had, and that it hindered Corporal Brown in the performance of his legal duties, when at that time he was acting as a caretaker for this minor child who was sick. The state intends to prove to you beyond a reasonable doubt that Ms. Anderson is guilty of disorderly intoxication, as she was drunk and endangered the safety of the minor child who was under the care of Corporal Brown that evening. The state also intends to prove to you beyond a reasonable doubt that Ms. Anderson is guilty of resisting an officer without violence or obstructing Corporal Brown while Corporal Brown was engaged in a lawful execution of the duty. At the conclusion of this trial, when you have seen and heard all of the evidence for yourselves, the state will then ask you to return a verdict of guilty for both counts. Thank you.
All right, defense, you may make an opening statement if you wish.
Yes, Your Honor. Good morning, ladies and gentlemen, counsel. So, As you know, this entire event revolves out of a high school party at Miss Anderson's friend's house that got out of control. And there's nothing new about kids having high school parties. They did it when I was in high school. They still do it. What's new now is digital media. And they get on something called Snapchat, and instead of just telling a few friends, hey, we're going to have a little get together, come on over to my mom's house. It goes on Snapchat, and kids pick it up all over the place and show up from everywhere, and it gets out of control real quick. So that's what happened, and this happened on January 19th of this year, which was the night before Martin Luther King Day. Martin Luther King Day was a school holiday, and this was a Sunday night. Okay, so the principal, Ms. Hill Brodigan, friends with Carly Anderson, called her up and said, hey, let's go out and have a drink. They live right down the street from each other. And Ms. Hill Brodigan picked her up, brought her out to a local establishment in Cocoa Beach, just a few miles away from their house on Minuteman Causeway. And they both live on Minuteman Causeway. And they proceeded to have adult beverages, and were in the process of thinking about ordering some wings and having a night out. At that moment, somebody from the Cocoa Beach Police Department called Miss Hill Brodigan and said, there's a party that's out of control at your house, and you need to come home right now and disperse it, extinguish it, fix it. So Miss Anderson gets informed of this and says, okay, I'll go with you. Big mistake on her part. That's where things start to go wrong for her. No good deed goes unpunished. So she drives, they drive back to the house. They may have made a stop someplace else. Within a few minutes, they're both back at the house. Miss Hill Brodigan goes right by Miss Anderson's house, doesn't give her an opportunity to get out of the car. And there's the remnants of an out-of-control party is going on. They proceed to work on telling the kids to go home. This house that this party is at backs up onto the golf course. So I'm imagining kids were running around on the golf course and making a nuisance to all the neighbors. So she was there for some time and never provided any alcohol to any minors, never had a drink with any minors, never knew anything about this party until the police called and said, you need to come back here. So I'm thinking it's about an hour after they returned, and that's when you're going to see a body cam clip. It lasts about 3 minutes, so don't worry, it's not going to be like grueling long or anything. And it shows Corporal Brown, who found a young man in the front yard, I think he said, vomiting and shivering. Well, this was towards the end of January, and I think this kid didn't have a jacket on, and it was probably about high 50s or 60 degrees. So he was cold, and probably had too much to drink, and sitting in the grass in front of Hill Brodigan's residence. So Corporal Brown calls the ambulance, which probably is an overreaction, but that's his choice. In the abundance of caution, call an ambulance on a drunk kid who's puking, that's okay. He calls EMT, the fire department shows up, they evaluate the kid, who is CR, state has told you, and that's his name for this trial today. They evaluate him, and he apparently is fine. And Corporal Brown asks him some questions. It's his mom's phone number. He calls the mom, and I think you're going to hear testimony that the mom was in Orlando or Sanford, but would come over to the Cocoa Beach Police Department to pick him up. And I'm going to ask Corporal Brown about that. And you just watch the video carefully. They pick up the kid. They go, 1, 2, 3, come on. You'll hear his name. 1, 2, 3, come on, let's get up. And Corporal Brown has agreed, for some reason, to put him in the back of this police car and take him to the Cocoa Beach Police Department where he can meet his mother. Instead of, knocking on the door of the residence and saying, hey, need to take care of this kid until his mom gets here, he's putting him in the back of a police car. And about 99% of the people that get put in the back of a police car are under arrest. So the kid is in the police car. No more emergency services being rendered on him. He's actually in and sitting down. And then you see Mrs. Anderson come out of the darkness. And yes, she was intoxicated at that point in time. She comes out of the darkness and goes, "What are you doing?" And the paramedic, maybe it's Mr. Roque, maybe it's one of the other ones, basically says, "None of your business," and then he walks away from him. That's it. Kate is already in the police car, and then Miss Anderson, who is a school teacher, is very familiar with Corporal Brown. He was a school resource officer at her school, which is also right down the street from where all this took place. And she knew him very well. They had spent many hours together during fire drills and in recess, talking to each other, and really had become friends. So she's familiar with Corporal Brown and considers him another professional in the area that's trying to take care of this kid. And she starts talking to him. She says, "What's wrong with him? Why won't they tell me what's going on with this kid? You guys are out of control." And she has a moment. And Corporal Brown is very calm most of the time. And she uses the word, "I'm concerned about this child. I'm concerned about a child being put into a machine." She says, "I've been at this party," and what she was saying is, "I've been here for an hour since the police told us to come back and disperse the party." And she basically has some conversation with him. She doesn't threaten him. She doesn't touch him. At one point in time, he flips the switch, so to speak, and starts yelling at her. He goes from calm to absolutely yelling at her. And he says, "I'll tell you what's going on. There was 200 kids here drinking with you and your boss, and get out of my face." And he turns and she says, "That's on your body cam," and walks away. And that's it. That's the whole case. So he got it wrong. She wasn't there drinking with juveniles or throwing a party. Not in any way. And I don't know what duty she obstructed him in doing, what legal duty or legal process. Kid was in the car. He had a consensual citizen police encounter with her. And although it's probably a bad idea to yell at a police officer, it's not illegal. It is protected under the First Amendment, our right to free speech. And we can say what we want to, as long as it doesn't, rise to the level of committing a crime. You can't sit in a theater full of people and yell fire when there is no fire and have people trample themselves on the way out. That's the common example of when free speech is a crime. So what she did is have a conversation with him. He yelled at her and said, "Get out of my face." And that was the end of it. And he walked around and got in the car and drove CR to the police department. CR was never endangered by Miss Anderson, and Corporal Brown was never impeded in any way. He chose to talk to her, and they knew each other well. It's not like they were strangers, and they engaged in a conversation which he ended at his choice when he was ready. You'll also hear that Corporal Brown was a law enforcement officer working for Cocoa Beach Police Department that night. I assume he still works there. And he didn't arrest Mrs. Anderson for anything. He didn't arrest her for disorderly intoxication. He didn't arrest her for resisting without violence. Had he observed those crimes, he certainly could have called another officer, said, "CR, you're going to have to wait a minute while I get another officer here to put Mrs. Anderson in the back of a police car." But notably, he didn't observe those crimes. He didn't choose to make any arrest. So you will hear more details, and I think we'll be able to conclude this case today, probably. So just pay attention, watch the video, watch for what I was suggesting. CR is in the car before Miss Anderson appears out of the darkness. And that's when there's no endangerment of CR by her at that point in time, because they already did whatever they're going to do to him. And even if she had have got up to him before they put him in the car, he was never in danger of anything except for his own excessive drinking as a minor.
All right, thank you. Deputy, can you approach for a moment, please?
Opening statements have concluded in the trial of Carly Anderson. Let me do a little bit of math here. It looks like the defense spoke for about 12 minutes for their opening argument. There you see Carly Anderson looking back toward the gallery. The defense spoke for about 12 minutes, the prosecutor only for about 5 minutes or so, as they kind of laid out their case and what they want the jury to be aware of and pay attention to. The prosecution talking about the effect that Anderson's alleged actions had, while the defense saying it was basically a misunderstanding and that the child was never endangered by Anderson's actions. First witness here, one of the EMTs on the scene that night.
I swear affirm the testimony you shall give will be the truth, the whole truth, nothing but the truth, so help you God.
Please watch your step, and as you'll note, you don't want to push back. You can move the chair in front of the room.
Good morning.
Morning.
Could you please state your name and spell your last name for the record?
My name is Andrew Rock, R-O-C-Q-U-E.
Where do you work?
I work for Brevard County Fire Rescue.
How long have you worked there?
2 years.
What is your position with Brevard County Rescue?
Firefighter EMT.
And is Brevard County Fire Rescue sometimes called BCFR?
Yes.
I want to direct your attention to January 19th of this year. Were you working that evening?
Yes, ma'am.
What station were you working at?
Station 51,
Where's that?
Cocoa Beach.
Around 11 p.m., 11:19 p.m., were you dispatched to a call?
Yes, ma'am.
What was that call in reference to?
We were dispatched to a sick person.
When you say we, was someone else with you?
My lieutenant.
What was the location of the call?
It was in Cocoa Beach, 44 Country Club Road.
Okay. And what kind of area is that?
It's a neighborhood.
When you got to your dispatch to the call, did you arrive at Country Club Road?
Yes, ma'am.
What did you observe once you got there?
When we got on scene, the engine was already on scene. We saw
I'm going to
kids.
stop really quick. When you say the engine, what's the engine?
It's a fire truck. It pumps the water.
Okay. And what kind of vehicle were you in?
I was in the rescue, which is an ambulance.
Okay. So the engine's there, and the ambulance comes. Okay.
Yes.
And then what did you observe?
When we got on scene, we saw kids all around. They were walking through the yard. We saw the one minor that we were giving attention to. He was sitting in the grass near the road with the officer, and then Engine 51 was there on scene getting vitals and talking to the officer and the minor.
Okay. When you said the engine was getting vitals, are those other firefighter EMTs?
Yes, ma'am.
Okay. And when they're getting vitals, what kind of things are you looking for?
We're just getting the basic blood pressure, pulse, SpO2 reading.
What's SpO2?
Just their blood oxygen level.
Okay. So the juvenile was assessed.
The juvenile was assessed. He was answering our questions correctly, and his vitals were great.
Okay. Based on that, what happened next?
Based on that, we determined that he did not need to be transported to the hospital. There was no need for him. He didn't need emergency medical care.
Okay. So once it's determined he doesn't need to be transported, what was the next step in your process?
Well, the next step in our process, since he is a minor, we did need to call his mother because he cannot refuse on his own.
Refuse? What do you mean by refuse?
He cannot refuse to be transported to the hospital.
Okay.
He can't sign a piece of paper saying that he does not want to go to the hospital.
Okay, because he's a
our
kid.
computer, yes, because he's a kid.
Okay. So somebody
So-
called the mom.
So the police officer called his mom, said that we checked him out and that he was good. He didn't need to go to the hospital. He was answering our questions. And then we had the police officer witness us signing the refusal, because obviously the minor couldn't sign, so we had the police officer witness it.
Is that like a form?
Yeah, it's a form. We have it on our computer and we just sign it electronically.
Okay. So that form gets signed by the Cocoa Beach officer,
Yes,
and the child's not going to be transported?
yes.
Okay.
Because mother was not present.
Okay. So after you got the form, then what happens?
After we got the form, Engine 51 got the refusal form. We typed that up as a cancel on our part. The engine cancels us on scene.
What does that mean?
Basically, we don't have to do any patient care, and we're not loading them up into our ambulance
Okay.
and taking them to the hospital.
Okay.
So it was.
So your call's kind of.
Yeah, it was
say
it
canceled.
was a PD matter after that.
Okay. Okay. So the call gets canceled, and then what happens?
When the call gets canceled, we basically pack up and we leave once we confirm with the officer and make sure everything's good on scene, that they don't need our attention anymore.
Okay.
Then we'll pack up and leave.
Did Corporal Brown, did you pack up and leave?
No, Corporal Brown asked us to help get the minor into the car, into
Whose
his car,
car?
his cop car.
Okay. Asked you and your lieutenant?
Yes,
Okay. Did you help with that?
we did. My lieutenant was the one standing beside the minor and helping Officer Brown put the kid into the car, help him walk him to the car. I was just walking behind. And at that moment, when we were trying to put the minor into the car,
Just, sorry, I want to really quick. How would you describe the condition of the child?
he was with it, but it was cold, so he was asking for a blanket.
Okay. Okay. Okay, so then he's getting put in the car. Sorry, I interrupted you.
Yeah, we were putting him in the car, and that's when a lady came up and asked what we were doing.
Came up to the car.
Yeah, she was a couple feet back, but yeah,
Did you know who she was?
no, had no idea.
Was she saying anything?
She just was wondering what we were doing, and we told her, this is none of your business, please go away.
After you said that, what did she respond at all?
Yeah, she was very angry at our response. She didn't like that we told her to go away. And she also was like, please don't put that kid into that machine.
Okay, so she comes up, you tell her to go away, and then what happened? Did you?
She did not go away. She kept yelling at us.
Okay. And what did you do?
We kept trying to be very nice and telling her, please go away. This is none of your business. We can't tell you anything under HIPAA. This is a private medical.
Okay. Then did you keep engaging with her, or?
No, she eventually steered her attention to the officer because she didn't like how we were talking to her. So she got angry with us and then started to talk to Officer Brown and was like, do you hear how they're talking to me? And wanted him to make us cooperate.
Okay. And did you, after that, did you guys stick around, or what happened?
We hung around for a minute or two, and then after her attention was focused on Officer Brown, we kind of looked at Officer Brown and was like, okay, this is yours, we're gonna get out of here. And we kind of just did that and left.
Got in
It
the
was not our
ambulance
scene
and left?
anymore. Yeah.
Okay. May I confer with counsel?
Yes, you may.
Nothing further from the state.
All right. Vince?
Good morning, Mr. Rock, right?
Yes.
Okay. So when Mrs. Anderson first contacted you, the juvenile was already in the back of the police car, wasn't he?
We were just about to get him into the police car.
Have you reviewed the video in this case?
I saw the video. I saw it once. And that's because it was posted all over social media.
Yeah. You saw it once a while ago?
Yeah.
Okay. Did you see yourself on the video at all?
I did see myself on the video.
Okay. And you guys determined that the minor, CR, was okay, right?
Yes, sir.
And in fact, Mrs. Anderson didn't do anything to endanger him, did she?
No, she did not.
Okay. And when she was talking to you, she didn't threaten you in any way, did she?
No, she did not.
Okay. And you say that did you personally have a conversation with her, or was it your supervisor?
No, I did not say a word. It was my supervisor that told her to go away.
And that was it, right?
Yeah, that was it.
There was no discussion about this is a private matter with HIPAA and all that, right?
We don't go out and say it's HIPAA. We just say it's a private matter. Please go away.
Right. Okay. And that was the end of it for you guys, right?
Yes.
Did you see Mrs. Anderson commit any crime?
No, sir.
Okay. I have no other questions.
All right. State, any redirect?
When the decision is made not to transport someone, does that mean they're totally fine and healthy?
We can't diagnose. We can't be sure that nothing is wrong. That's the hospital. They have to do blood cultures. But we do tell them, hey, we would suggest transport and everything. And then they have their free will to decide if they are able to, and they are able to answer our questions, which means they are in the state of mind to make that decision.
Could someone be considered sick but not meet the requirements that you have to
Yes, ma'am.
transport them?
Yes, ma'am.
Okay. And then when the ambulance left, was anything still going on? Was everything quiet and peaceful?
No. The lady was still arguing with the officer.
Okay. No further questions.
Okay. Any recross? Defense?
Just 1 second, Your Honor.
Sure.
Just very briefly. Were you aware of where this kid's mother was, by any chance?
We got told that she was in Orlando.
Okay. And you were under the impression that she was going to drive from somewhere in Orlando to go to the police department to pick up intoxicated CR?
Yes, sir.
Is that what's going on?
Yes, sir.
Okay. I have no other questions. Thank you.
All right. All right, so you may step down. Subject to recall? State?
Yes.
Okay. All right, State, you can call your next witness.
The state will call Demetrius Brown.
Also, please note not to push the chair back too far. Thank you. You may proceed when ready.
Thank you, Judge. Good morning.
Morning.
Can you please state your first and last name and spell your last name for the record?
Demetrius Brown, last name spelled B-R-O-W-N.
Where do you work?
The City of Cocoa Beach Police Department.
How long have you been employed by the Cocoa Beach Police Department?
6 years.
Can you please explain, just in a broad overview, the experience and training that you had to have in order to become a police officer?
I had to take a 770-hour course mandated by Florida Department of Law Enforcement. After completing that, I completed a series of training at my police department with a certified training officer before I became a sole officer on my own.
And what do your duties entail now with your job?
My current role is police corporal. I am a mid-level supervisor where I supervise a shift of 4 people.
What shift do you typically work?
I am currently assigned to our day shift.
What shift were you assigned to in January of this year?
I was on night shift.
Night shift? What are those hours typically?
6 p.m. to 6 a.m.
Directing your attention back to the night of January 19th, earlier this year, were you working that evening?
Yes.
And what were your duties that evening at work?
I was assigned as patrol corporal, so my duties were to supervise the shift, make sure officers are conducting her agency policy.
That evening, did you go to 44 Country Club Road in Cocoa Beach?
Yes.
Why?
We responded initially to a noise complaint.
What was that noise? Just give us kind of a big, broad background of what was going on that evening.
The call was dispatched regarding loud music, people running through neighbors' yards, and smoking marijuana.
And how many times did you respond to that address throughout the course of that evening?
I believe approximately 3 times.
And why were you, I guess, going and leaving and coming back?
The first time I responded after 2 other officers had already responded, and they made contact with someone and advised them of the complaint of the noise. So we left after that. And then we received another call, which we ended up going back out there a second time.
And how would you describe that location?
There were a lot of vehicles along the roadside in front of the house and further down in front of other residences as well.
Later in the night, after approximately 11 p.m., did you return to the house again?
Yes.
And why did you do that?
I drove down there to make sure that everyone had left and that there weren't still, people hanging around in the yard and things like that.
Okay. And when you drove by that time, a little after 11 p.m., what did you observe?
I saw 3 juveniles in the grass. There was one sitting who appeared to look ill.
And what were the other 2 juveniles doing?
They were standing there next to him.
Did you get out and interact with them?
I did.
And what was happening with the minor child at the time the one who was in the grass?
So as I walked up, I could tell his face was flushed. He was vomiting in the grass. So those signs to me that something was wrong.
Did you attempt to speak with him?
I did, yes.
And how did that go?
He was unresponsive to me.
What did you do after encountering him?
I tried to find out his name and things like that from the people that were standing there with him. And then I eventually called our fire department and paramedics to come check on him.
And what was it that caused you to be concerned enough that you called Brevard County Fire Rescue?
Because I knew that there was alcohol involved at the residence, I assumed that he was probably under the influence and that he needed some type of medical attention. I wanted to make sure that nothing serious was happening with him.
And what happened after Brevard County Fire Rescue arrived?
Between them and our fire department, they checked his vitals. They made sure that he was okay for the most part, and they were able to actually get his parents' phone number, so I called his mom while they were doing that.
So when you were able to contact his mother on the phone, what was the end result of that?
She was going to come pick him up from our police department, so I explained to his mom that I was going to drive him there and sit with him until she arrived.
So you were going to be supervising him and caring for him until she could get there herself?
Yes.
And after this decision was made, after you spoke with the juvenile's mother, what did you do?
I asked one of the paramedics to assist me with getting him to my patrol vehicle.
Did they help you?
Yes.
And while you were in the process of getting the juvenile into your patrol car, what happened next?
After putting him in, I heard a commotion behind me, and as I turned around to walk back towards the paramedics, I observed the person who was talking or yelling towards them.
And who was that person?
That would be Miss Carly Anderson.
How do you know Miss Anderson? Or how did you recognize her that night?
I recognized her because I've worked at the elementary school before a few times, and I recognized her as one of the staff there.
Do you see Miss Anderson in the courtroom today?
I do.
Can you please point to her and identify an article of clothing that she's wearing?
She's wearing a black shirt with a necklace.
Please let the record reflect that the witness has identified the defendant.
So reflected.
Why did you walk towards the commotion that you heard?
Because I didn't know what was going on. I didn't know if someone needed help or if there was someone else in danger. So I went to see what the issue was to try to resolve it.
And when we say commotion, can you describe what that was?
It was loud yelling as if someone was upset.
When you walked back there, did you then interact with Miss Anderson?
Yes.
When you approached her and the EMTs, were you wearing your uniform?
Yes, I was.
Is that the uniform that you're wearing today?
Yes.
Can you please describe your interaction with Miss Anderson?
She seemed upset. I could tell that she had been drinking because I could smell the odor coming from her breath. And it was just a different demeanor than what I'm normally used to seeing her in.
And how would you describe the demeanor with which she was speaking?
That night, I would say she was clearly visibly upset. Yeah.
Was she speaking at a normal volume?
No, she's loud.
Was this interaction with Miss Anderson recorded?
Yes.
How was it recorded?
On my agency body camera.
May I approach the witness?
You may.
Yes.
And how do you recognize it?
My signature, or my initials are dated there.
And what is that?
That is it's a USB drive with my body camera video on it.
And is that a fair and accurate depiction or representation of your body camera recording from the night in question?
Yes.
At this time, the state would ask to move the state's exhibit A into evidence of state's exhibit 1.
All right, any objection from the defense?
No objection, Your Honor.
All right, it'll be moved in as State's Exhibit 1.
Permission to
Yes, you may do that.
Looks as if we're going to watch some body camera footage here, and so I want to give you a warning just in case there's some language. I don't remember what we may hear here, so just want to give you a warning that keep your ears out for that. But we do advise viewer discretion. This is a live court proceeding going on right now in Brevard County, so keep that in mind as we continue to watch together.
You want the lights lowered, or do you want it to?
Yes, please.
That's Brevard County Fire Rescue.
Well, you know, I'm a teacher. Who the fuck is you put it moving about that next part?
It's okay, but they just like they can.
I was here hanging out at this party. I mean, what the fuck? What's wrong with them?
Okay.
You guys gotta act better.
Do you want the truth? There was like 200 kids here.
I've already known.
Drinking, okay? And you're drunk as well.
I'm not drunk.
Yes, you are. I smell it.
Oh, you smell it?
Yes.
All right, let's do it.
No,
Do
we're
a
not
test.
going to do that, but
You need to do a test.
purpose.
But I'm saying, but I'm concerned.
And you're intoxicated too.
Oh, who cares? So I look at your car and my view or call my
Because he's 17 and he was here drinking at a party.
Why are you yelling at me?
Because you're yelling. You're here with your boss having a party with 200 kids who are drinking. Get out of my face. Now.
That's on your camera.
It is.
were you at 44 Country Club Road when Miss Hill-Brodigan and Miss Anderson had initially appeared at the party?
Yes.
How much time approximately had passed between when they were initially seen at the party and the interaction that we just watched?
I would say probably approximately about 15 minutes.
At the time of your interaction with Ms. Anderson, were you engaged in the lawful execution of a legal duty?
Yes.
How would you characterize the duty that you were engaged in at that time?
I had a duty to care for the juvenile and make sure that he was safe. So I was in the process of doing that.
What effect did your interaction with Ms. Anderson have on that duty?
It took my attention away from the juvenile who was placed in the back of my car, who I could not see because I was interacting with her.
And why did you, when you heard her yelling at the EMTs, why did you feel the need to go back and investigate what was going on?
Because disturbances can lead to anything, you know, especially if I don't know what's going on. So it's a safety issue, and I also wanted to make sure that the paramedics were also okay.
On the video, we heard you eventually get frustrated with Miss Anderson and tell her to go away. Why did you do that?
Because after trying to give her some explanation without giving too much information, I realized that I couldn't get through to her, couldn't reason with her, so I just decided to end the conversation.
Why did you feel like you could not reason with her?
Because usually someone who is impaired, it is harder for you to talk with them and get an understanding because of the intoxication level.
In your experience as a law enforcement officer and even in your own personal experience, have you encountered people who are drunk?
Yes.
And what do you typically observe about people who are drunk?
Everyone's different, usually on the impairment, but slurred speech, you know, bloodshot eyes, flushed face, things like that, that would indicate impairment.
And based on your observations of the minor child, what were your concerns regarding his level of intoxication?
He was impaired, and I didn't believe he would be able to take care of himself without an adult.
What concerns did you have about leaving him in the back of your patrol car alone, unsupervised?
Alcohol affects everyone differently, especially for someone who's a minor. He would have had a medical episode back there while I was talking with Miss Anderson. Wouldn't have been able to know because I wasn't in the vehicle with him.
And did your interaction with Miss Anderson being forced to kind of ameliorate that situation, did that prevent you from transporting the juvenile, or I guess delay you from transporting the juvenile?
Yes, it did.
Why did you not make an arrest of Miss Anderson at that time?
I was the only officer there, and the child was more of my priority concern than making an arrest at that time.
So you would not have been able to arrest her since the juvenile was already in your vehicle?
Yes.
Did this encounter occur in Brevard County?
Yes, it did.
May I confer with counsel?
You may.
No further questions at this time, Judge.
All right. Defense, you can cross-examine.
Morning.
So your engagement with Mrs. Anderson is just what we saw here. It took about 2 minutes?
Yes, sir.
Okay. And did you feel that that 2 minutes endangered the welfare of the child in the back of your car?
Yes.
You do?
Yes.
When you got back in the car, was he the same as he was when you left him there?
Yes.
Was the door open while you were talking to her?
No.
You'd shut the door?
Yes.
Okay. And how long did it take you to get to the police department?
Roughly 2 minutes.
2 or 3 minutes?
Yes, sir.
And how long did it take for his mother to get to the police department?
I believe about an hour.
Okay. And was the child endangered because of her length of time in getting there?
No.
Okay. And how was that?
Because I was sitting with him the entire time.
And what was he doing?
He was sitting in the back seat. He vomited again.
In your police car?
Yes.
Did you take him into the police department?
No. We sat in the car downstairs.
Did you talk to him?
I did.
Asking him questions about the party?
No.
What did you talk to him about?
I wouldn't be able to remember that.
Okay. So you felt that it was your legal duty to take this child to the police department?
Yes.
Could you have just knocked on the door of the Hill Brodigan residence and say, this guy doesn't need to go to the hospital, but somebody needs to watch him until his mother picks him up?
No.
Why is that?
Because I already spoke with his mom, and that was the preferred choice she wanted.
Did you give her any other choices?
No.
Okay. So that was really your choice?
Not really.
And how is it your legal duty to transport a child who's not under arrest in the back of your police car anywhere?
My legal duty to care for him, as there was not an adult who could legally care for him. He was 17.
Okay. How often do you put people in the back of your police car that are not under arrest?
Quite often.
Often?
Yes.
Okay. Adults and juveniles?
Yes.
Okay. And you know Mrs. Anderson very well, don't you?
I wouldn't. Yes. I'm familiar with her. Had conversation.
Okay. And you were the school resource officer for a while where she was teaching?
No, I just substituted for a little. I substituted. I just assisted for a few days.
Okay, so it wasn't your assignment, but you worked in that role sometimes?
Yes.
And did you have conversations with her?
Yes.
And did you view her as a upstanding citizen, a nice person?
Yes.
Okay. And in this particular occasion, you knew she was upset, right?
Yes.
Okay. And the conversation that you had with her that we just saw in the video was with your consent, wasn't it?
Yes.
And she didn't threaten you or tell you not to do anything, right?
Correct.
And at one point in time, you became loud.
Yes.
And was that because your emotions were widely swinging?
No.
Okay. You went from calm and quiet to suddenly full-on yelling at her.
Yes.
And you told her to get out of your face.
That is correct.
And she did that, right?
I walked away.
You walked away. And you could have ended the conversation with her at any moment, couldn't you?
Yes.
Did you see her commit any crime during that interaction with you?
Yes.
By talking to you?
No.
What was the crime you saw?
Well, there is the 25-foot buffer between first responders.
25-foot rule, is that what you said?
Yes.
Okay. What rule is that? Maybe you could tell me about that.
Objection.
All right, you may approach.
Questioning of the police officer who responded that night continues right now as the attorneys are conferring with the judge about an objection. And it looks like our feed may have frozen here, but it's done that a couple times. I apologize for that. This is a pull feed that we're relying on here. It's done that a couple times, but it has come back. So we'll just be patient with it here for a second. While they're in the middle of discussing a sidebar with the judge, where he was asked what was the crime that you saw Carly Anderson committing that night. You heard the police officer just talk about the interaction. We saw the body camera video as well for a few minutes showing the confrontation between Anderson and that police officer. Some pretty direct questioning in this cross-examination from the defense, asking the police officer about the couple of minutes that he was speaking with her and whether he felt like that child was in danger. He said yes, despite that kid being in the same condition as he was before when he got back to the car. The police officer saying he felt like he had a legal duty to care for that child because he was 17 years old. Obviously, not in a great situation at the time, not requiring emergency medical care, as we heard the EMT testify just a few minutes ago, but still needing some supervision as well, that in the opinion of the police officer, especially who said that the kid ended up getting sick again inside the back of his police car while they waited on his mom to come pick him up. This is the second witness that the prosecution has called. The first one being the EMT who responded that night. Now we are hearing from the police officer, Corporal Demetrius Brown from Cocoa Beach. These are a couple of the main witnesses we do expect. I do believe we also expect to hear from the other EMT on the scene last night. Beyond that, unclear. But it does not seem like a long list of witnesses expected today. We also don't know who the defense may call. Unclear at this time whether Carly Anderson may testify in her own defense. We will have to wait and see with that. Meanwhile, the conversation continues at the bench here. Looks like they're getting ready to break that up. Let's listen in.
Mr. Weaver, you may continue.
Okay, so you can explain your answer if you remember the question.
The HALO law, which was signed by Governor DeSantis, creates a 25-foot buffer between first responders who are actively engaged in an incident.
Okay. Did you see you saw the video that just played, right?
Yes.
Would you agree with me that the child was in the back of the car by the time Mrs. Anderson walked up on the scene?
Yes.
And the child had already been evaluated, and they determined that no medical need was to be served by taking him to the hospital.
Yes.
And that's when you decided you were going to put him in your car and call his mother.
Well, I had already called his mother, but...
What's that?
I had already called his mother before putting him in the car.
And your position is that the 1 minute and 30 seconds or 2 minutes of Mrs. Anderson, someone you know well, asking you what's going on, that endangered this child's life?
Yes.
Okay. All right, thank you. I have no other questions.
All right. State, do you have any redirect?
Just briefly, Judge.
Okay.
Do part of your duties as a law enforcement officer, aside from making arrests for crimes and the things that we typically see police officers do on television shows and all of that, So part of your duties include being a community caretaker.
Yes.
What does that mean?
The best way I can explain that is for like Marchmans and bakers. So someone who is impaired to the point where they can't care for themselves, we have the legal responsibility to take them to a preferred facility to where they can get help and get assistance.
And does part of that duty include ensuring the safety of citizens, people that are part of the public?
Yes.
On cross-examination, you described, or you agreed with defense counsel that the conversation that you were having with Ms. Anderson was consensual. What is your, I guess, reasoning behind that?
So, like I said, initially it was the disturbance that I turned around and approached her in regards to. I could tell she had concerns about the juvenile, and my goal was to try to at least answer a question and give her a brief explanation before leaving the scene and taking the juvenile back to the police department. That was my goal.
So when you say it was consensual, you weren't talking to her against your will?
Correct.
Would it have been appropriate for you to just get in your car and leave the scene with the juvenile without first investigating what the commotion was and the yelling that you had overheard with the EMTs?
No.
Why?
Because if something were to happen, or if something was going to happen, and I just left, it would look bad.
You also stated that on cross-examination that the minor child, CR, was still vomiting in your car?
Yes.
And earlier when you described being concerned about a medical episode potentially happening while you were away, what kind of medical episode were you worried could potentially occur?
Seizures could happen. That happens a lot with alcohol abuse or anything other.
Did you have any concerns regarding the fact that he had still been vomiting throughout the time that you were with him?
Yes.
What were those concerns?
It is very easy for someone to choke on their own vomit and stop breathing.
So although, as you testified, when you ultimately got back to the patrol car, the minor child appeared to be okay, although he vomited later, there were concerns that in the time that you were away, something could have happened where you would not have been able to supervise it or assist him.
Yes.
No further questions.
All right. Any recross?
Would you agree with me that what Ms. Anderson, her interaction with you is just entirely verbal?
Yes.
Okay. And have you discussed this case with anybody else from your department?
Yes.
Okay. And what did those discussions entail?
Objection.
Your objection?
Relevance.
Okay. You may approach.
Another discussion at the bench there over the objection, over the relevance of the line of questioning about his discussion of the case with other officers. We heard just a moment ago in redirect the prosecutors asking about the duty of being a community caretaker. And the officer, Corporal Demetrius Brown, describing the legal responsibility of taking care of people who are impaired, talking about not wanting something to happen, describing some of the medical concerns that he had that could have happened to that child, as he described, including seizures, potentially choking on their own vomit. A couple of things there that he described his concerns about why he wouldn't want to leave that kid who was sick and throwing up unattended. The point the defense attorney making just a moment ago, this being an entirely verbal conversation between the officer and between the defendant, Carly Anderson. We are about, let me see here, when things started, about an hour and 10 minutes into this trial here. Opening statements began right around 9:30 with the prosecution, who spoke for about 5 minutes. The defense then gave their opening statement for about 12 minutes. Just to get you caught up here, if you're just joining us on fox35orlando.com or on YouTube, Carly Anderson facing charges of disorderly intoxication and resisting an officer without violence. She was initially, her initial charges, when this first happened, the initial charges from police included child neglect without great bodily harm, contributing to delinquency or dependency of a minor, and resisting an officer or obstructing without violence. The initial charges from the prosecutor involved disorderly conduct, disorderly intoxication, and resisting an officer. That disorderly conduct charge was dropped yesterday. Now these two misdemeanors, the charges Anderson is facing.
Relevance and sustained beyond the scope.
Okay. Have you discussed the case with any of the members of the state attorney's office?
May approach.
Another objection here as this continues, but we can keep talking about, give you a little bit of background here. Again, as I just mentioned, prosecutors dropped that disorderly conduct charge just yesterday. So there's two charges you're seeing. Disorderly intoxication, that is a second-degree misdemeanor. Resisting an officer without violence is a first-degree misdemeanor. Anderson at one point was facing a felony charge. That was the child neglect, the initial charge from police, the third-degree felony that she was charged with. At that point was when she had been put on administrative leave, taken out of the classroom in Brevard County. And as we've discussed...
Yes.
All right, let's go ahead and get you back into the testimony here.
Yes, I have.
And did the state explain to you the theory of the case here today?
Meaning?
What they had to prove in order to get a conviction on Mrs. Anderson?
Yes.
Okay. And do you think that that ultimately changed your testimony here in court, that conversation?
No.
You would have testified about these things no matter what?
Yes.
Okay. When you yelled at her on the video, you thought that she was responsible for orchestrating that party and providing alcohol, didn't you?
No.
That's what she said.
No. I said you and your boss, referring to Mrs. Brody.
So you meant just her boss, or you meant she was part of it?
Didn't mean any of them. I said she was there with it, not responsible for it.
And you said that she was drinking with juveniles, right?
Yes.
Yes.
Yeah.
And you didn't know that to be true at all, did you?
Correct. Other than her saying she was there at the party.
You certainly didn't see her drinking with any juveniles, did you?
No.
In fact, you never even went into that house, did you?
I didn't, no.
Did any members of the Cocoa Beach Police Department go in that house that night?
I don't know the answer to that.
Okay. And you testified that you had no way of arresting Mrs. Anderson at that moment.
Yes.
That's not true either, is it?
No, that's true.
You had a radio, right?
Yes.
and you could have used your radio to call another police car, which was probably 2 minutes away, correct?
Yes.
And you knew that CR was going to be waiting for his mother for another hour anyway, right?
Yeah.
So you could have sat in the police car, asked Miss Anderson to stay put, and another police car could have come and arrested her. Right?
Could have.
But you chose not to do that, correct?
Yes.
And you chose not to do that because you didn't actually see her commit a real criminal offense, correct?
No, that's not why.
That's not right. When she walked up to you, do you think she was trying to commit a crime?
No.
No.
Yeah.
So you think she committed a crime by accident?
Not really a possibility.
Pardon me? I couldn't.
It's not really a possibility, but
It's not a possibility.
no.
Because you can't commit a crime by accident.
Correct.
Crimes involve intent, right?
You may approach.
Another objection from the prosecution there over the defense's questioning here. Talking about the night that this happened, obviously, and the interactions, the ongoing interaction between the police officer and Carly Anderson. And just to finish my thought during the last kind of sidebar discussion here, Carly Anderson, when she was taken out of the classroom when the felony, because of the felony charge against her specifically, when that felony charge was dropped or amended down to a misdemeanor charge, she was very briefly placed back in the classroom and then removed once again once that body camera video came to light. Once it was released, as had been entered into evidence and released, then the school district talked about the behavior, not liking the behavior they saw in that, and so that prompted a further investigation. So Anderson has again been back out of the classroom as all of this goes on. The defense attorney making a point a minute ago in speaking with Corporal Brown that he did not see her drinking with the kids at the party, that he could have called another officer as backup to arrest her if she committed a crime, and then was just asking about whether she was trying to commit a crime. Let's continue to listen in.
Okay, Your Honor. May I have one moment to speak with Mrs. Anderson?
Yes, you may. All right, thank you. All right, so you can step down and you're subject to recall. All right, state, anything else? Any other witnesses? Okay. All right, so this appears to be a good time for us to take a comfort break recess. So I'm going to have the deputy take you out. I would ask you please to leave your written materials, leave everything here with you on your chair, and then I'd also ask you to follow the instructions that I've given you. You've now heard testimony and seen some evidence. Please do not discuss with your fellow jurors anything about what you've seen so far in the trial. Okay? Thank you.
All right, the jury.
All right, everyone may be seated. All right, are the parties needing a comfort break at this time? And then, Okay, we want to do that. I was thinking we give about a 10-minute break for comfort break and then come back and discuss how we're proceeding. Okay. All right. Court will be in recess for 10 minutes.
Court in recess for about 10 minutes here after the prosecution called 2 witnesses there. We still expect to hear from the defense coming up this afternoon. It seems like things moving along fairly quickly in this trial. We saw the body camera video. We heard from the EMT who responded that night. We heard from a police officer who responded that night as well. So getting ready to hear more from the defense. Unclear what witnesses they may call. We expect things to get back here in about right around 11 o'clock, right around the start of our Fox 35 News Plus. So we're going to step aside here for a couple of minutes, and we'll be right back with our coverage as well.
You're watching Fox 35 News Plus, streaming on Fox Local.
Well, good morning to you, and welcome into Fox 35 News Plus. I realized I had unplugged my IFB, so I'm just going to plug that in so I can hear what's going on here. Welcome back into Fox 35 News Plus on this Tuesday morning, live on Fox Local, fox35orlando.com, and also on YouTube. If you are just joining us here on Fox Local, I want to let you know what we've been doing today. We are live streaming the trial of Carly Anderson. She is the teacher in Brevard County, charged with disorderly intoxication and resisting an officer without violence. This morning we heard opening statements from both attorneys, and then also heard a couple of witnesses who have testified so far. The EMT who responded that night, and also the police officer who had the interaction with Carly Anderson. Now, Fox 35's Esther Bauer is in the courtroom. We expect things to get underway here any minute now. But I want to go ahead and play for you a recap of day one, which was yesterday, jury selection, as Fox 35's Esther Bauer kind of gets us caught up to speed here as this trial continues.
She came to court facing 3 charges, but that was dropped to 2. The state decided to get rid of the disorderly conduct charge, which means she's only facing disorderly intoxication and resisting without violence. It took almost 8 hours to even find a jury because so many people had heard about this case or seen the body cam. From a classroom to a courtroom, a BPS school teacher on trial. It all started back in January when Carly Anderson approached Cocoa Beach police officers. Police say she was belligerent with law enforcement and EMTs on scene. They were trying to help a kid who had passed out on the front lawn, vomiting and shaking. Officers tried to investigate the alleged house party hosted by a school principal, but Anderson wouldn't cooperate or come in for questioning.
No, I was no part of it. None.
So she was arrested.
She knows what this is about. That's why she tried to leave work early.
Anderson never accepted a plea deal, so the teacher's taking her chances in court. Her attorney says his client isn't guilty of anything but free speech.
The jury needs to be instructed that everybody has constitutional right to free speech.
The state thinks she's done much more than that.
Carly Gail Anderson was then and there intoxicated and endangered the safety of another person. C.R. Carly Gail Anderson did unlawfully obstruct Demetrius Brown, an officer of the Cocoa Beach Police Department.
Several jurors already had an opinion about the case.
Are you basically equally balanced, or are you leaning one way or the other? Have no opinion about it.
7 jurors were dismissed because of what they already knew. And the state says 2 EMTs who were on scene at the alleged house party will testify in support of the state's case. We're still not sure if Anderson is going to take the stand to share her side of the story. Opening statements will start on Tuesday morning at 9 a.m. Reporting in Vieira, Esther Bauer, Fox 35 News.
That kind of gets you caught up on where things stood with the jury selection. And this morning we did hear again the opening statements where the prosecutor spoke for about 5 minutes. The defense spoke for about 12 minutes or so, talking about what happened. The prosecutor made the argument that this case is about the impact that Carly Anderson's actions had that night, specifically when the officer was acting as a caretaker for that child, a 17-year-old teenager who was sick because of the alcohol. The officer, Demetrius Brown, you heard his name said there just a moment ago. He was one of the people we've heard from on the stand this morning, talking about how he was concerned about that child, and while he was dealing with Carly Anderson for those couple of minutes. But the defense saying basically it was 2 minutes. Did you really feel like that child was in danger, that something could have actually gone wrong, saying what was the crime you saw here, and kind of making the point that if there was a crime committed, that Carly Anderson could have been arrested that night, that if there was really a concern over the health of that child, that something more could have been done. We did hear from the EMT that that teenager, that 17-year-old, did not require emergency medical care, did not need to be taken to the hospital. We know the police officer called that boy's mother, and they made the arrangement to pick up the child at the police department, and that's why Corporal Brown said he put the child in the back of his car, and that's when Carly Anderson ended up walking up. And one of the things we did see this morning was more of that body camera video. We don't have the full clip for you here, but I want to play for you just a little bit of that confrontation that we saw in court just a little bit ago, in case you are just joining us here on Fox Local.
Into one of these vehicles, and it's not my business. You say something to them. Well,
Just a small clip of that there to kind of give you an idea. Here's some of the other video. The Saturn Elementary there was where Carly Anderson had been put back into the classroom after she was initially removed from the classroom. We talked about this a little bit ago. Let me go ahead and show you the charges here. She is charged with disorderly intoxication and resisting an officer without violence. Those are 2 misdemeanor charges. She had previously been charged with a felony in this, the initial charge being a child neglect charge, which is a 3rd-degree felony. That was dropped, and at that point, she was returned back to the classroom in Brevard County, but very briefly, because as you saw in some of that video, some protests from parents, and then came the body camera video that was released once it had been entered into evidence. And so had been a lot of controversy over that after seeing that. And we heard from board members saying that they believed her behavior was not something that a teacher should exhibit. And so she had been removed from the classroom once again, even after being placed back in the courtroom as all of this, or the classroom rather, as all of this goes on. So she is again on administrative leave while this court trial continues. A number of hearings last week, and then here's another live look inside the courtroom as we get ready for things to begin once again. We expect them any minute now. Jury should be coming back in the courtroom, and expect more the defense to put on their case. Unclear what witnesses, if any, they may call. We don't know if Carly Anderson is going to testify. Still a lot of questions about that. But I'm going to go ahead and play for you here while we're waiting on things to get going. The prosecution's opening statement today, as they kind of laid out their case and what they want people, what they want specifically the jury, what they want the members of the jury to take away and to keep in mind as this trial continues.
On January 19th, 2025, the Cocoa Beach Police Department received several calls, all of which were regarding a large open house party involving minors that was taking place at 44 Country Club Road in Cocoa Beach. And later in the evening, he drove by one final time just to make sure that everyone who had been in attendance at that party had dispersed. And that was when he saw CR hunched over in the front yard of that residence, in the grass, vomiting and spitting. When Corporal Brown began speaking with the minor child, he noticed that he was slurring his words and he was not able to answer the questions that Corporal Brown was trying to ask him. This caused Corporal Brown to become concerned for the child's safety and his well-being. So Corporal Brown contacted the local fire departments and requested that they send medics who could assess the minor child and possibly assist him if he was in need of medical attention. Corporal Brown was also able to contact the minor child's mother to inform her of the situation and what was going on. During this trial, you're also going to hear from one of the emergency medical technicians, or EMTs, who works with Brevard County Fire Rescue. His name is Andrew Rock, and he is going to tell you about his observations of the minor child and what his involvement was in this case. After the child was assessed by the medics and the fire department, and after Corporal Brown spoke with the child's mother, the decision was made that Corporal Brown was going to transport the minor child back to the police station, where his mother would meet them, and she would then take care of him from there and determine what should be done with him. You're going to hear from both Corporal Brown and Andrew Rock about Corporal Brown then asked one of the EMTs, two of the EMTs, one of which was Andrew Rock, to assist him in moving the child from the front yard of 44 Country Club Road into Corporal Brown's patrol car so that the transport could take place. And you're going to hear from both Corporal Brown and Andrew Rock about how when they were in the process of moving the child into Corporal Brown's police car, they were interrupted and approached by the defendant, Miss Carly Anderson. You're going to hear about how Miss Anderson approached the EMTs, demanding to know why the child was being placed into a machine. When the EMTs told Miss Anderson that they could not provide her with any information, and that quite frankly it was none of her business what was going on, and that she needed to go away, Miss Anderson became angry, belligerent, and began yelling at the EMTs. Corporal Brown, who was still in the process of trying to place the minor child into the back of his car, heard this commotion and walked toward them in an attempt to figure out what was going on and to make sure that the situation was not going to escalate any further. Miss Anderson then began yelling at Corporal Brown. You're going to hear from Corporal Brown about the interaction that he had with Miss Anderson. He's going to tell you what he observed about Miss Anderson. You're also going to see the interaction between Corporal Brown and Miss Anderson for yourselves, as this interaction was captured on Corporal Brown's body-worn camera. When watching that video, it is going to become clear to you that Miss Anderson was intoxicated. Corporal Brown is going to explain to you what impact this interaction with Miss Anderson had on his ability to care for the minor child that was in the back of his patrol car at the time, that this hindered his ability to care for that sick and impaired child and delayed him in being able to transport the child to the station where he was to be reunited with his mother so that she could care for him. You see, this case is not about what Miss Anderson was saying or the content of that speech. Rather, this case is about what effect Miss Anderson's outburst and belligerent behavior had, and that it hindered Corporal Brown in the performance of his legal duties, when at that time he was acting as a caretaker for this minor child who was sick. The state intends to prove to you beyond a reasonable doubt that Miss Anderson is guilty of disorderly intoxication, as she was drunk and endangered the safety of the minor child who was under the care of Corporal Brown that evening. The state also intends to prove to you beyond a reasonable doubt that Miss Anderson is guilty of resisting an officer without violence or obstructing Corporal Brown while Corporal Brown was engaged in a lawful execution of a legal duty. At the conclusion of this trial, when you have seen and heard all of the evidence for yourselves, the state will then ask you to return a verdict of guilty for both counts.
That was just moments ago, and here's another live look inside the trial and inside the courtroom rather, in the Brevard County Courthouse in Vieira, waiting on things to get back going after a brief recess this morning. We're going to take a break here on Fox 35 News Plus, but we'll be right back after this.
watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us on this Tuesday morning live on Fox Local, fox35orlando.com, and also on YouTube. But let's go ahead and get you back inside the courtroom here. Here is a live look. We are still waiting on court to resume. This break been a little bit longer than expected. They said about 10 minutes, which would have put it back around 11, now 11:15. Unclear what may be the reason for the delay here, but we expect to hear from the defense this afternoon, and hopefully some more resolution in this could end up coming today. The thought was maybe today or tomorrow, and the things have been moving along fairly quickly, so we could have this case in the hands of the jury in just a little bit. Again, unclear what the defense's plans are, but I do want to go ahead and play for you while we're waiting on things to get back going. The defense's opening statement, where they talked for about 12 minutes and kind of laid out their case, what they want the jurors to keep in mind, specifically when it comes to the actions of Anderson, basically chalking it up as a misunderstanding, that Anderson was not trying to obstruct anyone. She was had some concern for this child being put in the back of a police car, and basically saying that this police officer just got it wrong. So I want to play for you that opening statements from the defense just moments ago.
As you know, this entire event revolves out of a high school party at Miss Anderson's friend's house that got out of control. And there's nothing new about kids having high school parties. They did it when I was in high school. They still do it. What's new now is digital media. And they get on something called Snapchat, and instead of just telling a few friends, hey, we're going to have a little get-together, come on over to my mom's house, it goes on Snapchat, and kids pick it up all over the place and show up from everywhere, and it gets out of control real quick. So that's what happened, and this happened on January 19th of this year, which was the night before Martin Luther King Day. Martin Luther King Day was a school holiday, and this was a Sunday night. Okay, so the principal, Ms. Hill Brodigan, friends with Carly Anderson, called her up and said, hey, let's go out and have a drink. They live right down the street from each other. And Ms. Hill Brodigan picked her up, brought her out to a local establishment in Cocoa Beach, just a few miles away from their house on Minuteman Causeway. And they both live on Minuteman Causeway. And they proceeded to have adult beverages, and were in the process of thinking about ordering some wings and having a night out. At that moment, somebody from the Cocoa Beach Police Department called Miss Hill Brodigan and said, there's a party that's out of control at your house, and you need to come home right now and disperse it, extinguish it, fix it. So Miss Anderson gets informed of this and says, okay, I'll go with you. Big mistake on her part. That's where things start to go wrong for her. No good deed goes unpunished. So she drives, they drive back to the house. They may have made a stop someplace else. Within a few minutes, they're both back at the house. Miss Hill Brodigan goes right by Miss Anderson's house, doesn't give her an opportunity to get out of the car. And there's the remnants of an out-of-control party is going on. They proceed to work on telling the kids to go home. This house that this party is at backs up onto the golf course. So I'm imagining kids were running around on the golf course and making a nuisance to all the neighbors. So she was there for some time, and never provided any alcohol to any minors, never had a drink with any minors, never knew anything about this party until the police called and said, you need to come back here. So I'm thinking it's about an hour after they returned, and that's when you're going to see a body cam clip. It lasts about 3 minutes, so don't worry, it's not going to be like grueling long or anything. And it shows Corporal Brown, who found a young man in the front yard. I think he said, Bob.
I want to go ahead and get you back inside the courtroom here. The judge is now back in and getting ready to bring the jury back inside the courtroom as the Carly Anderson trial continues. So let's go ahead and listen in here to see if anything else needs to be taken care of before they bring the jury back in. It appears that they are going to have a conversation there at the bench, and so that is something that we cannot listen in on. The jury, again, still not in the courtroom. You see there those empty seats, they're notebooks where they are allowed to take notes. The judge giving them lengthy instructions earlier today about taking notes and how those they will be able to use when it comes to their deliberations, but also things that will be destroyed at the end of the trial, that no one will see them, and so their personal kind of notes there to monitor things, because there are, even in a fairly straightforward, a short trial like this, still a lot of things to keep in mind, to keep straight, dealing with legal issues and legal questions and those kinds of things. So certainly a good idea to be taking notes during it. I know I am taking a lot of notes as well as we continue to monitor things. So go ahead and get you back to the defense opening statement, where he's talking about the body camera video and some of what we were seeing, and we played a little bit of that for you. But want to go ahead and while we're still waiting on things to begin, go ahead and let him kind of finish out his argument of what he wants the jurors to kind of key in on.
And it shows Corporal Brown, who found a young man in the front yard. I think he said vomiting and shivering. Well, this was towards the end of January, and I think this kid didn't have a jacket on, and it was probably about high 50s or 60 degrees. So he was cold, and probably had too much to drink, and sitting in the grass in front of Hill Brodigan's residence. So
I apologize for jumping back and forth here, but they did wrap up their conversation. We want to listen in to see what the defense is saying here.
The most favorable light in the state still doesn't consist of a crime. That's count one. The state's witness testified, Andrew wrote that weapon that Mrs. Anderson did placed anybody in any danger. The video showed the defendant, or the juvenile, was in the backseat of the police car when she came out of the darkness with concerns, not trying to commit a crime. And basically she used words alone, which are protected by free speech. Corporal Brown said that he didn't really see her commit any crime, and that she had endangered the life of CR by having a 2-minute conversation with him, which is really just ridiculous. And I do have a case that stands for the proposition that words alone rarely rise to the level of instruction regarding resistance without violence. That is M.M. a child versus state, 51 South 3rd, 614.
Okay.
So the court should dismiss both of those counts at this point in time. And I'd be happy to provide those cases to you.
Yeah, so I was going to say, do you have a copy for the state and the court, or?
I don't know how this happened, but I only have one copy of the child case.
Okay.
The other ones I do have copies of.
All right. So provide the copies that you have, and then we can get the site for the other one. We can maybe access it. You may. That's the MM one you said. Just give me the site and I can. 51 South 3rd. The record is 51 South 3rd, 614, First DCA in 2011. All right.
I believe this is actually 3 copies of the same.
Oh. Yeah, I have Papalis also, and it appears that I have 3 copies of it too. So, all right. All right, and so the Papalis case is the one related to, all right, disorderly intoxication. All right. All right, anything further, Mr. Weaver? Okay. All right, state, I'll hear you in response.
Program identified the defendant, Ms. Anderson, and also testified that the offenses occurred in Brevard County. For count 1, the disorderly intoxication, program testified that Ms. Anderson was intoxicated, and that also was established with the video evidence that was submitted to the jury on the body camera recording. Regarding the second element, endangering the safety of another person, Corporal Brown testified that by being forced to interact with Ms. Anderson, she approached the EMT, she was yelling. He testified that it would not have been appropriate or plausible for him to get in his car and leave the scene without further investigating what was going on with that to ensure that there was not anything that was going to escalate further or that any crime was going to be committed, and not knowing what exactly was going on in the back of the ambulance. He had no choice but to walk back and engage with them. She was not there for any apparent reason. She was rather just interjecting herself into a situation that had frankly nothing to do with her. And Corporal Brown testified that because of this, the safety of the minor child who was in the back of the patrol car was in danger because he was left unsupervised. And at that point in time, the minor was under the care of Corporal Brown. There was no other parent or guardian around. So if anything had happened, he had suffered a medical episode, had seizure, regurgitated, vomited, choked on his vomit. The only person who was there supervising him was Corporal Brown. So by him being forced to divert his attention away from the child in order to engage with the defendant, Ms. Anderson, his safety was endangered. And I believe a good example of this is in the Apollos v. State of Florida case that defense counsel just provided. In this case, ultimately, the court talked about how someone being drunk in the middle of the road, waving their arms and behaving belligerently could have caused a public safety issue because a car could have hit her, or she could have caused the car to swerve off the road and cause a crash. And And even though those things did not happen, there was no crash, she was not hit by a car, the idea of endangering the safety is not that the unfortunate result actually occurred, but that it could have been, it was caused to potentially occur by the behavior. So this situation, although the minor child did not suffer a medical episode, her behavior was endangering his safety by the fact that there would have been no one around had that event actually occurred. And whether it rises to that level is a question that should be left to the jury. If there is sufficient testimony and evidence in the case to support a finding that those comments are present. Regarding the charges for resisting without violence, Carly Anderson did obstruct Corporal Brown by Corporal Brown's testimony. She hindered and delayed him from being able to transport the juvenile who was under his care. He was forced to interact with her and make sure that that whole situation was ameliorated before he could get back to doing what he was doing, which takes us to the second element, which would be engaged in the lawful execution of a legal duty. As Corporal Brown testified, he was in the execution of legal duty at the time that he encountered Ms. Anderson, was forced to deal with her, and that he was undertaking a community caretaker responsibility as a law enforcement officer for a minor who was sick and impaired and whose parent was not present. And at that time, Corporal Brown was an officer, and still is an officer with the Cocoa Beach Police Department. And at that time, Ms. Anderson knew the Corporal Beach Brown was an officer. She not only knew that from her previous encounters with him, and that they knew each other prior to this interaction, but also as Corporal Brown testified today, he was wearing his uniform, he was clearly on duty in his marked patrol vehicle at the time that the interaction with Ms. Anderson took place. So the state's position is that there is sufficient evidence to establish a preservation case of both disorderly intoxication and resisting an officer without violence. And as the state provided the case earlier this morning, I believe it is the CEL case, the Florida Supreme Court case. To support a conviction for obstruction without violence, the state must prove, one, that the officer was engaged in the lawful execution of a legal duty, and two, that the defendant's actions by his words, conduct, or combination thereof constitute obstruction or resistance of that lawful duty. So we take those words from the Florida Supreme Court, it can either be words, conduct, or a combination of both. It does not have to be both. It does not have to just be conduct. It can just be verbal for the obstruction element.
All right, does that conclude? All right. All right, so I am going to just take a brief few minutes just to look at both of these cases. I'm familiar with them, but I just want to read them before making the ruling. I will say a recess for about 10 minutes at most. Okay.
Another recess here, going to be for about 10 minutes expected from the judge as they argue a couple of motions there. And I missed the very beginning, so I'm not sure what the exact motion was, but we heard the defense attorney talking about how that there really was no evidence proven showing a crime. My assumption is that he was asking for kind of renewing that motion to dismiss this case, throw out those charges. But again, I did miss the very beginning of the discussion from the defense attorney as to what exactly that motion is. So trying to get some clarification on that, but we will find out very shortly when the judge makes her ruling as well on that motion. We're going to step aside for a couple of minutes here, take a quick break on Fox 35 News Plus. We'll be right back in just a minute.
watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us. So we are still standing by waiting for that ruling from the judge, who is taking a few minutes of a break to look over some of those case citations and that kind of thing. While we're waiting on that, I do want to play for you some of the questioning of the defense attorney of the police officer, Corporal Demetrius Brown, from the night. Well, this was from just moments ago as they discuss the night that this incident happened. Again, this is the defense with their cross-examination and some of the questions that he asked and the points he was trying to make. But the police officer standing by his opinion that the child would have been in danger and that Carly Anderson's actions interfered with him taking care of his legal duties to take care of that teen.
So your engagement with Mrs. Anderson is just what we saw here. It took about 2 minutes?
Yes, sir.
Okay. And did you feel that 2 minutes endangered the welfare of the child in the back of your car?
Yes.
You do?
Yes.
When you got back in the car, was he the same as he was when you left him there?
Yes.
Was the door open while you were talking to her?
No.
You'd shut the door?
Yes.
Okay. And how long did it take you to get to the police department?
Roughly 2 minutes.
2 or 3 minutes?
Yes, sir.
And how long did it take for his mother to get to the police department?
I believe about an hour.
Okay. And was the child endangered because of her length of time in getting there?
No.
Okay. And how was that?
Because I was sitting with him the entire time.
And what was he doing?
He was sitting in the back seat. He vomited again.
In your police car?
Yes.
Did you take him into the police department?
No. We sat in the car downstairs.
Did you talk to him?
I did.
Asking him questions about the party?
No.
What did you talk to him about?
I wouldn't be able to remember that.
Okay. So you felt that it was your legal duty to take this child to the police department?
Yes.
Could you have just knocked on the door of the Hill Brodigan residence and say, this guy doesn't need to go to the hospital, but somebody needs to watch him until his mother picks him up?
No.
Why is that?
Because I already spoke with his mom, and that was the preferred choice she wanted.
Did you give her any other choices?
No.
Okay. So that was really your choice?
Not really.
And how is it your legal duty to transport a child who's not under arrest in the back of your police car anywhere?
My legal duty to care for him, as there was not an adult who could legally care for him. He was 17.
Okay. How often do you put people in the back of your police car that are not under arrest?
Quite often.
Often?
Yes.
Okay. Adults and juveniles?
Yes.
Okay. And you know Mrs. Anderson very well, don't you?
I wouldn't. Yes. I'm familiar with her. Had conversation.
Okay. And you were the school resource officer for a while where she was teaching?
No, I just substituted
You were
for a
what?
little. I substituted. I just assisted for a few days.
Okay, so it wasn't your assignment, but you worked in that role sometimes?
Yes.
And did you have conversations with her?
Yes.
And did you view her as a upstanding citizen, a nice person?
Yes.
Okay. And in this particular occasion, you knew she was upset, right?
Yes.
Okay. And the conversation that you had with her that we just saw in the video was with your consent, wasn't it?
Yes?
And she didn't threaten you or tell you not to do anything, right?
Correct.
And at one point in time, you became loud.
Yes.
And was that because your emotions were widely swinging?
No.
Okay. You went from calm and quiet to suddenly full on yelling at her.
Yes.
And you told her to get out of your face.
That is
Viewing the evidence presented at trial in the light most favorable to the state for both the disorderly intoxication and resisting an officer without violence, along with all the reasonable inferences going to benefit the state. So viewing the evidence from that required standard, and admittedly it is a low bar, the court does find that the state's evidence is enough to go to the jury. All right, so we are at 12:15, and we'd like to go ahead and break for lunch. At some point, we need some time to do the charge conference. I don't know, would the parties be able to come back at 12:45, or would you like to hold it at 1 o'clock?
I guess till 1 o'clock, Judge.
Okay, all right, stay you, all right, 1 o'clock. Yes. And if I can have you approach, I would share something in the room. So. Yes, 1 o'clock. All right, so the court is going to be in recess and ask that the parties be back at 1 o'clock this afternoon.
You're watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. As you heard there from the judge, a charging conference set for 1 o'clock in this trial. So things will be headed to a jury shortly. Charging conference, closing statements, that kind of thing, as we watch this trial in Brevard County. But while we still have a few minutes left with you here, because they have broken for lunch in Brevard County, I want to get to some other news and a story. A really heartfelt story from Fox 35's Amy Caulfield, who had the chance to speak with Layla Bennett. She was shot in the head a year ago during a drive-by shooting in Sanford. She was just standing outside a home, talking with her friends. The friend's mom heard about a shooting nearby and told the kids to come inside. But that warning came too late, and a red SUV went speeding by. Layla's friend was grazed by a bullet, but Layla herself was shot in the back of the head. Bullet ended up going through the left side of her brain. Fox 35 anchor Amy Caulfield spoke to Layla to get an update on her recovery now, 1 year after that shooting.
It's been a year of change.
I didn't know, like, my smell and all those things would be changed too. Like, my eyes, everything.
Things that once came easy are suddenly hard, like reading.
What time will
you be home tomorrow?
Mm-hmm. Nice.
Writing with her left hand.
All right, word was pillow.
And walking.
Actually, I think that was the best I've seen you do that.
Layla is making huge strides because she's so determined.
When I was in the wheelchair, I hated it because I had to get help for anything.
The wheelchair didn't last long.
So I'm in my room and I'm like, I just want to see something real quick. And if I fall, I won't do it again. but I didn't.
Because Layla was shot on the left side of her brain, everything on the right is impacted.
It's amazing. She has been so resilient. She's been tough as nails.
Yesterday alone, 2 drive-bys injured 3 teens, including this girl who was just 3 days away from celebrating her 18th birthday.
1 year ago on a Monday evening, Layla was outside a Sanford home talking with friends. Her friend's mom heard about a shooting nearby and told the kids to come inside. Layla says the warning was too late. A red SUV came speeding by and gunshots rang out. Layla's friend was grazed by a bullet, but Layla had a gunshot to the back of the head. She was rushed to the hospital.
With neuro injuries like this, you see a good amount of improvement in 6 months, and then after that, you'll continue to see progress, but it's not as quick. It slows down.
Layla's mom, Nikki, says what happened to her daughter still hasn't sunk in.
I can cry every day at her bedside and be that person, or I can just say, all you need to do is stay strong. I've got this, we're gonna get through this.
Faith has been a guiding force in their journey.
Do you feel like God gave you a second chance?
Definitely, because before that I didn't really push him to the side. So I think he was like, I'm sorry I have to do this, but you have to trust me.
Another secret to Layla's progress, she's always positive.
If I get angry every day, it doesn't solve anything except just me just making myself miserable.
Layla's mom has been there every step of the way.
I love her so much. And one day I'll show her.
Layla will also show the world what she's capable of by walking the stage at graduation, 1 year behind schedule, as determined as ever, and always with that Layla sense of humor.
How do you think you're going to feel walking across that stage and getting that diploma?
I just hope I don't fall.
I love you.
And when asked what she wants the person who shot her to know, Layla wanted to address that person directly.
I forgive you, but I will get my justice.
Wow, a strong girl and a strong family, and glad to see that they are on that road to recovery. Obviously, a long process to recovery after something like that, but glad she's getting there. She's doing okay, and obviously a strong spirit. What a story from Fox 35's Amy Kaufeld. Well, again, we are getting ready to wrap up for a little bit here on Fox 35 News Plus. We'll keep our stream going on YouTube if you're watching that way. At 1 p.m. When that charging conference begins, you can still find it on that same video. If you're watching us on Fox Local, we will bring you more of that as well. You won't miss anything from that trial, the charging conference, as they kind of hash out the final jury instructions and things before closing statements and before this case is given to the jury. So a lot to watch for this afternoon, and we hope you join us here on Fox Local, fox35orlando.com, and also on YouTube. So we'll have that charging conference at 1 p.m. as the trial in Brevard County continues. We will also have, we'll see, because we will continue to stream that trial. When things go into verdict watch, we'll have some other news coverage for you during our 2 o'clock hour on Florida Live. But they're going to be a very fluid afternoon. We hope you join us here on Fox Local and on YouTube. So we're going to step aside for a little bit and kind of reset and get things ready for our next shows, and continue to monitor things in Brevard County. No feed up at the moment because it is a lunch break. So I'm just going to give you this, and I'll put it on some rotating cameras as well for those of you continuing to watch on the stream. Thanks for joining us. More to come this afternoon. Keep it here.
And I think I was probably the greatest thing that happened to him, but I can't take full credit. His party was losing by a lot, and he ended up winning. So I really want to congratulate him. It was probably one of the greatest comebacks in the history of politics, maybe even greater than mine. You know. But I want to just congratulate you. That was a great election, actually. We were watching it with interest, and I think Canada chose a very talented person, a very good person, because we spoke before the election quite a few times. And it's an honor to have you at the White House and the Oval Office. And you see the new and improved Oval Office as it becomes more and more beautiful with love. You know, we handle it with great love and 24-karat gold. That always helps too. Right? But it's been a lot of fun. We're going over some of the beautiful pictures that were stored in the vaults that were for many, many years, in some cases over 100 years. They were stored in vaults of the great presidents, or almost great presidents, all having a reason for being up, every one of them. So it's very interesting. But I just want to congratulate you, and ran a really great race. I watched the debate. I thought you were excellent, and I think we have a lot of things in common. We have some tough points to go over, and that'll be fine. We're going to also be discussing Ukraine, Russia, the war, because Mark wants it ended as quickly as I do. I think it has to end. We had some very good news last night. The Houthis have announced that they are not, or they've announced to us at least, that they don't want to fight anymore. They just don't want to fight. And we will honor that. And we will stop the bombings. And they have capitulated, but more importantly, we will take their word. They say they will not be blowing up ships anymore. And that's what the purpose of what we were doing. So that's just news. We just found out about that. So I think that's very, very positive. They were knocking out a lot of ships going, as you know, sailing beautifully down the various seas. It wasn't just the canal. It was a lot of other places. And I will accept their word, and we are going to stop the bombing of the Houthis. Effective immediately, and Marco, you'll let everybody know that, okay? Do you have something to say about that, by the way? It's a pretty big announcement.
Yeah, this was always a freedom of navigation mission. These guys, these are, a band of individuals with advanced weaponry that were threatening global shipping, and the job was to get that to stop. And if it's going to stop, then we can stop. And I think it's an important development.
And we'll have maybe before we're going to, as you know, the Middle East, Saudi Arabia. We're going to UAE and Qatar, and that'll be, I guess, Monday night. Some of you are coming with us. I think before then we're going to have a very, very big announcement to make, like as big as it gets, and I won't tell you on what, but it's going to, and it's very positive. I'd tell you if it was negative or positive. I can't keep that out. It is really, really positive. And that announcement will be made either Thursday or Friday or Monday before we leave. But it'll be one of the most important announcements that have been made in many years about a certain subject, very important subject. So you'll all be here. Mark, would you like to say a few words?
Well, thank you, Mr. President. I'm on the edge of my seat, actually, for the big announcement. But thank you for your hospitality and above all, for your leadership. You're a transformational president, focus on the economy with a relentless focus on the American worker. Securing your borders, ending the scourge of fentanyl and other opioids, and securing the world. And I've been elected with my colleagues here, with the help of my colleagues here. I'm going to spread the credit to transform Canada with a similar focus on the economy, securing our borders, again on fentanyl. Much greater focus on defense and security, securing the Arctic and developing the Arctic. And the history of Canada and the U.S. is we're stronger when we work together, and there's many opportunities to work together. And I look forward to, addressing some of those issues that we have, but also finding those areas of mutual cooperation so we can move forward.
That's great. Very nice. Thank you very much. It's a very nice statement.
Mr. President,
Anybody?
Is USMCA dead?
No, it was actually very effective, and it's still very effective, but people have to follow it. So, that's been a problem. People haven't followed it. but it was a transitional step a little bit, and as you know, it terminates fairly shortly. It gets renegotiated very shortly. But I thought it was a very positive step from NAFTA. NAFTA was the worst trade deal in the history of our country, probably in the history of the world. And this was a transitional deal, and we'll see what happens. You know, we're going to be starting to possibly renegotiate that if it's even necessary. I don't know that it's necessary anymore, but it served a very good purpose. And the biggest purpose it served is we got rid of NAFTA. NAFTA was a very unfair deal for the United States, a very, very terrible deal. It should have never been made. It was made many years ago, but it should have never been made.
Mr. President, considering Canada and the United States, would you like to see your first trade deal be with Canada? Our neighbors in the world?
I would love that. Look, I have a lot of respect for this man, and I watched him come up, in a sense, through the ranks when he wasn't given much of a chance, and he ran a really great campaign. He did a really great debate. I think that debate was very helpful. I was going to raise my hand. You know, I don't know if that's good or bad. I shouldn't say that. That might hurt you. But no, he ran a really great election, I thought. And yeah, something could happen. Something could happen. Yeah, please.
What's the top concession you want out of Canada? The top concession you want out of Canada?
Concession?
Yes.
Friendship.
But that's not a concession.
No, we're going to be friends with Canada. Regardless of anything, we're going to be friends with Canada. Canada is a very special place to me. I know so many people that live in Canada. My parents had relatives that lived in Canada, my mother in particular. And no, I love Canada. I have a lot of respect for the Canadians. Wayne Gretzky, I mean, how good, the great one. You happen to have a very, very good hockey player right here on the Capitals, who I have a lot of respect. He is a big, tough cookie, too. He just broke the record. And he's a great guy. And, you know, we had the team here, and I got to know a lot of the players. But now Canada is a very special place. Yeah, please.
Mr. President, and Mr. Prime Minister, I'd like to get your response to this too. But Mr. President, you have said that Canada should become the 51st state.
Yeah. No. Well, I still believe that, but you know, it takes two to tango, right? But no, I do. I mean, I believe it would be a massive tax cut for the Canadian citizens. You get free military, you get tremendous medical cares and other things. There would be a lot of advantages, but it would be a massive tax cut. And it's also a beautiful, you know, as a real estate developer, you know, I'm a real estate developer at heart. When you get rid of that artificially drawn line, somebody drew that line many years ago with like a ruler, just a straight line right across the top of the country. When you look at that beautiful formation when it's together, I'm a very artistic person, but when I looked at that beauty, I said, that's the way it was meant to be. But, you know, I do feel it's much better for Canada. But we're not going to be discussing that unless somebody wants to discuss it. I think that there are tremendous benefits to the Canadian citizens, tremendously lower taxes, free military, which honestly we give you essentially anyway, because we're protecting Canada if you ever had a problem. But I think it would really be a wonderful marriage, because it's two places that get along very well. They like each other a lot.
Well, if I may, as you know from real estate, there are some places that are never for sale.
That's true.
We're sitting in one right now, you know, Buckingham Palace that you visited as well.
That's true.
And having met with the owners of Canada over the course of the campaign last several months, it's not for sale, won't be for sale ever. But the opportunity is in the partnership and what we can build together. And we have done that in the past. And part of that, as the President just said, is with respect to our own security. And my government is committed for a step change in our investment in Canadian security and our partnership. And I'll say this as well, that the President has revitalized international security, revitalized NATO, and us playing our full weight in NATO, and that will be part of it.
And they have, I must say, Canada is stepping up the military participation, because Mark knew, you know, they were low, and now they're stepping it up, and that's a very important thing. But never say never. Never say never.
What would it take to get the tariffs off of Canada?
Well, we'll be talking about different things. Like, you know, we want to protect our automobile business, and so does Mark. But we want to make the automobiles, and we want to, you know, we have a tremendous abundance of energy, more than any country. We have, just in Alaska alone, Anwar has been reopened now. Anwar is probably the largest find anywhere in the world. They say it's larger than Saudi Arabia. I don't know, but it's a lot. But we have tremendous amounts of energy. Other countries don't. We're both lucky in that way. They have energy. We have energy. We have more than we can ever use and more than we could ever sell, actually. And you have the same thing. So we're two countries that are very lucky. If you look at China, they don't have that. You know, it's a big disadvantage. Other countries, most countries don't have. You know, most countries don't have that. So Canada and us, we have a lot of advantages over other places.
Mr. President, when you consider what Mr. Carney just said, that Canada is not for sale, does this make the discussion a little more difficult to start on?
No, not at all. No, not at all. No, time will tell. It's only time. But I say never. I've had many, many things that were not doable, and they ended up being doable, and only doable in a very friendly way. But if it's to everybody's benefit, you know, Canada loves us, and we love Canada. That's, I think, the number one thing that's important. But we'll see. I mean, over time, we'll see what happens. China.
I was hoping you could clarify something. Earlier this morning in Capitol Hill, Secretary Besson said that there hadn't been no negotiations yet with China. You have said something different.
They want to meet, and they're doing no business right now. And those ships are turning around in the Pacific Ocean. Big turn. Those are big ships. Those ships take about 10 miles to turn. And, you know, we lost $1 trillion to China on trade because of an incompetent president that we had who preceded me, grossly incompetent. You're finding it out more and more now. And by not trading, we're losing nothing. So we're saving $1 trillion. It's a lot. But they want to negotiate, and they want to have a meeting, and we'll be meeting with them at the right time.
But you haven't met with them yet.
I have not met with them, no, of course. You would know if I met. I'd tell you. They want to meet, but, you know, we are right now. Look, they're suffering greatly. Their economy is suffering greatly because they're not doing trade with the U.S. And they made most of their money off the U.S. Don't kid yourself. They don't make the money off other countries like this. And they were making. We had a trade imbalance. We had a deficit, or they had a surplus. Another way of saying it, of more than $1 trillion. Think of it, more than $1 trillion. And because of 145%, that's the only reason, but because of they have now 145% tariff, there's no trading. You can't trade with 145%. We are, therefore, making, in a certain way, I guess, $1.1 trillion. In other words, we're not losing $1.1 trillion. Our deficit is much better. When I started, I say we were losing billions of dollars a day on trade. That's rapidly turning around. We looked at numbers this morning. So we were losing, the United States during Biden was losing more than, I won't even give you numbers because they're so embarrassing, but billions of dollars a day on trade. Those numbers are rapidly turning between the tariffs. Don't forget, we're now getting 25% on cars, 25% on aluminum, 25% on steel, and maybe more importantly, massive numbers of companies are moving into the United States. Honda, we have tremendous, the car companies are moving in at levels we've never seen before. The biggest investment ever made in the United States is being made right now. Trillions of dollars. I would say we could be at $9 trillion. You could go back to other presidents. They haven't had $1 trillion for their entire term. Look at Biden. He had bad numbers. People were leaving. They weren't coming in. They were leaving with Biden, and he didn't know the difference. The only thing he knew is people coming in. You know who they were? Illegal immigrants, okay, from prisons, from mental institutions, from all sorts of places that weren't good, from gangs, from Venezuela. They were coming in, and they were criminals and murderers, 11,888 people that murdered, and at least half of them murdered more than one person. This is what Biden led into our country. I'm bringing in big companies. We have Apple is investing $500 billion. We have Jensen, as you know, is going to be 500 biggest chip maker, or chip thinker, I call him. He's really a thinker more than a maker. But we also have the maker, Mr. Wei. I get to know them all in the last, it was a cram course. But they're all moving into America because of the tariffs. And I don't think people have appreciated it. Some people do. Some of the smart people do. So we have more money coming in. It's really an amazing thing. We have more money being invested in the United States now than at any time ever before in our history, and it's not even close. And I think the real number could be 9 or 10 trillion. We don't know everybody that's doing it. We have many. I just heard about a plant that's being built right now, a very, very top-of-the-line company, and they didn't come to the White House. They're just doing it because they're making it, because if they build here, there are no tariffs. And this is the big market. This is the market. That sets us apart from it. This is the market where everyone wants to be. Now, if I didn't come here and do this, all of a sudden we wouldn't be the market where everyone wants to be. So we're able to do it in time. But we're going to have a great announcement. And I'm not necessarily saying it's on trade. Going to the beginning, we're going to have a great announcement over the next few days, an announcement that will be so incredible, so positive. And I'm not saying, I don't want you to think it's necessarily on trade. Just to finish, we also have a situation, because everyone says, when are you going to sign deals? We don't have to sign deals. We could sign 25 deals right now, Howard, if we wanted. We don't have to sign deals. They have to sign deals with us. They want a piece of our market. We don't want a piece of their market. We don't care about their market. They want a piece of our market. So we can just sit down, and I'll do this at some point over the next 2 weeks, and I'll sit with Howard and Scott and with our great vice president, who has done a really good job. We have some good news to report on a lot of fronts, but JD will be there, and Marco, and we're going to sit down, and we're going to put very fair numbers down, and we're going to say, here's what this country, what we want, and congratulations, we have a deal. And they'll either say, great, and they'll start shopping, or they'll say, not good, we're not going to do it. I said, that's okay, you don't have to shop. Now, we may think, well, they have a right, that maybe we were a little bit wrong, so we'll adjust it. And then you people will say, oh, it's so chaotic. No, we're flexible. But we'll sit down, and we'll, at some point, in some cases, we'll sign some deals. It's much less important than what I'm talking about. For the most part, we're just going to put down a number and say, this is what you're going to pay to shop. And it's going to be a very fair number. It'll be a low number. We're not looking to hurt countries. We want to help countries. We want to be friendly with countries. But you keep writing about deals. When are we going to sign? When? It's very simple. We're going to say, in some cases, we want you to open up your country. In some cases, we want you to drop your tariffs. I mean, India, as an example, is one of the highest tariffs in the world. We're not going to put up with that. And they've agreed already to drop it. They'll drop it to nothing. They've already agreed. They would have never done that for anybody else but me. So we're going to put down some numbers, and we're going to say our country is open for business. And they're going to come in, and they're going to pay for the privilege of being able to shop in the United States of America. It's very simple. It's very simple. So I wish they'd keep, stop asking, how many deals are you signing this week? Because one day we'll come and we'll give you 100 deals. And they don't have to sign. All they have to do is say, oh, we'll start sending our ships right now to pick up whatever we want or to bring whatever we want. It's very, very simple. And I think my people haven't made it clear. We will sign some deals, but much bigger than that is we're going to put down the price that people are going to have to pay to shop in the United States. Think of us as a super luxury store. A store that has the goods. You're going to come and you're going to pay a price, and we're going to give you a very good price. We're going to make very good deals. And in some cases, we'll adjust. But that's where it is. And we've been ripped off by everybody for 50 years. For 50 years. And we're just not going to do that anymore. We can't do that. And we can't let any country do that to us. We're just not going to do it anymore.
Can you tell us a bit more about the deal that you've reached with the Houthis?
No, it's not a deal. They've said, please don't bomb us anymore, and we're not going to attack your ships.
And where did you hear about that?
It doesn't matter where I hear it. The very good source, I could tell you. Very, very good source. Would you say, Marco? I would say pretty good, right, JD? A very good source. No, they don't want to be. They don't want to be. They don't want to be bombed anymore. You know, I sort of thought that would happen. No, no, behind you, please.
Clarifying something you said on USMCA. Is the U.S. prepared to walk away from that pact?
From what pact?
USMCA.
No. It's fine. It's there. It's good. We use it for certain things. It's there. We have the USMCA is a good deal for everybody. I won't say this about Mark, but I didn't like his predecessor. I didn't like a person that worked for. She was terrible, actually. She was a terrible person. And she really hurt that deal very badly because she tried to take advantage of the deal and she didn't get away with it. You know what I'm talking about. But so, you know, we had a bad relationship having to do with the fact that we disagreed with the way they viewed the deal. And we ended it. You know, we ended that relationship pretty much. The USMCA is great for all countries. It's good for all countries. We do have a negotiation coming up over the next year or so to adjust it or terminate it.
Mr. President.
I'll say a word on USMCA, if I may, Mr. President. It is a basis for a broader negotiation. Some things about it are going to have to change. And part of the way you've conducted these tariffs has taken advantage of existing aspects of USMCA. So it's going to have to change. There's other elements that are come, and that's part of what we're going to discuss.
Right.
During the campaign, Prime Minister Carney talked about the American betrayal. How do you react if Canada decided not to shop in the American store as much as before and decided to partner with other countries?
Well, we don't do much business with Canada from our standpoint. They do a lot of business with us. We're at like 4%. And usually those things don't last very long. You know, we have great things, great product. The kind of product we sell, nobody else can sell, including military. Look, we make the best military equipment in the world, and Canada buys our military equipment, which we appreciate. But we make the best military equipment in the world by far. The missiles, the submarines, everything. Everything we have is really top notch. I rebuilt our military during our last term. Stupidly, we gave some away to Afghanistan, which shouldn't have happened. But that was, I think it was the most embarrassing moment in the history of our country. It was just very incompetent people. But if you look, the man that's now the head of our Joint Chiefs, he led the attack on ISIS for me. That's why he's the head of the Joint Chiefs. And Raisin Kane, he was unbelievable. And as you know, we defeated ISIS in 3 weeks. It was supposed to take 5 years. We did it in 3 weeks. And he ran the campaign. I said, I like him. But I knew him before. I went to Iraq, and we agreed to a plan, and that was the plan. And as you know, we did it in record time. So we have the best equipment in the world. We have the best, a lot of things. And but Canada, it does a lot more business with us than we do with Canada. Yeah.
Mr. President, as your investments, Mr. President, when do you think the investments that you've announced, the trillions, will finally hit economic data this year?
When you're saying about the tariffs?
No, about the investments that you've announced.
Oh, it's hitting right now. Look, they're already starting AI plants. These are not people that look for financing. That's a good thing. You know, in real estate, you get a site, then you have to look for financing, you have to get your zoning, 5 years later you start building, you get a bank, then the bank's no good. And these people have massive amounts of cash. The CHIPS Act was a ridiculous thing because that doesn't get them to build. All we did is hand very wealthy companies money. The CHIPS Act that was done by Biden. Billions, we give them billions of dollars. They don't even have to do anything with it. And then if you weren't, if you didn't have, and I don't want to be a wise guy, but if you didn't go with the DEI, if you didn't go with all of the different things, woke, if you weren't woke, you couldn't even use the money. You had to have a certain percentage of this and that and that and that. It's impossible to have. The companies actually complained to me. They said they gave me all this money, but nobody can get these people to do anything. I mean, look, President Obama, and if he wanted help, I'd give him help because I'm a really good builder and I build on time, on budget. He's building his library in Chicago. It's a disaster. And he said something to the effect, I only want DEI, I only want woke. He wants woke people to build it. Well, he got woke people, and they have massive cost overruns. The job is stopped. I don't know, it's a disaster. And I don't like that happening because I think it's bad for the presidency that a thing like that should happen. He's got a library that's a disaster. And he wanted to be very politically correct, and he didn't use good, hard, tough, mean construction workers that I love, Marco. I love those construction workers. But he didn't want construction workers. He wanted people that never did it before, and he's got a disaster in his hands. Like millions of dollars, really many millions of dollars over budget. And I would love to help him with it, or somebody else. I could recommend professionals. But it was not built in a professional manner. By the way, nor was in California a little train going from San Francisco to Los Angeles that's being run by Gavin Newsom, the governor of California. Did you ever hear of Gavin Newsom? He has got, that train is the worst cost overrun I've ever seen. It's like totally out of control. So then they said, all right, we won't go into San Francisco. We'll stop 25 miles short. And we won't go into Los Angeles. We'll stop 25 miles short. It's hundreds of billions of dollars for this stupid project that should have never been built. And then they realized that it would have been a lot less costly if we just gave limousine service back and forth and gave it free. They would have saved hundreds of billions of dollars. They have airplanes that go there for 1/100th the cost, and they have cars. They have a thing called the highway that goes back and forth. It's not fully utilized. And they got involved with this project. And Gavin, I always liked Gavin. I had a good relationship with him. I just got him a lot of water. I sent in people to open up that water because he refused to do it. And we just got him a lot of water. If they would have had that water, and if they would have done what I said to do, they wouldn't have had the fires in Los Angeles. Those fires would have been put out very quickly. But if you think about it, and you got to take a look at this, it's the worst cost overrun I've ever seen. I've watched a lot of stupid people build a lot of stupid things, but that's the worst cost overrun I've ever seen, what's happening between San Francisco and Los Angeles. And you ought to ask about that because this government is not going to pay. I told our very great new Secretary of Transportation, he's doing a good job, Sean Duffy, I said, we're not going to pay for that thing. It's out of control. This is something that you don't have things like this. It's not even conceivable. Like 30 times over budget, 30 times. It's the craziest thing and now it's hundreds of, it was supposed to be a simple train. And I think the media should take a look at it. And I'd love him to run for president on the other side. I'd love to see that. But I don't think he's going to be running because that one project alone, well, that and the fires and a lot of other things, pretty much put him out of the race.
Mr. President, what changes would you like to see to the USMCA? Or what changes would you like to make?
We're going to work on some subtle changes, maybe. I don't even know if we're going to be dealing with the USMCA. We're dealing more with concepts right now. Look, right now, we're doing trade. We have trade. They're paying a tariff on cars and steel and aluminum. And I think we have a baseline of 10% or something like that for the tariffs. But we're getting along very well. Right now, going no further, but we have an agreement. We did something with even parts. You want to discuss that, Howard, with respect to Canada, which helps Canada out?
Sure. So we've made an arrangement with the car companies that 15% of their USMCA parts are included, and then 15% of foreign parts from the manufactured suggested retail price are not tariffed to help domestic manufacturing really thrive.
So it gave them a chance to be able to build their car parts factories if they're going to. A lot of these companies already have factories, and what they have to do is just fill them out. But they're able to build them in the United States, so we gave them a pretty substantial period of time.
Just to clarify, Mr. President, is there anything the Prime Minister can say to you today to change your mind on tariffing Canada?
Tariffing cars?
Tariffing Canada. Is there anything he could say to you in the course of your meetings with him today that would get you to lift tariffs on Canada?
No.
Why not?
Just the way it is.
What's
your
first state?
Yeah.
If Canadians don't want it, would you respect that?
Sure, I would. But this is not necessarily a one-day deal. This is over a period of time they have to make that decision. Yes, go ahead.
Yeah, if I may. Well, if respectfully, Canadians' view on this is not going to change on the 51st state. Secondly, we are the largest client of the United States in the totality of all the goods. So we are the largest client of the United States. We have a tremendous auto sector between the two of us, and the changes that made have been helpful. 50% of a car that comes from Canada is American. That's not like anywhere else in the world. And to your question about is there one thing? No, this is a bigger discussion. There are much bigger forces involved, and this will take some time and some discussions, and that's why we're here, to have those discussions, and that is represented by who's sitting around the table.
See, the conflict is, and this is very friendly. We're not. This is not going to be like we had another little blow up with somebody else. That was a much different. This is a very friendly conversation, but we want to make our own cars. We don't really want cars from Canada, and we put tariffs on cars from Canada, and at a certain point, it won't make economic sense for Canada to build those cars. And we don't want steel from Canada because we're making our own steel, and we're having massive steel plants being built right now as we speak. We really don't want Canadian steel, and we don't want Canadian aluminum and various other things because we want to be able to do it ourselves. And we, because of past thinking of people, we have a tremendous deficit with Canada. In other words, they have a surplus with us. And there's no reason for us to be subsidizing Canada. Canada's a place that will have to be able to take care of itself economically. I assume they can. I will tell you that Trudeau, when I spoke to him, I used to call him Governor Trudeau. I think that probably didn't help his election. But when I spoke to him, I said, so why are we taking your cars? Why are we taking we want to make them ourselves. I mean, I said, and if the price of your cars went up, or if we put a tariff on your cars of 25%, what would that mean to you? He said, that would mean the end of Canada. He actually said that to me. And I said, that's a strange answer, but I understand his answer. But no, I mean, it's hard to justify subsidizing Canada to the tune of maybe $200 billion a year. We protect Canada militarily, and we always will. We're going to, that's not a money thing. But we always will. But, it's not fair. But why are we subsidizing Canada $200 billion a year, or whatever the number might be? It's a very substantial number. And it's hard for the American taxpayer to say, gee whiz, we love doing that. Thank you very much. We're going to have a very substantive vote. Thank you. Thank you very much.
Why don't you now why did you Sir, NATO spending? You come out Canada's NATO spending. Cut it out, thanks guys. You should why don't you call him the governor? Why do you call him prime minister? Thanks guys. We're out. Are you going to the World Cup? Thank you. Are you going to go to the World Cup games? Thanks guys, keep going.
I'm just waiting for my pen. Thank you. Sorry.
not play dead. And if you have small dogs or small children, pick them up, make yourself look large. You know, even if a bear is touching you, you need to fight back. So if you're in Florida and you know you're having a conflict with a bear, fight back, because people have successfully been able to you know fight off bears. But again, and very important, you know, do not intentionally approach bears. Try to get closer pictures or you know sneak up on them. And certainly no feeding, right? Intentionally or unintentionally. But again, make yourself look large, and do not run or play dead.
You say that fatal bear attacks are very rare, but the population is growing, and humans are moving, sometimes even into, lesser populated areas. So are you seeing an increase in encounters? And how do you sort of manage that sort of conservation of the bear and the safety of the people?
Yeah, so we have actually seen a steady rise over the last 15 years of bear encounters, but we have sort of plateaued off around 6,000 calls a year. But the majority of those calls are I just seen a bear or a bear crossed the road in front of me. Our core conflicts are things like bears getting onto screen enclosures or getting in the trash. That seems to be stable across the state, and a lot of that is us doing education outreach, trying to teach people how to live in areas with bears, making sure any attractants around are secured so bears don't come out of the woods into the communities. This area here between the Big Cypress and Fakachi Strand, we have lots of bears in this area for sure.
Can you speak on the victims' injuries?
Yeah, so at this time, I don't think it's appropriate that we get into those details, obviously out of respect to the family and as the investigation ongoes, but that information will be available at the conclusion of the case.
We had a few neighbors call us and say that they noticed some bears getting bold in the area recently, kind of swatting pets under their cars and things like that. They said that they called into FWC to report it. Is this something that you were aware of, that maybe the bears were getting more bold recently?
So I believe we did some checking, and I don't think we had any calls from this specific area since I believe it was 2018. So, but we'll look into that. We do frequently get calls. Our bear management team across the state responds to those as they come in. We do have a wildlife alert hotline that residents can call to report that kind of activity, and our bear management team will look into that response.
I know, Director, you don't want to go into the nature of the victims' injuries. But I think yesterday it was still unclear if the man if you believed he had been killed inside the home, outside the home. Is that anything that you're able to discuss today?
Again, out of respect to the family, and I just know that the evidence that we found led us to believe that it was a bear attack. Which is why we had, the response that we have with all available assets and personnel and resources to come here and make sure that we could secure the scene and make sure the public's safe.
I think we ask about kind of the injuries of the individual, not to invade privacy, but kind of to understand if this individual had maybe passed out and then got attacked by the bear, or if the bear led to this person being killed. Can we kind of say confidently in either way?
So those are great questions. Obviously, we don't know the answer to those right now either, right? As the investigation goes on, as we get more information, as the results from the necropsy come in, we'll have a lot more information to be able to put together, because obviously right now we still don't have an eyewitness to that incident, and it would be really premature for us to speculate on exactly what and where it happened. All right, now Lieutenant Colonel Ascanio will provide those remarks in Spanish.
Ready? I'm going to go ahead and start in Spanish. Buenas tardes, Teniente Coronel Alfredo Escanio, ALFREDO-ESCANIO. El FWC, que es la Comisión de Pesca y Fauna, continúa investigando un ataque mortal de un oso en el condado de Collier. El incidente ocurrió la madrugada del lunes 5 de mayo en la zona de la carretera 29 y la carretera 41, justo al sur del Big Cypress. El ataque resultó en la muerte de Robert Markel, de 89 años, residente de Jerome, Florida, en el condado de Collier. La Comisión de Pesca y Fauna expresa sus más sinceras condolencias a la familia y amigos del señor Markel. La Comisión de Pesca y Fauna ha asegurado el perímetro de la propiedad y anoche se colocaron varias trampas y cámaras en toda la zona. 3 osos fueron abatidos por personal del FWC. Se han enviado muestras de ADN del lugar de los hechos y de los 3 osos a Gainesville para su análisis y estamos esperando los resultados. Como medida de precaución, le informamos a los residentes y visitantes de mantenerse alerta y evitar la zona. No se acerque ni intente arrastrar a los animales. El personal de FWC continúan monitoreando la actividad de los osos y garantizando la seguridad pública. Se dará a conocer más información a medida que avance la investigación. Muchas gracias. ¿Alguna pregunta?
El resto ya la complemento con la información que dieron. Muchas gracias.
Thank you, everyone.
Thank you.
Thank you.
¿Todo bien? Muchas gracias.
Hey, you guys all up? Yeah.
You did good? Yeah. I'm just thinking, did you guys have any other specific facts? Yeah.
Scario, sí, una cosa.
It's my personal information. That's how I distinguish. I have both of them, but they're identical. Exactly. Thank you for putting your first course. Thank you. Of course. Important stuff. Chinese money, you got Chinese money. Chinese money, take it out. Take it out.
Shame on you.
Chinese, your Chinese paymasters. Might say this first.
One, two, three, four, five. One, two, three, four, five.
Testing 1 2. Testing 1 2.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
All right, we are back on record in State of Florida versus Carly Dale Anderson. And
Welcome back here on Fox 35 News Plus. We appreciate you joining us and staying tuned here on Fox Local and on YouTube. Had some eventful things going on over the last little bit with a number of news conferences and meetings that we were keeping an eye on. Court getting ready to get back underway in Brevard County. Going to start with a charging conference where they go through some of the final jury instructions. So let's go ahead and listen back in.
all right. All right, and are we wanting to do, or are you prepared to do the charge conference at this time? Yes? Okay. All right, so I am in receipt of the instructions that were provided by the State Attorney's Office yesterday, and I'm also in receipt of 29.1 disorderly intoxication, and also 21.2 the resisting officer without violence, that proposed instructions that the defense has provided to the court. So, all right, so let's just start with the 2.7 closing argument. Of course, I would read that prior to closing argument. You're following along with me. Okay. All right, 3.1, introduction to final instructions. Nothing different about that. All right, and then 3.2, statement of the charges. Any objection to how that has been prepared? All right, and it is after I would read 3.2 that I would then read the disorderly intoxication, and after disorderly intoxication is count 1, count 2, resisting an officer without violence. All right, so at this time, the state has submitted a copy, and then of course I have a different copy from defense. This time we can go ahead and discuss this instruction. Are you still seeking to have special information provided in the instruction?
Yes, Your Honor.
Okay. All right. All right, and State, have you had an opportunity to look at the proposed instruction that the defense has provided?
Yes, Judge. The state would object to the special instructions. I do have case law to provide
Okay.
regarding when a defendant is entitled to special jury
Please provide that to the defense and the court. Thank you.
In this case, which is Boonship versus State of Florida, the court held that a defendant is entitled to a special jury instruction and the following three elements are satisfied. One being the special instruction was supported by the evidence. Two, the standard instruction did not cover the theory of defense. And three, the special instruction was a correct statement of the law and not misleading or confusing. For the disorderly intoxication proposed special instruction submitted by defense, the optional definition of a public place would not be relevant in this case since the state is proceeding under A1 and 2 rather than B1 and 2. So the elements are just that the defendant was intoxicated and endangered the safety of another person, not the anything to do with the public place. Additionally, the following paragraph about the defendant's admission that she drank an alcoholic beverage is not sufficient by itself to prove beyond a reasonable doubt that she was under the influence of an alcoholic beverage, but this admission may be taken into consideration along with other evidence. The standard is not whether she was under the influence of an alcoholic beverage, but rather that she was intoxicated. So I feel that that would be misleading and would also be unnecessary and confusing. And regarding the following paragraphs that talk about the First Amendment and verbal conduct, they would also be misleading for the charge, as the charge, again, is for the defendant being intoxicated and endangering the safety of another person. It has nothing to do with verbal words or verbal acts that would be protected by the First Amendment. The piece here is the behavior.
All right, so you're asking that really everything under the optional definition you've addressed, and you would want none of that to be included, correct? All right. All right, and your response, Mr. Weaver.
So I agree that subsection B shouldn't be included.
Okay.
Because the state didn't proceed on that theory. Or the rest of it is standard. I see the state's is different than mine, but and then this is a case where the conduct that Mrs. Anderson is accused of violating the law for is strictly verbal. So I think that some instruction on First Amendment is appropriate. It is part of the law in this case and in every case. And I asked Corporal Brown if she did anything other than just verbal acts, and he said no, nothing but verbal. So there should be some instruction from the court that there is such a thing as the First Amendment, and that people have the right to free speech. And this instruction that I provided is taken out of the case that I provided yesterday.
All right. right, and did you want to also argue the resisting language too?
If you give a First Amendment instruction, you don't have to do it twice as far as I'm concerned.
Okay, so you would not want it on that one. Okay.
It doesn't have to be attached to either one in particular, it just has to be an instruction from the court.
Okay.
It's my request and my opinion.
All right, so I have considered, I had a chance yesterday to look at what you have proposed, and I took some time to look at as much case law as I could look at for disorderly intoxication and resisting an officer without violence. I am going to deny the special instruction that you have proposed here. And let me start with the disorderly intoxication. That standard instruction was adopted back in 1981. I did note that it appeared that there was an amendment to it in November 20th of 2020. For sure, the bulk of all the case law I reviewed regarding free speech and these two crimes was before 2020. And I do feel like when it was amended in 2020, if they wanted that included, that it would have been included. And I do think that you've addressed it in your opening. I do believe it's fair for you to argue that during closing argument regarding free speech, but I don't think that the court should provide an instruction as you have asked for in this. And just let me say on the resisting, the same thing, I looked at that for free speech. I looked at the case law. The instruction was adopted also in 1981, and it's been amended 4 times, 1989, 1995, 2008, and then 2014. And, no information or no optional definitions or no instructions have been included regarding free speech for the resisting an officer without violence either. So I am going to deny the special instruction that you have provided.
Okay, I would like, if it's possible, for the court to make those instructions part of the record of this case.
Okay, I will absolutely do that, but I will say that I have written my own notes on them. I don't know if you have other copies that you could provide. You don't have to provide them right this moment, but you could provide them for the conclusion of the trial. I've got to put some notes and circled some things and just, made a lot of notations.
I do have one more set, Judge. Maybe I can give it to you after the closing argument.
Yes, if you can keep a note, and maybe Madam Clerk, if you can note that he wants to provide that as part of the record for appellate review. So, all right. So, based on that ruling, I want us to look at the ones that have been provided by the State Attorney's Office and make sure we all agree to the language. So starting with 29.1, disorderly intoxication. To prove the crime, the state must prove the following 2 elements beyond a reasonable doubt. 1, that Carly Gail Anderson was intoxicated, and 2, she endangered the safety of another person. You have crossed out property. So we take the brackets off of person. And then there is an intoxication definition that just read it to make sure that the pronouns are correct. All right, so I have read that. Any issue with that from either party? Okay. All right, moving to 29.2. Resisting an officer without violence. To prove that crime, the state must prove the following 4 elements beyond a reasonable doubt as to the alleged victim named below. So number 1 would be Carly Gail Anderson obstructed Corporal Demetrius Brown. We would take the brackets out of that. Number 2, at the time Corporal Brown was engaged in the lawful execution of a legal duty, with the brackets out of that. Number 3, at the time Corporal Brown was an officer. We're removing the brackets on that. And number 4, at the time Carly Gail Anderson knew Corporal Demetrius Brown was an officer. And then the last sentence is, the court now instructs you that Corporal Demetrius Brown is an officer within the meaning of the law. Any objection to any of that language? And state you're working on those? Yes. Okay. I realize I don't want to go too fast, but if you need me to slow down, let me know that.
Thank you.
All right. So the next one that I have in the packet is 3.4, when there are lesser included crimes or attempts. Is there any indication that you were intending to argue an attempt in the assisting? Okay. All right. Neither party? All right. So we will discard 3.4. All right, next I'm at 3.7, which is the plea of not guilty, reasonable doubt, and burden of proof instruction that I read during voir dire. The part that has been marked out is in the beginning of the third paragraph, the language starting with except for the defense. There has been no affirmative defense raised at this stage. So that language would go out unless that changes. Anything else that we need to do? All right. All right, the next one is 3.9, weighing the evidence. So in the weighing the evidence instruction, the list starting at number 1 through number 10, we need to make sure we all agree on those. So far, the state has kept in number 1 through 5. So let's take a look at the ones 6 through 10 that have been crossed out to make sure they should stay out. All right, and is the state seeking to keep any of 6 through 10 in the instruction?
No,
okay. And defense, are you seeking? You need to continue reading, that's fine.
I think number 8 is always important.
All right. All right. And state, what is your position regarding number 8? So you said you believe it's a good idea to keep it in, but you have something specific that you were thinking would aid the jury in keeping this instruction in?
Well, the out-of-court statements are on the body cam video. And Demetrius Brown, Corporal Brown, also makes statements on that video.
Right, okay. And state your response to that.
I don't believe that Corporal Brown made any statements during his testimony today that would be inconsistent with any of the statements that he made to Ms. Anderson during their interaction.
All right. And then defense? Do you have an intention to argue that in closing?
When he was yelling at her, he accused her of
Okay. And State, do you want to give a response to that?
Just briefly, I think that was cleared up during Corporal Brown's testimony that on the video, the statement that he had said was, you're hanging out at this party with your boss, with kids that are drinking, and that was said to her in response after she said, I've been here hanging out at this party, and I think he explained during his testimony today that when he said that to her, he was referring to her statement that she had said she'd been hanging out at the party, and he clarified during his testimony on cross that he was not insinuating that she was responsible for the party or had been the one conducting the party, merely that she was hanging out at the party because that is what she had told him.
All right. All right, I am going to allow the question. I do think that it's available to both parties during closing argument to discuss that if needed, the information that you just provided to the court. So if you would include number 8, which now would actually be number 6. It'll become number 6, please.
Yes, Judge.
All right, and Mr. Weaver, was that the only one out of the ones marked through that you were requesting to be included? Okay. All right, and then looking at the 2 paragraphs at the bottom of the page after the numbered information, is there anything that's objectionable in that? Regarding the number of witnesses, number of offered, and also law enforcement law enforcement being employed as a law enforcement officer. All right, and then on the second page of 3.9, there's a paragraph about expert witnesses crossed out, and the next 2 paragraphs also regarding testimony of a child. At this stage, the defendant has not become a witness, so that is marked out. If we mark all of that out, that from the very beginning of the top of page 2, the court would then start at, it is entirely proper for a lawyer to talk to a witness about what testimony and so on. And then I would read the final sentences. You may rely upon your own conclusion about the credibility of any witness. So you would want those 2 paragraphs included at the bottom.
Yes.
Okay. I mean, they'll fall to the beginning of it. All right, anything else that we need to address in 3.9, weighing the evidence from either party? No. Okay. All right, we're going to move to 3.9, subsection A, defendant not testifying. That's currently our state right now, okay? And you would want that included. And is it, have you had a chance to read it and confirm that it is appropriate for? All right. Yeah, I had an opportunity to read during lunch to make sure pronouns read appropriately. All right, next we're going to move to 3.9, subsection B, defendant statements. All right, any party has an issue with either party have an issue with it? All right, thank you. All right, next one that was included in the packet is 3.9E, eyewitness identification. Does not seem to apply in this trial, but both parties agree? All right, so we will remove that one. 3.10 is rules for deliberation, the standard instruction. And was there anything on that that you wanted to raise as an issue? All right, 3.11 is the cautionary instruction. A few sentences there. It seems appropriate. Anything that you raise for that? All right, 3.12 verdict. You may find the defendant guilty as charged or not guilty. We would take out the bracketed language because we don't have a lesser included. And then we would take out the next paragraph regarding the verdict should be for the highest offense on the verdict form. So I would say the first sentence that I said, then I would say the verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows, and I will be going over them. So the language that you have crossed out, of course, would be removed too. All right, so any objection as to how that one reads?
So just to clarify.
Sure.
It will be, you may find the defendant guilty as charged or not guilty, and then straight into the verdict must be unanimous?
Yes, yes. The state is not requesting that that paragraph be there at all. Okay, just making sure. All right. All right, so I do have two verdict forms. All right, and the first one that I would read to them would be, we, the jury, find as follows: as to Carly Gale Anderson for the charge of disorderly intoxication, check only one. All right, so we'd definitely read that as count one, and then the second one, we, the jury, find as follows: as to Carly Gale Anderson for the charge of resisting an officer without violence. I have confirmed we're in the county court, and we've got the right case number, the right defendant's name and spelling. Option A. Option A does say is guilty of both of the of disorderly intoxication and of resisting an officer. Option B does read the defendant, Carly Gale Anderson, is not guilty on both verdict forms. And then, so say we all, this day of month 2025 in Brevard County, Florida, there is a line for the foreperson to sign.
We did notice that the case number and on the forms I printed out as AXXXXX, the left two should be DC.
DC, yeah. You have changed them already?
I just did.
All right, thank you. Yeah. All right, so anything about the verdict form that you would like to address? Verdict forms.
I always think not guilty should be first, but
Okay.
I never win that argument.
So you want to raise that argument, you can.
It's okay.
Okay. All right, so moving to 3.12, subsection A, single defendant, multiple counts or informations. So a separate crime is charged in each count. The information, although they've been tried together, each crime and the evidence applicable to it must be considered separately in a separate verdict form, separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect the verdict as to the other crimes charged. Anything about that instruction? Okay. All right, now we're at 3.13, submitting case to the jury. Did you find anything in that one that you would like to raise?
It's the standard instruction, I think.
I think that I did want to, let's address this briefly. So we have one item in evidence, which is the body camera footage. It's very brief. We do have we have two options. We can send it back with them with the clerk of court computer. We have a laptop computer. Or if they want to view it again, we could bring them back into the courtroom. So, okay. And state, what is your position about that?
The state has no objection to them viewing it in the jury room if they're that's easier for everyone. If
Okay.
that gives them the ability to watch it, pause it, play it, talk about it together.
Defense, any objection to that?
I'd like to know what they're doing, so I'd ask for it to be done in the court.
Can you expound on that a little bit? Because during deliberations, we don't get to know what they do, what they say, what they consider. So, being that it's such a brief video, we're not sending them back a 30-minute video, sending, what you've said a few times is 2-minute video or 3-minute video. And the time it would take to bring them out, set it up, do all that, they may. So that is always a concern that we do have a laptop, and I will tell you that we can look at that laptop too. We want to look at it to make sure that it is clean and clear with nothing else on it that they can access, which I know the deputy clerks do check that, but we also could check that too. We could, it was a thumb drive, I guess, or flash drive. Thing on that too. Okay. All right. So, I guess part of the thing I could consider is I don't know their technical know-how or not either. So, I also could offer both options to them if you're in agreement with that. Okay. And like I said, if either the state defense, if you want to look at the laptop before we send it back, we can certainly do that. I have done that in the past myself. As the judge, I look at it, but you are welcome to look at it too.
Is this a computer that is kept for that purpose?
That is the only thing. It is locked up in that closet. It's only used for this purpose, to to be sent back with the jury. It's never used we never use it to present evidence, in other hearings or things like that. It's only for jury use. Is that correct, Madam Clerk? Yes. Yeah. So given that information, the parties would be fine with me telling the jury that they could watch it back there, and we would provide them the computer to do that. Or if they would prefer to watch it on the big screen out here, they could send a note to me to tell.
That's fine.
All right. So I just need to All right, and then the last instruction I have, of course, is 4.2, which is the instruction upon discharge of the jury once they have returned conclusion of the deliberations. Any objection to anything there? All right. All right, so can the parties please approach?
The judge and the attorney has been working through the jury instructions during this charge conference. Before the jury is brought back in the courtroom here in Brevard County, we should note that we heard the judge rule just a few moments ago that the jury will not get special instructions about the First Amendment and free speech rights when they go through this to talk about this. That was something that we know the defense attorney wanted, had argued for, had filed a motion for, and pushed again for today. during this charge conference as they discussed the jury instructions and how they would read. But again, the judge rather, denying that, saying they would not include that special instruction about free speech and the First Amendment. Been working through some of the other issues, and we're just talking about watching back the body camera video, how they would do that, whether they would be brought back in the courtroom or whether they would be able to watch it on a laptop back in the deliberation room. So we expect the jury to be brought back in shortly. Sounds like they were just kind of finishing ironing up some particulars here, but it seems like we're getting closer to bringing the jury back in for the remainder of this trial this afternoon that we have been following. Began this morning around 9:30 with opening statements, and sounds like shortly we should have some closing statements and send this case to the jury. We heard testimony this morning from 2 witnesses, one of them being an EMT who responded to the party that night, the other one the police officer who said on the stand today and testified that he believed that Carly Anderson's actions were obstructing his work and his duties as he was trying to take care of a 17-year-old kid who was sick from believed to have had too much alcohol at this party. And so that kind of the center of these charges: disorderly intoxication, resisting an officer without violence, both of them misdemeanors. Prosecutors had dropped yesterday a disorderly conduct charge, which was also a misdemeanor.
In the country to pass legislation.
All right, so Mr. Weaver, at this time, I am going to inquire with your client, Ms. Anderson, about her decision to testify or to not testify.
Yes, Your Honor.
And Ms. Anderson, at the beginning of court today, I did place you under oath to tell the truth to the court, and you are still under oath to tell the truth. You understand that?
Yes.
All right. All right, so at this time I'm going to also ask you a series of questions about your decision regarding whether to testify or not testify. So I want you to understand that the court is asking these questions. Please don't believe that the court has any preference in whether you testify or not. The decision is solely your decision. So number one, do you understand that you have an absolute constitutional right to testify during this trial?
I do.
Do you also understand that you have an absolute constitutional right not to testify in this trial?
I do.
Number three, do you understand that it is your decision and not the decision of your attorney?
I do.
Number four, do you understand that you may seek his advice regarding the decision to testify, but that ultimately it must be your decision?
I understand.
Okay. All right. And lastly, what is the decision that you have made regarding to testify or not testify?
I'm not going to testify.
Okay. All right. The court wants you to understand that this decision is final, and you cannot at and say that you wanted to testify.
I understand.
All right. All right. And let me ask this too. Does either party need a comfort break before we bring the jury in? You want a short comfort break at all?
Not the defense.
Okay, just making sure. All right.
getting ready to bring in the jury here, but big news from just a moment ago, Carly Anderson telling the judge she will not testify in her own defense. So we will not hear Carly Anderson. We will not see her take the stand to testify in this trial.
You may. Thank you. All right, and I'm going to actually have the parties approach one more time for something real brief, please.
So still a few moments here before the jury is going to be brought back in, another consultation between the attorneys and the judge here. But again, Carly Anderson is not going to testify. You heard the judge asking her a number of questions, making sure she understands it's her decision, that she does not have to testify, and that she realizes she cannot change her mind, that this is a final decision, that she won't say, yes, after all, I did want to testify, but I didn't have the chance to. Bailiff has gone out, and I believe going to get the jury, and this trial will resume here as we near the 2 o'clock hour on this Tuesday afternoon.
Jury may enter. All right, you may be seated. Everyone else may be seated. All right, members of the jury, I want to thank you for your patience in that break that we took that extended into our lunch hour, and I want to assure you that we got a lot of different business done during that time. Holding did anything happen on our the court? With all of you that
Looks like we are having some more issues with the pool feed here, kind of glitching and lagging. Has frozen up for the moment here. Unfortunately, we are reliant on this pool feed, have no control over that. It looks like it is back now. We know the jury is back inside the courtroom, and things are getting ready to begin.
will have equal time. Is entitled to divide time from opening argument and argument after closing argument. All right, State, you may proceed.
Good afternoon. To prove the crime of disorderly intoxication, the state must prove the following two elements beyond a reasonable doubt. Number one, that Carly Anderson was intoxicated. And two, that she endangered the safety of another person. The judge is going to, and following these closing arguments, provide you with some jury instructions, and this information will be provided in the jury instructions. And these instructions also include the definition of intoxication, which states that intoxication means more than merely being under the influence of an alcoholic beverage. Intoxication means that the defendant must have been so affected from the drinking of an alcoholic beverage as to have lost or been deprived of the normal control of either her body or her mental faculties, or both. Intoxication is synonymous with drunk. You heard testimony today from Corporal Demetrius Brown. He testified that when he approached the defendant after he heard her yelling at the EMTs, he observed her to be flushed, that she was slurring her words, and he immediately noticed the strong odor of an alcoholic beverage emitting from her person. You also saw for yourselves, watching the body camera footage, but you also have the opportunity to watch again when you were deliberating, that she clearly appeared intoxicated on the video. You also observed on the body camera footage that when Corporal Demetrius Brown told the defendant that she was drunk or intoxicated, he initially denied it and said, "No, I'm not." And then after he insisted again later in the conversation, "You're intoxicated," her response was, "Oh, so what?" Carly Anderson was not only intoxicated at the time of this interaction with Corporal Brown, but she knew that she was intoxicated. And that second element, she endangered the safety of another person. Her interaction with Corporal Brown, her yelling at the EMTs, causing a scene, being drunk and belligerent, endangered the safety of the minor child, PR, who was in the back of the patrol car at the time that all of this was going down. Whether this encounter lasted 30 seconds, a minute and 30 seconds, 2 minutes, 3 minutes, an hour, that doesn't really matter. Something bad could have happened in the matter of moments. This was not a drunk adult at a bar who'd had one too many beers and had experienced something like this before. This was a child. And at the time that the child was in the patrol car, the only person who was responsible for him and was there to supervise him was Corporal Brown. As Corporal Brown testified, he'd been vomiting throughout the night. He vomited continuously in Corporal Brown's patrol car. He was clearly extremely intoxicated and impaired. Corporal Brown testified that he had concerns. He was so concerned about his well-being that he contacted the fire department to come and check on him to make sure that it wasn't a true medical emergency, that they didn't need to transport him to the emergency room. And thankfully, they determined that he did not need emergency medical care. But that does not mean that he was not impaired to the extent that something worse could not have resulted from that. While he was in the back of the car, Corporal Brown testified that he was concerned that he could have had a seizure, regurgitated, vomited, choked on his vomit. He was not even able to stand up on his own. You saw in the video that Corporal Brown had to ask the EMTs for help just getting him from the side of the road to the car. So regardless of how brief the defendant's behavior was or how long that drew Corporal Brown's attention away from the child, anything could have happened in the time frame where Corporal Brown was forced to divert his attention from the child that was under his care to the defendant. Moving on to the second charge, which is resisting an officer without violence. To prove the crime of resisting an officer without violence, the state must prove all of the following 4 elements beyond a reasonable doubt. Number 1 is that Carly Gail Anderson obstructed Corporal Demetrius Brown. Obstructing being hindering, preventing, delaying. And at the time, Corporal Brown was engaged in the lawful execution of a legal duty. Number 3, Corporal Brown was an officer. And number 4, at the time, Carly Anderson knew that Corporal Brown was an officer. The judge is going to explain to you when she provides you with the jury instructions that Corporal Brown is an officer within the meaning of this law. So let's go through those a little bit. The first element, Carly Anderson obstructed Corporal Demetrius Brown. Corporal Brown testified today that in having to divert his attention away to deal with her, she absolutely obstructed him. She hindered his ability to focus on the task that should have been his primary focus at that time, which was caring for the sick, impaired juvenile that was in the back of his car. She delayed him from transporting the juvenile and from supervising the juvenile because, as he testified earlier today, he could not just walk away and throw his hands up and leave after he heard her and observed her yelling at and berating the EMTs that were on scene. He had a duty as a police officer to go and investigate that situation to make sure that what was going on, make sure that it didn't escalate any further, and address if there were any real problems that were going on back there that she was causing. The second element, at the time, Corporal Brown was engaged in the lawful execution of a legal duty. As Corporal Brown explained earlier in his testimony, part of his legal duty is to be a community caretaker. The role of a police officer is very broad. You know, when we see TV shows and movies, it's all just arresting the bad guys and going on pursuits and craziness. But the role of a police officer also includes taking care of members of the community when they are in need. And I don't know who, if anyone, could be more in need than that minor child that night. And thank goodness that Corporal Brown happened upon him when he did, because he clearly had no way to get home by himself. And thankfully, Corporal Brown was able to contact his mother to let her know what was going on so that she could then come and assist him. The third element, that Corporal Brown was an officer, that's undisputed. Corporal Brown is a police officer. And he was at the time that his interaction took place with Ms. Anderson. And the last element, that Carly Anderson knew that Corporal Brown was an officer. As we heard Officer Brown testify, Corporal Brown, I apologize. Not only was he in uniform that night, clearly on duty in his marked patrol vehicle, but Ms. Anderson knew from her previous experience with him that he is a police officer. So she's aware that he's an officer, and it was clear that he was an officer on duty that night when this incident occurred, because he's at the scene in his patrol car in uniform. Ms. Anderson isn't being charged for drinking with juveniles or having anything to do with conducting the party that took place. Those are not the charges that the state has filed against her or is pursuing. Corporal Brown testified that he didn't arrest her. Why? He couldn't. You could only have one person in the back of a police car at a time, and the minor child was already in the back of his police car. So he had no way of placing her under arrest at that time. His focus was not on her, it was on the child. His main goal was to end that encounter with her and get back to what his real focus was, which was getting the child back to the station so that he could supervise him and make sure he was okay until his mother was able to come and pick him up. You heard defense counsel ask Corporal Brown about why didn't he just give the minor child to knock on the door of 44 Country Club Road and give the child back to the house where the party occurred. I would argue that that would not have been an appropriate or reasonable thing to do, to return him to a house where clearly were hundreds of impaired juveniles. This is where the juvenile just came from. He's sick, he's a minor, where are his parents? And not only that, but it is clear based on the body camera footage that Miss Anderson was intoxicated. Were the other adults intoxicated? Who knows? But I don't believe, and I would argue to you, that Corporal Brown had any other option other than to take the child back to his mother rather than knock on the door of a nearby residence and say, hey, you take it. That would not be a very appropriate thing to do for a police officer. You'll have the opportunity when you're back in the deliberation room to watch the video. I recommend that you do that. Watch it as many times as you feel like you need to. And I feel like when you watch that video, it will become clear to you that Ms. Anderson was without a doubt intoxicated, endangered the safety of the minor child's CR, and obstructed Corporal Brown, hindered him, delayed him, prevented him from being able to maintain his focus on what it should have been on, which was the child all along. At this time, the state would ask you to return a verdict of guilty for both counts for the disorderly intoxication and for the resisting an officer without violence. Thank you.
All right, defense, you can now proceed. Closing argument.
Thank you, Your Honor. Afternoon, ladies and gentlemen. So now you know what the evidence is in the case. And it's really hard to believe that this is what a prosecution is based on. However, here we are. So, as to disorderly intoxication, remember, everything has to be decided to the standard beyond a reasonable doubt. Was Miss Anderson intoxicated? Maybe so. Because of her intoxication, did she endanger a drunk high school student in the back of the police car? Absolutely not. That's ridiculous. Absolutely ridiculous. Can't say that beyond a reasonable doubt. The state says the child could have vomited and inhaled it. The child could have had a medical emergency, could have done this, could have done that. That's not good enough for conviction in criminal court. As to resisting without, she walked up to somebody she knew and talked to him about what was going on. She didn't obstruct him. He didn't have to talk to her in any way. And he said that. He wasn't really engaged in any lawful duty. Taking a kid back to the police department isn't really what the police do. He could have taken him to jail. That might have been a lawful duty. And Mrs. Anderson didn't obstruct him from doing anything. She had a very brief, elevated conversation with him where she said over and over again, I'm concerned. I'm concerned about the child. And Corporal Brown could have asked CR, what are your plans for the night? Where are you planning on staying? Was he there visiting the high school student who was really hosting that party? Did he have another place to go? Obviously, his mother was in Orlando. He had something to do other than sleep on the yard that night. So we don't know what his plans were. And then Corporal Brown takes him to the police department, doesn't even take him inside, leaves him in the back of the police car for at least an hour, which is how long it takes for somebody to drive from Orlando to Cocoa Beach. So what happened in this case is it got a lot of publicity. Initially, it was believed that Miss Anderson had something to do with this party. But that wasn't true. So there was a lot of publicity, a lot of pressure on the state attorney's office to file something. Got to get her on something. And this is just made up stuff. To say that she endangered a kid who was already in the back of a police car when she walked up and had a conversation with somebody she knew is ridiculous. I would admit to you that this is not her finest moment. And she probably shouldn't have been interjecting herself in that situation. She shouldn't have been talking to the police officer that way. However, what she did is not a crime. Being convicted of a crime is a serious matter in our society, and it should not be taken lightly. And when you look at that video with no instructions, no background, you'll see somebody having a conversation, whatever you want to call it, with a police officer. That is not a crime under any circumstances, especially not under these circumstances. And she is protected by the First Amendment, which includes the right to freedom of speech. And as long as her free speech didn't cross the line and really become a crime, she shouldn't be convicted of anything. I asked the paramedic, Andrew Rock, did she endanger CR? He said no. He said that her CR's vital signs were great. And I asked him simply, did she endanger him? No. And he was right there. And I asked him, did you see her commit a crime? He said, no, sir. He did not. Well, Corporal Brown, part of the police department, part really of the prosecution team in this case, he was instructed somewhere along the line as to the theory of this case, and he had to come in and say, yeah, I did talk to her, but because I chose to talk to her, CR was in danger. And that's just not true. It's absolutely not true. And you certainly can't find that CR was endangered by that brief conversation by a reasonable doubt. Corporal Brown could have said, hi, Carly, leave me alone. I can't deal with you right now. I'm taking this kid to the police department to sit in the car with him for the next hour while his mom shows up. He didn't do that. He had a consensual encounter with her because that's what he wanted to do. And when he felt that when he was done with it, he burst into an outburst and started yelling at her, said, leave me alone, get out of my face, and she did that. She was given a direct order by a police officer, and she complied. Up until then, she wasn't given any orders. He was talking to her, and she was saying, I'm concerned. I'm concerned. She used that word several times. So, because this case got out of control, received all this media attention, the state attorney's office has felt the need to squeeze something out of it. And the only choice Mrs. Anderson had was to take it to you, take it to the people. And she's asking that you give her the benefit of every reasonable doubt. If you want to look at the video again, you can. It's just as bad as the first time you saw it. She's having bad behavior, but it's not a crime. I asked Corporal Brown, you saw her commit a crime? You could have arrested her right then, right? And he would have. Absolutely. He could get on his police radio, say, hey, drunk CR, hang on 1 minute. We got to wait for another cop car to get here, which might take 2 minutes. And then he would suggest to one of the other officers, go ahead and take CR, or take Carly. If he had observed a crime, either of these crimes, while he's working as a police officer, he would have made a move. He would have arrested her and maybe taken them both back to the police department with Carly in handcuffs. He didn't do that. He didn't see any crime. The paramedic, who obviously was a little bit nervous today, testified truthfully. I could say that I would bet that's the first time he's ever testified in court, because he looked a little nervous, and he absolutely told the truth. CR was not in danger and did not see Mrs. Anderson commit any crime. As to the community caregiver, that's also ridiculousness. Police officers was there to enforce the laws about noise violations and try to make this party go away. He was a nice enough guy to call the mother, who apparently doesn't have any fault in this case. Why is she letting CR come all the way over here and get himself so drunk that he gets to ride back to the police department in the back of a car? Nobody said anything about her. And anyhow, Corporal Brown could have had many options. He could have knocked on the door and said, is anybody here with CR? Who's supposed to be taking care of him tonight? Because he needs to be watched for a few minutes while he sobers up. So, when you look at the video, which you've already done, it should strike you immediately that that wasn't great behavior. It wasn't Mrs. Anderson's best moment. It wasn't very becoming, but it's not a crime either. And please don't make a mistake of making her a convicted criminal over this behavior when she had the absolute right to walk up to somebody she knows and say, what's going on? Even if she was a little bit intoxicated, she could have walked up and said, what's going on? I'm concerned. And Corporal Brown really had a duty to alleviate her fears too. She saw a kid being placed in the back of a police car, and I can tell you that 99% of the time somebody gets in the back of a police car, they are under arrest. They're not being driven around by Cocoa Beach PD Uber. They are going to the police department and then to jail. So that's what she saw. She said she's concerned, and she acted on her concern. She got into this whole thing by going out for drinks with her friend who was facing much more serious charges in another case. That's where the state attorney's office should be focused. If they're focused anywhere, they should be trying to squeeze some sort of conviction, something out of this behavior. This is free speech, constitutionally protected. No matter how you look at it, she didn't endanger anybody. So I'm asking you to consider these things, find Mrs. Anderson, who was a very nice lady, not guilty.
All right, State, if you have a rebuttal argument, you may proceed with that.
This case is not about First Amendment or protected speech or free speech. It's not even about what exactly Ms. Anderson was saying. It's about her behavior, the way that she drunkenly interjected herself into a situation that was none of her business, that she had no business being a part of, and that behavior is what caused all of these events to unfold. Defense counsel argued that, yes, the child could have had a seizure. The child could have vomited and choked on. The child could have this or that, but he didn't. And it's true, he did not. But that's not what endangered means. The state does not have to prove that she caused injury to this child or that some terrible medical episode did occur as a result of the behavior, but rather that he was endangered. What does that mean? He was placed in harm's way. There was a possibility of danger there that leaving him extremely impaired as a child in the back of a car, vomiting, with nobody else around, could have led to the possibility that something bad could have happened, that his safety was endangered. Defense counsel stated that Ms. Anderson walked up to someone she knew, just wanting to see what was going on. But that's not what the evidence that you heard today showed. She didn't walk up to Corporal Brown initially. She walked up to the EMT. She didn't know them. They had no idea who she was. She just appeared out of nowhere, wanting to know what was going on. They kindly told her that they could not tell her what was going on. They're not allowed to provide her with any information, and she needs to go away. It wasn't until, as you saw in the video, Corporal Brown then walks over and she immediately sees him. Corporal Brown, someone she knows. Then she starts interacting with Corporal Brown. Defense counsel stating that Corporal Brown didn't have to talk to her. We know that that's not true because we heard from Corporal Brown today that he has a duty to go back there and see what's going on. He can't just take off and leave. He does have to talk to her. Corporal Brown testified today that his intention wasn't to go back there and have a long conversation with her. His intention was to tell her, like, hey, you need to calm down. Like, it's okay. He was attempting to try to calm her and ameliorate her concerns, and he was not able to do that due to the intoxicated state that she was in. At the time that he initially encountered her, she is fuming mad, yelling, raging, complaining to him about how the EMTs are so rude and terrible and something needs to be done about them. They can't talk to her that way. And then the conversation escalates from there. He's trying to be reasonable with her. He's trying to calm her down, and she just won't have it. The conversation is going in circles. Why? Because she's intoxicated. She's not grasping anything he's saying. That's why she refers to the car as a machine. Why are you putting that child in that machine? That's an intoxicated person speaking. Nobody refers to a car as a machine. Defense counsel said that he didn't have to help the child. He could have taken the child to jail. Is that what we want law enforcement to do, is when they see an impaired, sick juvenile at a house party, is to just arrest them all immediately at the age of 17, start their criminal career out right then and there for a house party? I hope not. That would be pretty unfortunate. So I don't know what he would have arrested him for or taken him to jail for, but I'm certainly glad that Corporal Brown, rather than deciding to do that, decided to help him. Defense counsel also mentioned that rather than take him into the police station, when they get to the police station, he left him in the back of the police car. That's not what happened. As we heard from Corporal Brown earlier, he didn't just leave him there in the car by himself. He stayed with him, and that is where they decided to stay, likely because it was probably hard to try to move the juvenile again, as we saw how difficult it was the first time. And if the juvenile is still vomiting, and he's already vomited all over the police car, might as well just keep that the area that he's contained in until his mother's able to get there and retrieve him. This is not just made up stuff. We are not here for made up stuff. We're here because the defendant committed 2 crimes that night: disorderly intoxication and resisting an officer without violence by obstructing Corporal Brown. Defense counsel pointed out that if you just watched that video with no instructions and having no background on what you just saw, then maybe you wouldn't think that there was a crime there. But the background is important. Instructions are important. If we take just a short clip of somebody's life or one small incident, that's not going to explain all paint the rest of the picture of everything else that was happening that night. It's important to think about the background. It's important to think about the instructions that we provide for you here today, and the evidence that you hear, and the testimony, and the video. It all is part of the charges. That's why we're here, because this is important. Your role is important. Defense counsel pointed out that Andrew Rock, the EMT that you heard from earlier, he asked him on cross if he felt like Ms. Anderson had endangered the safety of the child. And Mr. Rock stated no. But Mr. Rock didn't see what happened after the fact. They left, the EMTs left, knowing that Corporal Brown was there dealing with the situation. So to ask Andrew Rock whether the juvenile's safety was endangered by the defendant going up and yelling at the EMTs, he's only talking based off of his knowledge, which is that she walked up and yelled at the EMTs, and then they got in the ambulance and said, let's get out of here, or this gets crazy, and they left. As far as blaming the child's mother, CR's mother, well, I don't know about you all, but my mother certainly didn't always know everything that I was doing in high school. So I think it's quite unfair to say that whether CR's mother knew where he was or what he was doing, I highly doubt it. Probably unlikely that she knew that her son was extremely impaired at a house party with a bunch of other high schoolers. But high schoolers will be high schoolers. So whether she knew where he was or not is completely irrelevant to the defendant's behavior that evening. Regarding whether Ms. Anderson was truly concerned, defense counsel stated that 99% of the time, I believe he said, when there's someone in the back of a cop car, it's because they're getting arrested. Well, you heard Corporal Brown, who is a police officer, tell you that they put people on the back of cop cars all the time that aren't under arrest to help them. That is part of their role. It's part of their duty to help people, not just to arrest them, to help them. The judge is going to explain to you when she gives you the instructions what reasonable doubt means. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable but one which waves and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. I would ask you to ask yourselves in deliberation whether any of the doubt here is reasonable. You should not have to force yourself to imagine some possibility of doubt that may be floating out there in space somewhere. It has to be a reasonable doubt. And the state has proved to you throughout the course of this trial, beyond any reasonable doubt, that Carly Anderson is guilty of disorderly intoxication and resisting an officer without violence.
All right, members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Carly Gail Anderson, the defendant in this case, has been accused of the crimes of disorderly intoxication and resisting an officer without violence. To prove the crime of disorderly intoxication, the state must prove the following two elements beyond a reasonable doubt. Number one, Carly Gail Anderson was intoxicated, and number two, she endangered the safety of another person. Intoxication means more than merely being under the influence of an alcoholic beverage. Intoxication means that the defendant must have been so affected from the drinking of an alcoholic beverage as to have lost or been deprived of the normal control of either her body or her mental faculties, or both. Intoxication is synonymous with drunk. To prove the crime of resisting an officer without violence, the state must prove the following 4 elements beyond a reasonable doubt as to the alleged victim named below. Number 1, Carly Gail Anderson obstructed Corporal Demetrius Brown. Number 2, at the time, Corporal Brown was engaged in the lawful execution of a legal duty. Number 3, at the time, Corporal Brown was an officer. Number 4, at the time, Carly Gail Anderson knew Corporal Demetrius Brown was an officer. And the court now instructs you that Corporal Demetrius Brown is an officer within the meaning of this law. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if you having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in the trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number 1, did the witness seem to have an opportunity to see and know the things about with which the witness testified? Number 2, did the witness seem to have an accurate memory? Number 3, was the witness honest and straightforward in answering the attorney's questions? Number 4, did the witness have some interest in how the case should be decided? Number 5, does the witness testimony agree with the other testimony and other evidence in the case? And number 6, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. A statement claimed to have been made by the defendant outside of the court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, number one, whether when the defendant made the statement, she had been threatened in order to get her to make it. And number two, whether anyone had promised her anything in order to get her to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number three, this case must not be decided for or against anyone because you feel sorry for anyone or you are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number five, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number seven, the jury is not to discuss any question that a juror wrote that has not been asked by the court and must not hold that against anyone. Number eight, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. and they are as follows. In the County Court of 18th Judicial Circuit in and for the Brevard County, Florida, case number 05-2025 MM 013006A, State of Florida, Plaintiff versus Carly Gail Anderson, Defendant. Verdict. We, the jury, find as follows as to Carly Gail Anderson for the charge of disorderly intoxication. Check only one. A, the defendant, Carly Gail Anderson, is guilty of disorderly intoxication. B, the defendant, Carly Gail Anderson, is not guilty. So say we all, this day of this month, 2025, in Brevard County, Florida, and it will be signed by the foreperson. Additionally, in the County Court of the 18th Judicial Circuit in and for Brevard County, Florida, case number 05-2025 MM 13006A, State of Florida, Plaintiff versus Carly Gail Anderson, Defendant. Verdict. We, the jury, find as follows as to Carly Gail Anderson for the charge of resisting an officer without violence. Check only one. A, the defendant, Carly Gail Anderson, is guilty of resisting an officer without violence. B, the defendant, Carly Gail Anderson, is not guilty. So say we all, this day of this month in Brevard County, Florida, and there is a signature for the foreperson. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict form returned as to each. A finding of guilt or not guilt as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring those verdict forms back into the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until that juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through any telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberation. These communication rules apply until I discharge you at the end of the case. If you become aware of a violation of any of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Now, many of you have cell phones, tablets, laptops, or other electronic devices here with you. The rules do not allow you to bring your phones or any type of these electronic devices into the jury room. Kindly leave those devices on your seats or with the court deputy who will guard those devices while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take a little time. You may continue your deliberations while you wait for the answer. I will answer any questions, if I can, in writing or verbally here in open court. During the trial, an item was received into evidence as an exhibit. You may examine whatever exhibit you think will help you in your deliberations. Now, We are going to give you two options because we have a thumb drive that is the exhibit. The first option is that we can send it back with you to the jury deliberation room with a laptop computer, and you would be able to view it that way, as long as someone has the technical capability of doing it. The second option is, of course, you can write a note requesting that you are brought back into the courtroom, and we would view the video up on the large screen there, and here in the courtroom with the parties and myself. All right, so the foreperson can write me a note when that is decided by the jury. If they need to view the video, would like to view the video, you can provide that to me. All right, in closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. All right, parties, if you would please approach.
The jury instructions have been delivered to the jury in the Carly Anderson trial. They will retire shortly to the deliberating room to begin deciding whether or not to find her guilty of disorderly intoxication and resisting an officer without violence. We heard closing arguments just in the last little bit, about a total of 20 minutes or so from the prosecution between their closing argument and their rebuttal. The defense spoke for about 13 minutes as well. So they made their final pitch to the jury, the defense saying that they found it hard to believe this is what a prosecution is based on, but here we are. They said it was bad behavior, but certainly not a crime. Meanwhile, the prosecution saying this is not about free speech. This is about her behavior. This is about what she did and acting belligerently and was drunk and endangered the safety of that child.
All right, at this time, ladies and gentlemen, I am going to excuse our alternate jurors. We actually selected 2 alternate jurors. And the first one is Chad Stewart, Jr., all right, and Chin Tran. Okay, so both of you, you can leave your notebooks. Like I said, we will destroy any notes that you have in that. No one will ever read them. You can go ahead and come forward. I just want to say to both of you, thank you very much for your time and your attention and your patience in this matter. Do you have items back in the jury room that you would need to retrieve? Do you have all of your items with you? Yeah, take that. So what you'll do from here is you'll go down to the jury assembly room to let them know that the trial's concluded and you have been released as an alternate. Again, I want to thank you very much for, I know both of you shared how very busy you are in your lives. It's very much appreciated that you were here for this process. So thank you. You look at them and check to see that I took off. I have to know. All right. All right. At this time, the jury may retire to the everything's there. All right. either party want to review the verdict forms before they go back? All right. All right. We're going to send back a legal pad with the jury for the notes. I am. All right, now confirm there's nothing on it. All right, so at this time, everyone may be seated back there. I want to say to the parties, thank you both, all of you, for your professionalism with this. When you have a trial that has a lot of publicity and a lot of media attention to it, I think everyone was incredibly professional, flexible, and patient to a lot of the different things that we had to do here. And I do want to ask you, Ms. Anderson, are you generally satisfied with the job of your attorney during this trial? All right, thank you for that. All right, so what we'll do is retire until we hear back from the jury. I'd ask everyone to stay pretty close. Anybody, it's 2:45, so anybody need to leave the courthouse, or will you all remain in the courthouse at this time? Are you planning to go to your office?
No, we'll stay.
You're going to stay? All right. And then, Mr. Weaver, you plan to be in the general area?
I'm staying here, Judge.
Thank you. All right.
I would like to make this instruction part of the record.
Okay, you may do that. The instructions for the charges that you wanted added, you'll provide those to. Just the disorderly intoxication one is the one that you wanted to add? Okay. All right. All right, so let's add this if we can. Yes. Part of the record. So. All right, anything else that we need to address before we conclude? No? Not from the defense. All right. All right, court will be in recess until we hear back from the jury.
Well, you heard it there. Court is in recess until the jury either has a question or a verdict. They retired to the deliberation room around 2:45. The first thing they'll have to do is to elect a foreperson and begin those deliberations. They are deliberating whether or not to convict Carly Anderson of disorderly intoxication and resisting an officer without violence. This is in connection with that large house party in Brevard County that involved a number of students, more than 100 students. You heard a lot of testimony today about the 17-year-old who was being taken care of by the officer, and prosecutors alleging that Carly Anderson's actions obstructed that officer from being able to take care of that 17-year-old who was sick and dealing with some illness because of what they say was drinking too much alcohol at that party. So we are standing by for that. We are now on verdict watch in that trial in Brevard County. We're going to take a quick break here on Florida Live. Still have a few more minutes with you before we wrap up this show and then continue our coverage here on Fox Local and YouTube. So we're going to step aside for a couple of minutes, and we'll be right back after this.
Earlier, we've requested data so we can
Welcome back into Florida Live. I'm Garrett Wymer, and thanks for joining us on this Tuesday afternoon live on Fox Local, fox13news.com, fox35orlando.com, and also on YouTube. If you are just joining us, we have been in coverage since shortly before 9:15 this morning, 9:30 this morning, of this Brevard County teacher on trial, charged with disorderly intoxication and resisting an officer without violence. This is a story we've been following closely from Brevard County, and we are now waiting for a verdict. But to get to some other news, because we do have a few more minutes with you here on Florida Live, we heard from Congressman Randy Fine this afternoon, speaking as part of a news conference on Capitol Hill about anti-Semitism, and specifically anti-Semitism on college campuses. So I want to play for you his remarks. Spoke for about 4 minutes, where he talked about advocating for the freezing of federal funding from colleges and universities that allow students to participate in pro-Palestine and anti-Israel protests on campus. Here is Congressman Randy Fine, newly elected Congressman Randy Fine from Florida's 6th District.
Well, thank you all for being here. You know, there's a lot of things where people could be spending this time this afternoon, but to be in a room like this, which is standing room only, is incredibly encouraging to me. My name is Randy Fine. I'm the newest congressman. I got elected 1 month ago, and I am many things in my life. I'm an American, I'm a father, I'm a proud Floridian. But among all of those things, there's one thing that I am most proud of, and that is that I'm a Jew. And as a Jew, I have personally experienced the scourge of anti-Semitism. I experienced it my entire life, particularly as I grew up. And I made a solemn vow when my oldest son, who's now 17, was born, that he would not have to go through what his father did. And it is a vow that I have failed to live up to. You see, anti-Semitism today is as bad as it ever was when I was a kid. In fact, some can argue that it is even worse. So when I got elected to the Florida legislature 8 years ago, I said I was going to solve that problem. And if you look at the anti-Semitism you see around the country, we don't have as much of it in Florida, because I was willing to fight that fight, often alone. So imagine my surprise. Imagine my joy and my gratitude and my appreciation that when I showed up here 4 weeks ago, for the first time, I had leaders that were as committed, if not more committed, to fight for this issue as I did. The two chairs that are right here, as well as our vice chair. Because the fact of the matter is, Jewish kids today are afraid. It's never been easy to be a kid going to college. Ask anyone. But no child should walk through campus today and wonder if they will make it from their dorm room to their classroom, or their classroom to the library, or the library to the dining hall, and they will be attacked. And that is not only happening, it is excused. And I would say encouraged at many of our institutions around the country. There are children that are scared to go to school, and in America, that is unacceptable. But for those of us that are Jewish, it is even more unacceptable, because core to our faith and who we are is a belief in the power of education to take us from where we were to where we want to be. So I will say this to every Jewish student that is here. I am here, and I will fight for you. And I will fight along these amazing leaders every day to make sure that we solve this problem. And I will do it for one simple reason. My son is going to be going to college in a year, and I'll be damned if he's going to be afraid to walk through that campus. Thank you all very, very much for being here. But it is now my privilege to talk about the horrors, to make it real, to talk about what actually does happen. This is not esoteric. This isn't something that you read on a page. Michael, who's going to speak, can show you the physical wound, the scar that he has, that he got not in a war on the other side of the world, a scar that he got on his college campus where his wrist was broken and he had to go to the hospital. Not because he was being attacked because they wanted to mug him or any other reason. He was attacked and he was hurt for one reason, because he was Jewish.
That was Congressman Randy Fine speaking on Capitol Hill at that news conference just a little bit ago while we were in our trial coverage. Well, we appreciate you joining us here on Florida Live. We are still on Verdict Watch, so if you are watching us on Fox Local Orlando, or if you're watching us on YouTube or fox35orlando.com, we are going to continue with our coverage here of this Brevard County teacher trial. We have some other news that we'll get into in the next hour as well, so you can keep it right here. If you are watching us on Fox Local Tampa or fox13news.com, you'll have your regular 3 o'clock programming coming up in just a couple of minutes. So we appreciate you joining us. We're going to go ahead and step aside, get ready to take our final break here on Florida Live, but we'll be right back. And we'll also be back tomorrow at 2 p.m. with what we anticipate to be a regular coverage here on Fox Local. Have a great afternoon.
You're watching Fox 35 News Plus, streaming on Fox Local.
Well, welcome back into Fox 35 News Plus. I'm Garrett Wymer. Thanks for joining us on this Tuesday afternoon, live on Fox Local, fox35orlando.com, and also on YouTube. We appreciate you joining us this afternoon. Been a long day of trial coverage when it comes to this Brevard County teacher that has been on trial. If you are joining us on YouTube right now, drop us a hello in the chat. Say hey, let us know where you're watching from. If you have any questions about what we've been covering this afternoon with this trial, or if you missed anything, have any questions about what has happened today, go ahead and ask those questions. We might be able to answer those for you. But yeah, also let us know where you're watching from. We'd appreciate it and would love to see that. We are still standing by. Let me give you a live look inside the courtroom right now, waiting on for a verdict or for a question from the jury. Still a lot to be decided. The jury retired to the deliberation room at 2:45, and so they have 2 charges to consider. And I want to start by kind of taking you through those here while let me see here. Yeah, let's go ahead and take you through those while deliberations are underway. You can start here. The first count is disorderly intoxication. And as you heard the judge describe, there are 2 elements to that charge. The first would be proving that Carly Anderson was intoxicated at the time of the incident. And that was basically all but admitted by the defense team in their arguments and questioning today. The second element of that charge is that Carly Anderson endangered the safety of another person, and that other person that the prosecution has tried to prove whose safety was endangered is that 17-year-old who Corporal Brown, the police officer, Cocoa Beach police officer, came across in the yard getting sick when he arrived at the scene there. Ended up taking that teenager, putting him in the back of the police car, and that is when, according to the evidence and testimony we heard, that Carly Anderson walked up and this confrontation happened that was seen on body camera video that we heard testimony from an EMT from that police officer as well. And the argument from the prosecution is that because of that, the safety of that 17-year-old was in danger because, as we heard the police officer testify earlier today, he could have gotten sick, he could have had seizures, he was heavily intoxicated. They were concerned for his safety, which was why he was in the back of the police car and the police officer was keeping an eye on him. So those are the two elements of the disorderly intoxication charge, in proving the intoxication, proving that the safety of another person was endangered. The second count is resisting an officer without violence. Now, the elements of this charge that the prosecution had to prove, first of all, would be that Carly Anderson obstructed Corporal Brown, who we heard testify earlier today. The defense going to great lengths this afternoon to say that this was nothing more than a verbal conversation, that it was a consensual conversation, that Corporal Brown did not have to engage in it, and that she was not actually obstructing the officer. The second element of that charge is that Corporal Brown was engaged in the, quote, lawful execution of a legal duty. This would have been caring for that 17-year-old, according to the prosecutors. We heard during questioning of the officer, of Corporal Brown, that he has a duty of being a community caretaker, that he had a legal responsibility at the time to take care of those who were impaired, including that 17-year-old who he was taking care of, and had told the mother of that teen that he would take him to the police department where the mother would be able to pick him up. The third element of that charge is that Corporal Brown was an officer, and that has been stipulated to. Corporal Brown is an officer. You heard the judge tell the jury that, so no difficulty proving that. That fact has been agreed upon by all the parties involved. And finally, that the status of the officer was known. So basically, Carly Anderson knew that Corporal Brown was a police officer, and that was basically all but admitted to as well, because we know that Anderson and Corporal Brown had worked together before, had spoken before, and that was something else that the defense tried to say, that this was just a one person walking up to someone she knew, trying to figure out what was going on. That there was a misunderstanding here, that she was wondering why that teenager was being put inside the back of a police car, and that she was concerned for him. As for that confrontation on body camera video, the defense admitted this was bad behavior, but it's not a crime. That's the point he was trying to make, and that what she did not endanger the, quote, drunk high schooler in the back of the police car. That's from the defense. The defense also saying that he found it hard to believe this is what a prosecution is based on, but here we are, he said. We will see who the jury sides with, whether it's the prosecution or whether it's defense. We've now walked you through all of those elements. We are still standing by for that. It's been about 20 minutes that they've been back in the deliberation room, and so we will keep a close eye on that in the next little bit. In the meantime, I want to play for you a news conference from Governor Ron DeSantis, who was in Miami this afternoon. In fact, spoke just a little bit ago, where he talked about his intentions to sign a bill, that the Florida Farm Bill that was passed by the state legislature, that would ban well, it would do a lot of things, but many of them agriculture related. One of the other things it would do is ban local communities from adding things to the water that don't purify it. So think fluoride. That's been a big topic of conversation, a big push by the Surgeon General here in Florida, Dr. Joseph Ladapo. He was at this news conference this afternoon as well. I want to play that for you as Governor Ron DeSantis spoke just a little bit ago in Miami.
If you look at the amount of surplus that we've carried, used to be pretty consistent. There'd be $5-6 billion in reserve. And then we've gotten that up to where we're like 20, 25 even. That we got it down from there because that was too much, and we've done some infrastructure, tax cuts, whatever. But we have really, really healthy reserves and running big surpluses. But then, at the same time, paying down an accelerated rate of our state's debt. So of 180 years, if you looked at all the debt that we've accumulated as a state, just since I've been governor, we've retired 41% of that. And when you do that early, and you got to be strategic, you don't always do it early because it depends, but if you can do it early, we've now saved each year hundreds of millions of dollars in interest costs that you would have had to bear as taxpayers. And so that's a great story. We're going to continue that. We now have the lowest per capita debt of any state in the United States. And we have the lowest number of state government workers per capita. So you talk about lean government, lean bureaucracy. We have that for sure. But with all of that, paying down debt, surplus, lean government, we've done really big things, and we've done big things for environment and natural research. You look at what we've done with Biscayne Bay, the Everglades. You look at what we've done for transportation. You know, we obviously have the junction here in South Florida that's going to end up being very helpful. This is tougher here to help with the traffic because there's not as many options to do. But we've accelerated billions of dollars. We have projects. We just unveiled in I-4. We got all this stuff around I-4. That honestly sometimes is even worse than South Florida traffic, believe it or not. Horrible traffic sometimes, and it can be at any time of the day. And so there's been a bunch of I-4 stuff done. We've opened stuff. It's been good, but there's more that needs to be done. There's also connecting roads and bypass roads, so we're doing all. But we said, well, while we're accelerating that, let's do some temporary expansion of lanes. And so we did that 8 months ahead of schedule. And I just put out a video of that on Friday. You look at before and after, massive increase in traffic flow. But, you know, that requires resources. And so we've done that. We've also done education. Number one, we've never done more per pupil for K-12 education than we've done in this recent year. Our colleges, our colleges and universities. Our universities, we have not raised tuition 1 penny for Florida residents. And so you've got about $6,300 on average to go to these universities, and that's part of the reason we're number one in higher education, because of affordability. So we've been able to do all of that. So that's really positive. We've got a lot of great momentum. We need to keep it going. But one of the reasons why we've been able to do all this stuff, one of the reasons our economy is number one, one of the reasons why we've added over 100,000 manufacturing jobs in Florida just since I've been governor, one of the reasons we have surplus, pay down debt, is because during COVID, we had to make a decision that people had a right to work in this state, businesses had a right to operate, and kids needed to be in school. And I know there was a lot of people down here that I had to fight with that. I remember when I said you can't fine people for masks. They were fining people for not wearing masks. And so I overrode that with an executive order and saved people a lot of money. So we did that, and the contrast between some of these states that were, you know, I mean, look, after 6 or 8 weeks, like, you had to start to think that maybe you need to go in a different direction. Certainly after 3 or 4 months and all this stuff, but nevertheless, people really persisted in this, and it was really intolerable. And then you had the BLM riots. You had a lot of things happening. And so we were able to attract a lot of folks, businesses, individuals, you name it. People would visit Florida. It was funny, I was talking to some folks in tourism about, like, well, how are things going now and whatever, because you hear different things about, you know, no international travelers, or that, you know, the media will try to say this or that. And I don't, you know, sometimes it's like, you can have an anecdote, but what's the truth? So I'll ask these people what's going on, and they're like, look, we're doing really well, but they're like, we will never be able to recreate 2020 to 2022, because it was just like Florida was the place where you would go, right? I mean, I was down in the Keys recently. I remember people flooding the Keys, flooding the Panhandle, you name it. You know, they had record years. But part of the reason, and that wasn't really the main reason we took the stand we did. Obviously, we wanted to do well economically, but we also, and even more importantly, wanted to respect people's ability to make the most of their own lives and make the appropriate decisions for themselves. And so, you know, if you wanted your kid to go to school remote in that initial school year, 2020-21, you know, we said fine, but you can't demand that all schools be closed just because you don't want. And guess what? Parents wanted their kids in school overwhelmingly. We don't think that walking down the street, government has a right to tell you you must muzzle yourself and cover your face with a piece of cloth. First of all, it's not going to do anything. But second of all, it's not the appropriate role of government to be doing that. I remember, and first of all, you've seen it in South Florida, we embrace things like restaurants. Fauci hated restaurants. He thought that was like the worst thing ever. And I'm just thinking to myself, like, what about all these people whose livelihoods depend on these things? And so what's happened, like a lot of the New York restaurants moved here to South Florida. You had a big boom in that in Florida because we were very supportive of them being able to earn a living, which is something that's really, really important. We also, so that contrast was huge. That led to Florida really taking out. We would not be #1 economy had we governed like New York or Illinois during those time periods. And so that was really, really important. Obviously in education too, it's important that the kids are in school, and that will have a ripple effect for many, many decades probably. The states, or some of these states, lock these kids out of school for a long time. Really, really harmful. So those were decisions, and you know, I was using it's interesting, like you'd have these governors around the country, they'd use executive orders to basically restrict. We were using executive orders to liberate, like saying local governments can't do this, local governments can't restrict, local governments can't do the mass fines or any of this stuff. And that was great, but those were kind of like emergency actions. And so we worked with the legislature, and when Wilton was Senate president, we enacted protections for people against these coercive policies. For example, no one should have to choose between a job they need and a shot that they don't want. And they were trying to fire people because of COVID jabs. We didn't allow that to happen. We also were, and I think if had Florida not taken this stand, that this may have caught fire all across the country. In early 21, people had this idea of COVID vaccine passports. So literally, if you wanted to go to a ball game or a movie theater or a restaurant, they wanted you to have to show proof of an mRNA COVID jab. And so what that does is it eliminates any informed consent, because your life is restricted based on a medical choice you made, which is really not anyone's business. But it was also even more ironic because these mRNA shots weren't preventing you from getting COVID in the first place. And it wasn't preventing you from spreading COVID. You know, it was sold as if you do the shot, you'll never get COVID and COVID will stop. But that wasn't what actually happened. So they wanted to do vaccine passports, which really would have limited the ability of a lot of our residents just to be able to make the most of their own lives. And so we were the first state in the country to pass legislation banning the use of COVID vaccine passports in our state. And not just with government, anything. It was just not an appropriate thing to do. So we viewed it as a civil rights issue. We viewed it as something that we wanted everyone to be able to participate in society. And so we got that on the books. We saved jobs as a result of the employment, not allowing employment mandates. First, they were looking at government agencies. We're like, well, obviously the state, we're not going to do it. Local fire departments, police departments, that's unacceptable. We're not going to let it. But even private businesses, this was run amok, and a lot of people would have lost their jobs. And so we saved thousands of jobs as a result of doing that. And we've also recognized bogus guidance coming from some of these exalted health authorities like the World Health Organization. You know, they want to do a lockdown treaty. We've already done legislation in Florida rejecting the WHO mandates in the state of Florida. So we really believe in informed consent. We really believe, we were also, I think, the first state to ban very dangerous gain-of-function research, which is, I mean, just think where we would be if Fauci had not run wild on gain-of-function research. I mean, it really changed the scope or the path of the country even. So, and people now have looked at that. And almost everything we did, you had the usual suspects saying, oh, this is terrible, they're not listening to experts. And now, no one would advocate for a vaccine passport. No one would advocate, well, some may, but not very persuasively, would advocate that you should lose your job over mRNA shots. No one is saying that somehow what the WHO is doing is good. Everyone has seen this now for what it is. And so, that brings us here today because we're going to be talking about two pieces of legislation that I will sign. The first is SB 700. Now, there's a lot more to that, and we'll probably talk about that. The Commissioner and I will do something in the near future to highlight some of the other provisions. But what this does with respect to putting fluoride in the water supply is it basically doesn't allow that anymore in the state of Florida. It's forced medication when they're jamming fluoride into your water supply. And they did it because, if you have fluoride, it'll help with dental. And I'm not saying that's not true, but we have other ways where people can get access to fluoride. When you do this in the water supply, you're taking away a choice of someone who may not want to have overexposure to fluoride. And there have been studies done, and Joe will talk about it when he comes up, that there are impacts to pregnant women, to children, about having too much of this. And you don't even have to agree with that analysis, but at the end of the day, we should all agree that we want people to be able to make informed consent, have informed consent when it comes to these things. Jamming fluoride in the water supply, irrespective of whatever for the teeth, when you can get that other ways, that's impinging on other people's ability, to have access to water in ways that they may not want to be exposed to what is essentially a forced medication. So the legislature was able to pass that, and we will be able to sign that. Joe Ladapo issued guidance, I guess like last year, right, late last year, about community water fluoridation due to the potential risks that were associated with exposure. And again, pregnant women and children were at most risk. That this fluoride is a naturally occurring mineral present in groundwater, fresh and saltwater, rainwater, soil, plants, and foods. But the community fluoridation adjusts the amount of fluoride in drinking water to levels that are recommended high enough so that it could deal with the tooth decay. But of course, you can get fluoride in toothpaste other ways outside of that. So what you've seen is these studies have been coming out. People are now looking more critically at this. And honestly, I think because we saw how out of whack some of these medical elites were during COVID, I think people are just much more skeptical when these elites are trying to jam anything down our throats. And so there's a lot of people that look at this and they say, okay, well, show me the evidence. The burden is on you to prove why this is a net benefit, which I think Joe would argue it's probably not in terms of health. But the highest burden is why should this be forced on people? And it really shouldn't be forced on people. So you're seeing more and more places. You have countries where a lot of the municipalities in Europe have moved away from the forced fluoridation. Many municipalities in the United States, and a lot in Florida. I mean, we've had a number of counties that acted after Joe's guidance, but also other stuff that was happening there. So this is, I think, the things that a lot of people want to see done. They want to see protections against this. They understand there's other ways that you can get fluoride if that's something that you need. And so there have been studies that have raised concerns about physical and mental health risks that have been associated with overexposure to fluoride. Now, if you're brushing your teeth a couple times a day, that's not going to likely present the same type. But, if you're drinking a lot of water, exposed to that in the home, or that's a different story potentially. And so people just should have that information, and then they should make the appropriate adjustments. And there's nothing preventing you and your house from adding fluoride to your water. If that's what you think is good for you and your family, then you still, of course, have the ability to do that. So we don't want local governments unilaterally injecting the chemical into the water supply. and exposing people to potentially harmful side effects. I know the Miami-Dade Board of Commissioners has voted, and I think they voted the right way. And so thank you. Of course, for the counties that voted the other way, we're the legislation that we'll sign is gonna answer that question anyways. But I do think that you guys led on this, and I appreciate your leadership for that. The other bill that I'll be signing is Senate Bill 56. So this was done by Senator Ileana Garcia, and it protects Floridians from geoengineering and weather modification activities. Now, people have been coming up to me. We don't do that in any of our state agencies. There's never been any permit issued from the entire modern history of Florida. We're not engaged in any of that, but people have concerns about, because you have all these people that are saying, well, the way to fight climate change is to inject this stuff and block the sun and do all that. And I'm just like, no, okay? No, we're not doing that in Florida. We're the Sunshine State. You know, we don't need any of this now. So it wasn't being done by the state of Florida, I can tell you that. But this is something that you hear out there. That it's kind of like a little cottage industry where people think that they can, solve global warming by just putting stuff into the atmosphere. So Ileana's bill really slams the door on that. Any of those efforts are dead on arrival in the state of Florida, so you don't have to worry about that going forward. And I know there was, some back and forth on this bill. I know there was an attempt by the House leadership to water it down. We were concerned about what may end up happening, but I can say that this strong bill ended up passing and prevailing. So that's good. Good on Ileana for doing that and making sure that we continue to do what's right by the people of Florida. So I'm happy to be supportive of these two measures. I know that there's a lot of folks that wanted to see this done, and so here we are getting it done as usual. And with that, I'll turn it over to our Commissioner of Agriculture, Wilton Simpson.
Thank you, Governor. Florida has passed now the 2025 Farm Bill. After 7 years, it sure would be nice if the federal government would follow our lead here. I would think so. This bill is great news for agriculture, and it's great news for all Floridians. Agriculture is a national security issue. We know that to keep the free state of Florida free, we need to support agriculture. I look forward to joining you in the near future to talk about all of the great things we have done in this comprehensive bill, but today is about medical freedom. Governor, I was proud to be part of your courageous work during COVID, banning vaccine mandates, banning vaccine passports, and being co-chair of the task force to reopen the state of Florida when everyone else was shutting down their states. You have continued to fight that fight, and so have I. This Farm Bill includes many protections for our consumers. Today we announce that drinking water will hydrate, not medicate. You should not be medicated without your consent. It's plain and simple. This is one more way that we block trampling of personal liberties. There's a fundamental principle here: informed consent. If you have the right to decide what medication you take, you have the right to decide what medication your children take. That should not be a controversial idea in a free society. This provision is more than just water. It's about restoring trust in public institutions. It's about drawing a bright line between public health and personal freedom. And it's about pushing back against creeping philosophy that the government always knows best. It doesn't. We've seen too many examples in recent years where trust the experts turned into sit down, shut up, and obey. Not in Florida, not on our watch. With this legislation, we're saying loud and clear, Florida water will be clean, it will be safe, and it will be medication-free. That's how it should be, and that's how it's going to stay in Florida. From protecting parental rights to fighting back against federal overreach, Governor, thank you for your leadership. I would also like to thank President Albritton, Speaker Perez, Senator Truenow, Representatives Tuck, Alvarez, and McClure, and our partners in the Florida legislature for advancing this bill and standing up for common sense. This is what conservative leadership looks like: protecting agriculture, defending liberty, and putting the people of Florida first. Thank you, Governor, and God bless Florida.
Hello, everyone. I've been down in Miami. I was just thinking as I was sitting there listening to the commissioner, I'm like, I've been to Miami a lot lately. I've had a lot of trips down here. I love Miami. Don't love Miami traffic, and I gotta say I do like the Pinellas County, Tampa Bay area more, but it is beautiful here. It's a very special place here. And a lot of And you know, Miami's obviously a very, very special place. Some people say it's actually part of Florida. I know that there's some discussion about that, but it is a very, very special place. And I also have a lot of friends in the audience today, so that's always a pleasure. A lot of friends in the audience, so that's great. And you know, where do we start? We start with our governor, who made like all of this possible, right? Leadership by example, right? Leadership by example, leadership, you know, that is bold in the name of truth and in the name of your convictions and what you believe is right, and that creates space for other people to do the same. You know, it created a space for me to come here when the governor invited me to be the Surgeon General. It's created space for me to do what I think is right scientifically and based on conscience and ethical values. And it's created space for other people to also to live up to what they believe is the right thing to do. So it starts with that man right there. And I want to thank Commissioner Wilton Simpson for this agriculture bill that, you know, that makes it possible for the children, the families of Florida not to have to worry about fluoridation in their water. This fluoridation is like, you know, I think of Charlie Brown, and I love that. I don't know, I can't remember his name, but the little guy who holds his blanket, right? And I love it, you know, hold your blanket. But unfortunately, you know, he's a kid. But what we have instead, we have professionals. They're doctors, dentists, public health leaders who are holding on to fluoridation like that blanket. I mean, it doesn't matter what the evidence shows, right? Whatever the studies show about potential harms in children and pregnant women, and who knows about the rest of us, they're just holding on to it. And it's okay when you're a kid, but we're grown-ups here. We're adults. We're responsible for, you know, for the lives of other people, and we need to make good decisions. So you just, you know, it's really cute when you're a kid, but you can't hold on to that blanket as a grown-up, okay? I mean, it's just, I don't know, you know, you're Sue Alcalde, right? You're Mayor Sue Alcalde. I listen to the statements, and I understand she's not a scientist, and God bless everyone. I honestly, I don't really so much have a problem with people, whatever position they take on an issue, but I really want to see that you're making an honest decision, and I mean that's what's important to me. And it's just like, literally, guys, with this fluoride issue, you have multiple research groups in different states and different countries finding the same things. Right? Are they all just making it up? I mean, can you actually, in a sane mind, ignore all of that evidence? You can't. You gotta let go of the blanket. It's okay. You know, it's all right to revise your position. It's all right to do something that goes against what, you know, whatever, you know, Dr. Fauci, we're talking about him. You know how he feels about fluoridation. But it's okay to reverse your position when there's evidence. I mean, that's the right thing to do. You're in a position of leadership. You're there to serve people, and like, you got to serve them. You know, and that means doing whatever's needed to serve them. And, Senator Garcia, we've been exchanging communications about this weather modification issue. This was an issue that I have learned so much more about, and honestly, I am gobsmacked. I mean, there's quite a lot more to this, and we're still in the Department of Health. We're actually engaged in some work right now to study this scientifically in partnership with the Department of Environmental Protection. And we're engaged in that work, frankly, because I'm incredibly grateful for her leadership in this legislation, but I don't know if it's going to be enough to stop these activities. I don't know if it's going to be enough to stop these activities because of the experience in Tennessee when they've done something similar, although our legislation is more far-reaching, and because of the etiology of the activities, which I've learned more about. I mean, it's one of the pieces that it's kind of stunning. I mean, first of all, as the governor said, are you kidding me, right? So your plan to save us all is to release stuff like aluminum oxide and other things into the sky so that it reflects the sun back out. Like, that's your plan, and you think it will come down at some point, and we will breathe it in, right? And that's your plan to save humanity. It's completely. I mean, it's not only off kilter, but it's really. I mean, it's nuts that people think that they have a right to affect the air that you drink without your permission. I mean, the fluoride's bad enough in terms of people doing stuff without your permission, your acknowledgement, your affirmative participation. But are you kidding me? You know what I mean? The air that we breathe, right? That you have a right to do whatever you think is best for the air in terms of putting something into it. So it's an issue. It's an issue. And I actually want to. So one of our partners in our trips down to Miami and other parts of the city, other parts of the state, pardon me. And I want to say also, I mean, this is a shout out to all of the cities and the counties that have taken wrestled with this issue. Even if they voted the wrong way on it, I'm really appreciative of our communities, our community leaders who made this an issue that they were willing to step up and wrestle with and make a decision on instead of hiding about and not making a decision on. So that's for all of them. And in these visits, we've actually been invited often to different counties and cities. And I certainly I'm a physician. I take care of patients. I have a PhD, a doctoral degree in research science. So I'm very comfortable and familiar with science. But it helps to have an expert in an area. And I actually just want to call Dr. Mallon up. She's a University of Florida professor. She's made the trip with us to many, many parts of Florida to present some of the science. So, Dr. Mallon, would you share some words, please?
Yes. Thank you so much to Governor DeSantis and Dr. Latipo for having me here today. I'm an epidemiologist and an assistant professor at the University of Florida, as well as a clinical psychologist. And I have been conducting research on fluoride in human health for about 12 years now. I first want to say it's really been an incredible journey from speaking with Dr. Latipo at the press conference last November when he issued guidance on community fluoridation, to traveling around Florida and presenting research on health effects of fluoride exposure over the last several months. And one of the most rewarding parts of this experience has been meeting and hearing from Floridians in local communities across the state whose voices are now finally being heard on this issue. But we also saw situations like in Bartow, Florida, where, for example, where many people pleaded with their elected officials to stop adding fluoridation chemicals to their drinking water, and that didn't happen. Now with this bill, their requests will be answered. There have been major milestones in the research on fluoride and neurodevelopment over the last decade, and especially in the last year. And with more and more studies finding associations of fluoride exposure with adverse neurological outcomes, even at levels that we commonly encounter in Florida. The findings of these studies point to an imminent need for policy change, and the policy change happening in Miami-Dade today with the ultimate signing of this bill is one that will protect the brains of children in Florida from unreasonable risk of harm for generations to come.
That was Governor Ron DeSantis, some other state officials speaking in Miami just a little bit ago, talking about the Florida Farm Bill and really highlighting the ban on fluoride, adding to the fluoride additives to water supplies across the state of Florida. We're going to take a break here on Fox 35 News Plus, but when we come back, I want to take you to a news conference in Fort Walton Beach this afternoon where civil rights attorney Ben Crump announced a lawsuit filed in the death of U.S. Airman Roger Fortson. This is a story that's gotten a lot of attention since it happened in May of last year. And so we'll have you the latest updates and take you inside that news conference coming up in just a couple of minutes. So keep it here on Fox Local and on YouTube. Going to take a quick break, but we'll be right back.
You're watching Fox 35 News Plus, streaming on Fox Local.
Welcome back in here on Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us on this Tuesday afternoon live on Fox Local and on YouTube. Attorney Ben Crump, who is a nationally known civil rights attorney, personal injury lawyer as well, held a news conference in Fort Walton Beach this afternoon. It was at Greater Peach Missionary Baptist Church, announcing that he's filing a lawsuit in the death of U.S. Airman Roger Fortson, who's 23 years old, when he was shot and killed inside his apartment by an Okaloosa County deputy in May of 2024. So it's been about a year since this happened. Now, according to the lawsuit, they claim the deputy used, quote, excessive and unconstitutional deadly force, and they say that was done within seconds of the door opening, despite Airman Fortson posing no threat. They also make allegations of failures by the sheriff's office in training, supervision as well. And they also say that the apartment staff provided some misleading and unverified information that led to that police response that ended in the shooting death of Roger Fortson. I want to play for you this news conference that wrapped up just a couple of minutes ago, a few minutes ago actually, as Attorney Ben Crump speaks with family members as well of Roger Fortson.
Against Deputy Duran of the Okaloosa Sheriff's Department. This is pursuant to 42 U.S.C. 1983. Count 2 of our lawsuit is the Monell lawsuit against the sheriff and the sheriff's department. because we believe Roger's death was as a result of a pattern and practice here in Okaloosa County. And we'll talk about that in just a moment. Count 3, wrongful death based on the state of Florida statute 768.16 against Deputy Durand and the sheriff. Count 4, a state claim of negligence against the Eden apartment complex and their apartment manager. We'll talk about that more in just a moment. And count 5, the final count of our complaint is gross negligence against the Eden apartment complex and their apartment manager. So let me take just a few minutes before you hear from Attorney Jackson, and then finally from Roger's mother, Mika, and then we'll take some of your questions. A little bit more about why we filed this lawsuit and what the counts really mean in layman terms. We could talk about Roger Folsom and his goodness, what he meant to his mother, what he meant to his brothers and his little sister, to his community. We could talk all night, Reverend. He was a patriotic young military airman. He was legally armed in his own home. He was gunned down within 2 seconds of opening his front door, even though he was following the commands of the officer who killed him. You remember his last words when you watched that video. He was trying to do everything that the officer asked him to do. As Attorney Jackson and our experts looked at it, the gun was in a down position. He was opening the door for what he perceived danger. So like any American citizen, he had a right to the Second Amendment too, to protect his home, to protect his castle. He didn't do anything wrong. He didn't do anything that any American citizen would have been allowed to do. And so we pray that the NRA stand up for Roger Folsom's right to the Second Amendment too. And so when we think of how he shot Roger in less than 2 seconds, this is not policing. This is an unlawful execution. This was not a tragic mistake. This was a predictable and preventable outcome of broken policing, rooted in poor training, reckless escalation, and zero accountability. The sheriff's office knew they had a problem. Another deputy had shot at a handcuffed suspect just a few months earlier because an acorn hit his car. And they did nothing. There were no new policies, no remedial training. There was nothing done to prevent excessive, unjustified shootings by Okaloosa sheriff's deputies. And now Roger is dead. We're here to declare that this veteran life matters. That lawful gun ownership in your own home cannot equate to the death sentence, and that justice must be served in Okaloosa County. It must be served in the court of law, because that's what Roger went halfway around the world
to fight for as a military airman, that the Constitution applies. And so we have to make sure that the Constitution applies to him. This lawsuit sends a message when you allow untrained deputies to hide behind doors based on hearsay and shoot citizens without cause. There is a legal and a moral price to pay. But it's not just blood on the hands of Okaloosa County Sheriff's Department. Roger Fortson's blood is also on the hands of the Elam apartment complex. Let's be clear. The deadly police encounter began with alleging the complaint with false, reckless, and unverified claims made by a leasing agent who had no business planned dispatching. The apartment complex is not innocent at all in Roger Fortson's death. Their employee, we believe we can prove, made multiple false statements, not based on facts or first-hand knowledge, that sent a deputy to Roger's door with his gun drawn. The apartment employee, who is Jane Doe in the lawsuit, told 911 that a woman sounded scared and that people were actively fighting in Roger's apartment. But she never saw or heard anything herself. It was all speculation, hearsay. And that speculation got a 23-year-old patriot named Roger Fortson shot and killed by the Okaloosa Sheriff's deputy in less than 2 seconds. We keep saying 2 seconds because we need you all to put the pieces to the puzzle together so it'll be clear for everybody to see. It started out with these allegations, unfounded, and then it led to broken policing and lack of training that led to him opening his door, and in 2 seconds, he was shot, dying, with his little dog barking in the background. Not only the Elam Apartments had a duty to act responsibly when calling law enforcement. You cannot make 911 calls like you're gossiping in a break room and expect no consequences. Not only did they fail to train their staff on how to handle emergencies, they doubled down when their agent escalated the situation by feeding Deputy Duran this gossip, this inflammatory information at the scene, that there was somebody sounded scared and they were fighting in Roger's apartment. Roger was in his apartment by himself with his little dog, playing video games, chatting with his girlfriend. He was by himself. It was the wrong apartment. And had they not based everything on speculation, maybe the deputy would have gotten the right apartment. This wasn't just negligence, it was gross negligence. They turned an ordinary day into what would be a death sentence with their carelessness and their negligence. And under the Florida law, they must be held accountable because Roger Fortson's life mattered. And for them to be able to have no accountability will be ashamed before God. They cannot wash the blood off their hands and try to pass the buck just to the sheriff's department. No, both of these entities have blood on their hands. And no matter how much they try to wash it, as we stand in the house of the Lord, they cannot go unaccountable. There must be accountability. We are suing the Elon Apartments because justice for Roger Fortson means holding everybody responsible. He deserves full justice. He doesn't deserve 3/5 justice. He doesn't deserve half justice. If anybody deserves full justice, it's Roger Fortson. It's not just about the man who pulled the trigger, but it's those who lit the fuse, who loaded that gun that was loaded by speculation, hearsay, innuendo, and gossip. Can you imagine being killed because somebody said they thought it was you? I mean, it's heartbreaking. Heartbreaking. And so, Roger Fortson deserves justice. If this was your child, wouldn't you want the same? At this time, you're going to hear from Roger's mother, who is still completely devastated. The years passed, but the pain is just as bad as it was when she first came to Okaloosa County. Her son is never coming back, and there must be accountability. Continue to pray for her daughter, her family, who miss Roger every day. Every day. Not a day goes by that she doesn't think of Roger. So help us have his legacy of justice. Let's continue to pray for her in the nights when nobody's around. Roger was her hope in so many ways. And so many people from our community know that our children represent a hope for us. Deacon Forson is going to talk to you about why we have to get justice for Roger Forson.
Good afternoon. I don't know why people keep saying justice. It's no justice for my baby. I want accountability. I want accountability because he was 23. I want accountability because he had life ahead of him. I want accountability because he was in his own home. I want accountability because Florida gave him a permit to carry the gun that he had pointing down. I want accountability because he opened the door with his left hand thinking that he was safe because it was the police he was opening the door for. Roger's not right hand, Roger is left handed. I can't express that enough. May the 3rd, I looked at my son's funeral. And my daughter-in-law sat beside me and said, "Do you remember anything about that funeral?" And I had to tell her no. I said, "Why did I walk to the casket? Who was the lady grabbing me?" And she was like, Mika, I don't understand, and I had to tell her. I lost my lifeline. My baby was one call, that's all. He could feel when his mama needed him. As far as even the apartment, I found his lease. You guys have an off-duty state patrol. Why didn't the state patrol go to the door? The sheriff department, you looked me in my face and lied to me. I will never forget it because you put it on your mother. And at that time, I was a grieving mother. You said on your mother, if you find anything wrong, you was going to do something. You got up, went to the podium, and tried to paint my child as a bad person. You looked me dead in my face and lied. I have to come down here to a county that I have no faith in. I do not trust at all. Because of these laws, his case can't.
Hearing from family members of Roger Fortson there speaking at that news conference just a little bit ago, wrapped up just a little bit ago in Fort Walton Beach. Meanwhile, you are taking a live look inside the courtroom in Brevard County at the Brevard County Courthouse in Viera, where the trial has been going on all day today for the Brevard County teacher facing charges of disorderly intoxication and resisting an officer. We are still standing by for a verdict on that. We will have the latest updates coming up in just a couple of minutes. As we continue Fox 35 News Plus coverage, we will have our top 4 at 4, where we break down the 4 big stories that we are keeping an eye on in the Fox 35 newsroom today. So keep it here on Fox Local and on YouTube. More coverage to come in about 2 minutes.
You're watching Fox 35 News Plus, streaming on Fox Local.
Well, good afternoon to you and welcome into Fox 35 News Plus. I'm Garrett Wymer and thanks for joining us on this Tuesday afternoon live on Fox Local, fox35orlando.com, and also on YouTube. It is 4 o'clock. That means it's time now for our top 4 at 4, where we break down 4 of the big stories that we're keeping an eye on in the Fox 35 newsroom today. And joining me for today's top 4 at 4, Fox 35 News anchor Luann Sorrell. And Luann, we appreciate you joining us.
No problem. Good to be here.
So our big story of the day, we are on verdict watch right now. Here's a live look inside the courtroom in the trial of this Brevard County teacher.
Yeah, Carly Anderson is accused of being at a party with more than 100 underage students. They were drinking, allegedly doing drugs. One was passed out on the front lawn. She's facing 2 misdemeanor charges for allegedly being at that party and then interfering with police when they arrived and they tried to help the student who was passed out on the front lawn. Now, we know that a lot of things happened today in court. We had opening statements. We had a paramedic and a police officer take the stand for the prosecution. And the defense really didn't put on a defense. They just said she can say whatever she wants to police because that's her First Amendment right. You've probably seen the video where she's screaming and cussing in the EMT and police officer's face, telling them to get out of there and just go away. And that's what got her in this position. She was actually offered a plea deal. And they said, we'll give you no jail time, just take this plea deal. And she said, no, I'm taking this thing to trial. So here we are.
Yeah, here we are, and waiting now for a verdict. It was about 2:45 that the jury first retired to the deliberation room, beginning to deliberate. So we're coming up on about an hour and a half of that. So we will see. It was not a long trial, not many witnesses called.
I was surprised.
Yeah, it did not take long at all. But opening statements this morning, and then closing arguments this afternoon. Just a little bit ago, you heard from the prosecution talking about her behavior that night and how they say it endangered the safety of a 17-year-old kid that they were trying to help. Meanwhile, the defense said that yes. You mentioned the body camera video. Yes, this was bad behavior, but that doesn't make it a crime. Here's a little bit of the closing arguments.
Carly Anderson was not only intoxicated at the time of this interaction with Corporal Brown, but she knew that she was intoxicated. And that second element, she endangered the safety of another person. Her interaction with Corporal Brown, her yelling at the EMTs, causing a scene, being drunk and belligerent, endangered the safety of the minor child, CR, who was in the back of the patrol car at the time that all of this was going down. Whether this encounter lasted 30 seconds, a minute and 30 seconds, 2 minutes, 3 minutes, an hour, that doesn't really matter. Something bad could have happened in the matter of moments.
So, because this case got out of control, received all this media attention, the state attorney's office has felt the need to squeeze something out of it. And the only choice Mrs. Anderson had was to take it to you, take it to the people. And she's asking that you give her the benefit of every reasonable doubt. If you want to look at the video again, you can. It's just as bad as the first time you saw it. She's having bad behavior, but it's not a crime.
So we will see who the jury ends up siding with.
Yeah.
And it's
Hopefully
all up to
today
them.
It all wraps up. Yeah,
Yep.
everything in one day. That'd be nice.
Very efficient when it
Yes.
comes to a trial there. Well, this afternoon, story number 2 here. We're learning some more details about this deadly bear attack in Collier County.
Yeah, we are learning some new information. We now know that an 89-year-old man was mauled by this bear, and his dog was as well, and they both passed away. Happened early Monday morning. There still isn't a whole bunch of information that came out. They don't know if this man was walking his dog, if he was hiking, if he was camping. All they know is that he was attacked and killed by the bear along with his dog. And now, as a result of this, FWC has killed 3 bears and set up traps to see if there are any more bears in this area. They're going to send the DNA from the bears up to a lab in Gainesville to see if they caught the bear that actually mauled and killed this man and his dog. But just a very disturbing story. We hear of like bear attacks pretty frequently here in Central Florida. But this is actually the first deadly bear attack in our state, which I was unaware of, that no one has ever been killed by a bear before. But yeah, a sad story out of Collier County.
That is crazy, because you're right. We do hear about, and we see videos all the time of encounters that don't escalate to the point of an attack necessarily, but we do hear of those attacks, every so often. But yeah, to this extent, it's kind of scary to hear, and Still a lot of questions at this point.
Yeah, we do.
Story number 3, and that is some new video released in a Sanford drive-by shooting that was a big story last year.
Yeah, a lot of people remember this story. The victim was a Seminole High School student. My son actually went to school with her. She was supposed to graduate last year in 2024, but because of this shooting, it took her a little bit longer. She was shot in the back of the head. Here is the drive-by shooting. Police in Sanford are now searching for 4 people seen in this red SUV. Layla Bennett was outside. The girl you see running from the car, that was actually her friend. She was grazed in the head by a bullet. Layla's actually in the street next to a man in a white shirt. She was the one who was shot, gone through extensive physical therapy, surgeries, and Amy Caulfield actually sat down and spoke with her. It kind of surprised all of us that they had this video for a year now. It's been more than a year. But they thought they had some leads. They thought they were going to probably get some people to turn on each other, but nothing actually came to fruition. So no one's been arrested in this case. So they released it to the media, hoping someone knows who the gunman is in this case.
And Luann, watching this video, it's terrifying to see because you can see the dirt fly up where some of those bullets are hitting. You just see multiple shots being fired as they drive by. What a scary situation there.
Yeah, they could have hurt a lot more people. There's Layla over there on the right standing next to some other people. So it's really a miracle that she was the only one who was really shot, because a lot more people could have been. This was broad daylight in a neighborhood.
Yeah. And you mentioned Amy speaking with Layla, and one of the things Layla told her, we've got a soundbite for you here, is about she felt like God gave her a second chance.
Do you feel like God gave you a second chance?
Definitely. Definitely, because before that, I didn't really push him to the side. So I think he was like, I'm sorry I have to do this, but you have to trust me.
She has been through a lot.
Yeah, it's good to see her doing so well, and we hear she's graduating this year.
Yeah.
So that's awesome. We love to see her doing so well after. We were really worried about her, and so were her classmates for a really long time.
Yeah, glad to see her taking those steps forward. Our 4th story of the day, and that is a new contract for a national champion.
The Florida Gators coach got a big old contract, didn't he? Todd Golden. Not only did he win the SEC tournament, he also won the NCAA tournament for basketball. So he was rewarded with a big contract extension, a 6-year contract extension worth $6.75 million a season is what I'm hearing. So yeah, that's kind of a big deal. He's going to be a Gators coach until 2031 now, and he really deserves this. He really took them to the pinnacle of basketball championships. It's been a while since they had won one. So a lot of Gators fans were very, very happy, and I'm sure they're going to be happy to hear that he's going to be staying there for a lot longer.
I guess that's a good time to renegotiate a contract right after you win a national championship.
Absolutely. No better time than that.
A little bit of leverage,
yeah,
I would
just a
say.
little.
All right. Well, Luann, we appreciate you joining us. That is today's Top 4 at 4. We're going to take a break here on Fox 35 News Plus, but we'll be right back. Hey, TJ, you got me? You got me okay? Yes, I've got you. Cool. We're 20 seconds out.
Awesome. Sounds good.
You're watching Fox 35 News Plus, streaming on Fox Local.
Fox 35 Storm Team meteorologist TJ Springer joins me now. And TJ, I know you had an eventful day out there in the Thunder truck yesterday.
Oh my gosh, Gary. Yeah, that was unreal. I mean, it got really bad in a hurry as we got out toward the coast yesterday. Saw a fire from only you can imagine a lightning strike and some really just intense rain, as well as some hail too. We kind of went through it in the Thunder truck yesterday.
Yeah, my goodness. Going to be hopefully not quite as eventful today?
Yeah, it's definitely not looking quite as bad as what we saw yesterday. Garrett, still a few showers and thunderstorms out there. We do have this same frontal boundary that is stalled across central Florida, so that's kind of driving that storm threat. That as well as the sea breeze. So between these two factors, we're still going to stay somewhat unsettled here through the remainder of our Tuesday afternoon and evening. Fox 35 Storm Tracker radar pinpointing some of the heavier rain right now concentrated closer to the coast in places like Brevard County, from just to the west of Melbourne, Satellite Beach, kind of hugging the I-95 corridor, and then up closer to the Cape. We're seeing some heavy rain right now, but certainly a lot of lightning south of Lake Poinsett with this activity. So if you are traveling, make sure you keep your eyes to the sky and that Fox 35 Storm Team app. You can get all of the latest radar in the palm of your hand. A few sprinkles up closer to Ponce Inlet and Flagler Beach, kind of splitting Flagler and Ormond beaches. These were looking a little more intense just a little bit ago, but these have kind of faded away. Not a lot of upper level support today, but we have the instability in the air. We have the moisture in the air, so that as well as the lift. We'll likely see these perk up and then slowly rain themselves out, kind of an erratic storm motion too as we progress through the remainder of our Tuesday. I think once we get toward our Tuesday evening, these should start to slowly diminish. But notice it is pouring around the Space Coast. It's a live look in Titusville right now from our Launch Credit Union camera. You can see how gloomy and wet it looks, and with the rain, temperatures have been dropped a bit from Cocoa Beach to Titusville, New Smyrna, all in the low 80s. But notice inland, 90s from Leesburg to Winter Haven. It is 89 right now in Orlando. We have 86 in Ocala. The temperatures rising today. That boosts the instability in the atmosphere. The moisture content is there. That's why we have this low-end threat of severe weather. Kind of like yesterday, we had that heightened risk, though. We actually saw level 2 out of 5, or that scattered threat of severe storms closer to the coast yesterday. Today, it's a level 1 out of 5, but that still means that a couple of storms, if they can organize, could turn severe, could include some gusty wind and some small hail. So that's something to keep mind of if you do have any outdoor plans through the remainder of our day. Let's time them out here on our Fox model. That's our future clouds and radar picture through the remainder of the evening, through the evening drive. You can see these dancing around Central Florida. Notice they're not really all moving in one direction. That's because of the lack of upper level wind. So with these, they're kind of just dancing around, so to speak. Then they rain themselves out, fizzling out as we head through 10, 11 o'clock. And then we'll see some clearing as we head through the wee hours of our Wednesday. But then another disturbance starts to move our way as we head into our hump day. We're dry to start, no issues for the morning commute, but notice throughout the afternoon we start to see more showers and thunderstorms starting to develop, scattered in nature, hit or miss, and I wouldn't be shocked if we see another marginal risk tomorrow. We'll have the instability, we'll have the heat. That's something that'll help drive that potential for a few stronger storms again tomorrow afternoon. This is good news. We need the rain. We're in a more unsettled pattern here at home, and that's going to stay really as we head through the next few days. Tonight we're back down into the upper 60s and lower 70s, staying above normal for this time of the year. Then tomorrow we are expecting that chance for hit or miss showers and thunderstorms again, with highs staying parked right around that 90-degree mark. So you might want to have the rain gear and the umbrella with you just in case if you have any plans outdoors on Wednesday. Now, as we look forward to the weekend, late Friday into Saturday, that's when our next storm system is moving, and you can see this cold front, and this brings more widespread showers and thunderstorms as we head through Saturday into our Sunday. So it's definitely looking like a wet weekend. I don't know if Saturday will be a washout, but certainly wet. I think Sunday looks to be the wetter day as this front is on top of us. We'll also have to watch the threat of some strong to severe storms as we start to increase the dynamics in the atmosphere, as we have an upper level area of low pressure that'll be kind of sitting pretty close to the southeast, kind of driving that chance. That's something we'll have to monitor. So be sure you stay tuned to not just our forecast here today, tomorrow, through the rest of the week, but over the weekend for sure. Now, looking forward to the future, May 12th through May 16th, we still look wet. You can see the darker shades of green. That's that higher chance of above normal precipitation. So this is some good news for the drought. Little by little, we can hopefully eat away at how much we've been dry over, it seems like, the last couple of months. That's some good news in that regard there. Now, our Fox 35 Storm Team 70 forecast shows chances each and every day becoming higher over the weekend. With the rain, the clouds, temperatures are going to be a little cooler, lower to middle 80s as we head into early next week. And I'm thinking probably Monday and Tuesday, Garrett, for sure, those chances for severe storms look a little bit greater. I know it's still at the end of the 7-day, but we'll be watching those days closely for sure.
All right, something to keep an eye on. Fox 35 Storm Team meteorologist TJ Springer, we appreciate you joining us this afternoon.
Thanks, Garrett. I appreciate it.
And we were going to go ahead and get you back inside the courtroom here because the judge and the attorneys just came back with a question from the jury. Their question is, what does obstruction mean? They want the legal definition of that. So the judge, the attorneys discussing what they will say to the jury when they bring the jury back in to answer their question. It's been about an hour and a half now that they've been deliberating, the jury has. So let's go ahead and listen in back inside the courtroom in Brevard County.
Were conducting an undercover drug operation, I believe it was, and bystander who was looking out and observing that decided to shout out, "Look out, he's a cop, don't interact with him, don't throw drugs to him." But I think that was where the intent came from, was that the defendant in this case's intent was clearly to intentionally interfere with their lawful investigation. But I would argue that sorry.
No, that's fine.
The jury instructions don't include any type of element of intent. It's a general intent crime, so I think it would be misleading and an error to require that there be language involving intent. So I believe that it could be intentionally hindered or also did in fact hinder.
All right. Do you want to respond to her?
You're not guilty of a crime if you accidentally hinder a police officer doing something. It's all about intent.
But it is a general intent crime, too.
So, it's like driving along, cop is behind you trying to pass you. He's trying to go someplace. If you don't get over fast enough, you have hindered his progress, but you haven't committed a crime. And I remind the court that criminal law is all about intent.
All right, just give me a few moments to finish it up reading.
In this case, it doesn't involve just words. It says the focus thus should be on whether the defendant's false statements were intended to hinder the police officer in the exercise of his duties, not on whether the defendant's ruse achieved the intended result.
Anything else that y'all want to share or argue regarding this?
Just that, I guess as I said a moment ago, I believe that the facts in this case differ greatly from the facts that are present in the instant case. I think the state's purpose in filing this case was to flesh out the meaning of the word obstruct, which this court held to be similar to hinder, if the jury is looking for a specific definition. But if the parties cannot agree on the definition, the state would request that we use the information that Your Honor provided.
Okay. So yeah, after reading the case, I agree that the scenarios in there are different than the facts in this, and I still have a concern that the standard jury instruction for resisting an officer without violence has been, I think I said, was adopted in 81 and been revised 4 times, and they still have not defined resist, obstruction, or oppose, or that has, for some reason, never been added to it. So, and my thought is at this juncture is to give them the instruction that they must use their common understanding of the word obstruction, and as well as the jury instructions.
Okay.
Well, let me go ahead and, to make the record clear, is there an objection from the defense of me doing that, as the state said they're okay with it? Is there any objection to that?
We do object to that, Your Honor.
Okay.
However, I understand your ruling, and I'm not trying to obstruct or oppose you.
Okay. For the record, can you just say, you've said a few things, so I want to make the record clear. What is it that you would like in lieu of the instruction that court intends to give?
On the case provided by the state, which is State v. Legnowski.
Yes.
27 Southern 3rd, 794. It talks about...
Can you direct me, like, either what page or where you are, paragraph-wise?
Yeah, it's third page, bottom right corner.
Okay.
Legnowski's words were intended to hinder, prevent, or obstruct Deputy Darst's legal duties of serving process and taking Cotero into custody. So the definition, Legnowski's words were not mere verbal expressions challenging police action. Rather, on their face, they were intended to impede the officer. So the definition should be words or actions that are intended to impede the officer in the execution of his duties, according to this case, and that's what the defendant would like.
All right. I am going to proceed forward with what the court has suggested. I'm going to write it on here, and I will give the parties a moment to come up and look once I have it written. So. All right, the parties can come up just to view the response. We will be in recess until we hear back from the jury.
What does obstruction mean? That was the question from the jury asked just a couple of moments ago, and the answer they worked on to send back in writing to the jury. So back in recess, we continue to be on verdict watch in that trial in Brevard County of Carly Anderson, the teacher facing charges of disorderly intoxication and resisting an officer without violence. And I want to kind of pull up these graphics again to discuss the elements of these charges here briefly, and we can talk about why the jury may have had that question. So there are 2 counts. I just told you disorderly intoxication and resisting an officer. The disorderly intoxication charge has 2 elements that involve intoxication. Was Carly Anderson intoxicated? As we talked about earlier, that was basically all but admitted. And the second element being that she would have endangered the safety of another person. That's referring to the 17-year-old kid. The prosecution tried to prove that the 17-year-old who had too much to drink and was sick, throwing up, that the officer was taking care of. They're trying to argue that the confrontation between Anderson and that officer endangered the safety of that 17-year-old because the officer then was not able to keep watch over that teenager. The obstruction comes in the second count. So that may give us an indication that in the hour and a half that the jury has been deliberating, they have perhaps decided on count 1 and have moved on now to count 2, which is resisting an officer. It is resisting without violence. Here's the elements of that charge. There are several of them. There were just 2 elements in the disorderly intoxication charge, but 4 elements in the resisting an officer charge, those being obstruction of Corporal Brown. That Corporal Brown, who we heard testify today, was engaged in the lawful execution of a legal duty, that Corporal Brown was an officer, and that has been stipulated to, and that Carly Anderson knew Corporal Brown was an officer. So the jury's question about the legal definition of obstruction. If we had a check mark here, we would put a check mark on Corporal Brown was an officer. We would go ahead and put a check mark on status of the officer known, because we know that, as the defense said, that the 2 knew each other, that Corporal Brown worked at some points as a school resource officer in the school where Anderson taught. The questions that were the elements of this that were really up for grabs were the lawful execution of a legal duty, and the prosecution saying that Corporal Brown, and as he testified to, has a duty as a community caretaker and had the responsibility and a legal duty to take care of that 17-year-old in the absence of their legal guardian. And so that would be what's being referred to there as a lawful execution of a legal duty. Now, whether the jury agrees with that or not, we will see. But the question about whether obstruction and whether that confrontation between Corporal Brown and Carly Anderson would have obstructed Corporal Brown from that act. And so the jury wanting the legal definition of obstruction, we heard them kind of hash that out with the judge and the attorneys. You heard the defense also lodge an objection there, so still some things to watch. It's been about an hour and 45 minutes now, coming up on 2 hours since the jury first retired to deliberate at 2:45. So we are still on verdict watch here. We're going to step aside, take a quick break on Fox 35 News Plus, but we will be right back after this.
watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us on this Tuesday afternoon, live on fox35orlando.com, Fox 35 News app, and on Fox Local, and on YouTube as well. What I meant to add at the end there. Sometimes doing too many things at once here, and the gears just stop working. So the House Select Committee on Property Taxes is going to meet again in Tallahassee next week. This is the new committee that was appointed by House Speaker Danny Perez to look at the issue of property taxes, potentially getting rid of them. This has been a big topic of conversation, something that the governor wants to be a priority. The House Speaker has said he wants this committee to come up with a joint resolution by the end of the year for the state lawmakers to vote on during the very first week of the 2026 legislative session, to hopefully put on a ballot for you and I to vote on in November of 2026. So one of the members of that select committee is Representative Anna Escamani, a Democrat from Orlando. Earlier today, I had the chance to talk with her about the work of the committee, some of the questions that she wants answered. But the first thing I asked her was, why did you want to be on this committee?
Right now, Florida families are struggling to make ends meet. And whether it's the cost of property insurance or the cost of groceries or just the everyday expenses like property taxes, it's important for legislators and elected officials to be at the forefront of these conversations to find compromise to deliver results and relief to our families. And so when the opportunity arose to serve in this committee, I made the request immediately. I also serve as the ranking member of the Ways and Means Committee, so I have a lot of tax experience and tax background, and take pride in the tax breaks we've been able to give Florida families over the past 7 years that I've been in this position. And we have an opportunity to make major systemic changes to property taxes, but I want to have level-headed conversations and be collaborative with local government, with constituents, with different stakeholders to ensure that the solutions we bring forward to the voters in 2026 are going to be an approach that lets everyone win versus an approach that defunds local government without any type of safety net for them to be able to continue to support the essential responsibilities like public education, police, and fire.
With that being said, then, what did you think of some of those initial kind of springboard proposals from the speaker?
Yeah, well, these proposals were a fair starting point, but some of them were actually just laughed out of the committee, even by my Republican colleagues. So I think it's important to be open to all ideas and concepts, but I'm grateful that this committee is going to be very collaborative. I've actually asked if we can host meetings outside of Tallahassee and bring the conversation to our constituents at a local level. I'm already organizing a roundtable with some of our local elected officials in Orange County. And so they were a decent place to start conversations, but there really has to be not just vetting of ideas, but data. We need data to make informed decisions, and we are in the process of collecting information from local property appraisers, tax collectors, of course, from the Department of Economic and Demographic Research, so that we can have the best information to then drive policy from.
Because this, I mean, to be frank, this is a major issue and would have major implications and major ramifications, maybe in some ways that we don't even fully know yet.
Yes, 100%. We have any changes to Florida's property tax structure has to come from the voters. At the end of the day, the voters make decisions on what their property taxes look like. And of course, at the local level, you have the ability to change millage rates, but even that can have huge political consequences, and it doesn't always shift over time. What we have seen is that property values have gone up, and with the increase of property values, so have your taxes. And some people can afford that shift, but a lot of folks can't, especially those on fixed income. And there's also the reality that when you buy a home, let's just say you're a first-time homeowner and you purchase a home, chances are you're going to be paying a lot more in taxes than your neighbor who's been there longer than you due to portability. And there's a larger question of, is that fair? That a house in the same neighborhood with the same infrastructure and so forth would have different property value, same property value rates, but different property taxes just because of the longevity of the home ownership. So there are bigger conversations for us to have, and though it is, of course, historic, if there were changes to be made, I do think that our constituents are asking us to evaluate the current structure. And my hope is that in this collaborative approach, we'll be able to come up with policy solutions that don't defund local governments, provide them with flexibility to cover these everyday costs, while also trying to deliver relief to that everyday homeowner and renter. Because that was a part of the conversation too that we had in our first committee, was that renters also pay property taxes, just passed down to them from the landlord. But if you make adjustments to property taxes, how do you ensure that a renter feels and sees the relief? So these are all the conversations that we're having right now, and more to come.
What are some of the main questions that you think need to be answered before action is taken?
Well, the biggest question is alternative revenue generation. So for folks who don't know, Florida is a very sales tax reliant state. So when you look at our budget of $117 billion, the avenue of revenue is coming from 3 main locations. One is federal dollars. Florida does benefit from billions of dollars of federal money, often in the shape of Medicaid reimbursements and other types of state-federal partnerships. We also have state trust funds. These are programs that are funded by the taxpayer, but for specific purposes. So for example, when you buy a home, you have a document stamp tax that goes into a trust fund. When you buy gas, the transportation tax goes into a trust fund. And then you have what is known as general revenue, and that's made up of overwhelmingly of sales tax, some corporate income tax, but mostly sales tax. So that's how the state generates revenue. But local governments generate revenue predominantly from property taxes. So the bigger question that we're grappling with is, this is $50 billion in local property tax revenue that is funding essential government services like public education, law enforcement, and fire, alongside your everyday utility needs and so forth. So the big question is, how do you replace that revenue? Because those are not expenses that can go away. No doubt there's always opportunities to trim down a budget, but at the end of the day, the essentials of government include high quality education, safe communities, and that is why you need local governments to fund these institutions. So that's the question, is how do you replace that revenue? Because at this point, the alternative has been to increase sales tax, but that really isn't sustainable. You would have to potentially double sales tax in Florida from 6 cents to 12. And it would also then impact shopping behavior, where folks may purchase less, thus generate less revenue. So it's not necessarily the most sustainable or popular route to go.
So where do you hope things go from here with these ongoing committee meetings?
So we're likely to have our next meeting in a week. We're back in Tallahassee as we have extended legislative session. So session is not over yet. We're still needing to confirm and finalize the state budget. My hope is to continue in the learning phases. As I noted earlier, we've requested data so we can make decisions with more information. I also have asked the committee to travel to other parts of the state to host town halls so we can actually hear from local government officials and the community on what they want to see, what their concerns are, what their ideas are. And from there, bringing together the data, the stakeholders, to knock out some concepts for the greater legislative body to consider. But at the end of the day, every idea would have to be approved by the voters. So this would be a potential 2026 election debate, assuming that we're able to work with our Senate colleagues on the other side of the chamber to get their feedback and guidance and advice and insight on these concepts as well.
All right. Well, I think that's some of the main points I wanted to hit. But is there anything else you want to add that we didn't cover before I let you go?
It's a great question. I would say that part of this debate, part of this discussion is also, of course, grounded in tensions between the legislature and the governor. But I'm very hopeful as it pertains to something like property taxes, and we can put aside any type of inner party or external party politics and dynamics and focus on delivering relief and results to our families.
Well, that was Representative Escamani in a conversation that we had earlier this afternoon, or excuse me, this morning it was, I guess it was. Now, we also heard from Governor Ron DeSantis, who held a news conference in Miami today. We played for you a big chunk of that during the 3 o'clock hour. He, at the very end, talked about property taxes and what he wants to see, and he also called that House Select Committee a dog and pony show, saying, and had some other strong words for the House leadership specifically. But here's what Governor Ron DeSantis, his take was this afternoon on the property tax discussion.
You know, one of the things that I called on for many months now and have huge support from the people of this state is what Florida families would like. You know, we don't have an income tax. We're never going to have one as long as I have anything to say about it. So we don't have to worry about that. At least not yet. Who knows down the road? But for me, like, don't worry. Like, it's never going to happen. But and then we're fortunate that we have 142 million visitors last year. A lot of our tax revenue is paid by non-Floridians. The tourists, the Canadians, the snowbirds, like, that's a good thing. So we have less of a burden on Florida families. But the one thing that is pinching people are property taxes. And so I said, you know, ultimately we want a constitutional amendment on the ballot because this is local governments, you know, that are doing it. The state's role is minimal. We can't just, you know, change the millage rates, although there is this, you know, required local effort that we could definitely relieve people of, and we're working on doing that. But in the before you get on the ballot, you know, people can get relief now. We had a great proposal that would give people, homesteaded Floridians, particularly middle class, you know, $500 to $1,000 rebate on their next year's property tax bill, November, when you get the notices going out. And that would be like really, really good. And we have a lot of support from individual legislators. But, you know, this was not anything that the House leadership was willing to entertain, and largely just because they want to be different than me. If I'm saying property tax, they're saying, you know, they actually want to cut taxes for Canadian tourists. You'd get like $40, I think, a year and no property tax. Are you kidding me? So, but they realize that that's not a good spot to do. And so what the House leadership did, the last day of the legislative session on Friday, convened a committee of 37 people, including some of the most left-wing Democrats in the state of Florida. We have almost a 3-to-1 Republican majority. You shouldn't be trying to resurrect the Democratic Party when you have a 3-to-1 majority. You should be winning and continuing our wins. Instead, they're doing that. So you're putting very far left on this committee, and then they have a hearing on the last day of session. And I don't even think I need to say this because I think most people get this, but if you have a legislative body that is creating a 37-member committee, they're not doing that because they want to give you property tax relief. They're doing that to try to kill property tax relief. So this is a total dog and pony show. This is not anything that is credible. The fact that you would wait until the last day of the legislative session, that just shows your cards. It shows, you know, what you're trying to do. That's not what the voters sent any of these guys there to do. They want relief from property taxes, and we have an opportunity to do that. Doing that committee, you know, and have very left wing on the committee, that ain't cutting it. And I don't think anybody is fooled when they start to see those types of things. If I wanted something done, I do it. I don't put a committee of 37 people together where they're not going to be able to agree on anything. So just know that that's something that is that was done at the last day. Obviously, they didn't even come close to doing a budget. They didn't come close to doing, you know, their basic core constitutional functions. And so now they're saying they're going to, you know, do it by sometime in June. The reality is, it's honestly not that difficult to do any of this stuff. You know what you do? You just look back what's been done under the last 6 years. You look at when Wilton was Senate President, or Kathleen Pasadoma, or Paul Redder. You just look at that and you basically copy and paste. That's really all you have to do. You don't have to do much different, and so it shouldn't be that hard to get this done and to just do your job. But when I see a committee of 37 people, when I see far left Dems being injected into this process, when you have a 3-to-1, almost a 3-to-1 Republican supermajority, which, by the way, they didn't have before I came along. So why would you be doing that? I have no interest in trying to throw a lifeline to the far left. Floridians have rejected the far left. That's not what they want. They want the solid, bold, conservative vision that we've had, and that's what we're going to insist.
That was Governor Ron DeSantis talking about property taxes this afternoon in Miami. We're going to take a break here on Fox 35 News Plus, but we will be right back after this.
You're watching Fox 35 News Plus, streaming on Fox Local.
Welcome back into Fox 35 News Plus. I'm Garrett Wymer, and thanks for joining us here on this Tuesday afternoon, live on Fox Local, fox35orlando.com, and also on YouTube. Been a long day of covering this trial in Brevard County. I will note, we've had a live shot for you up from inside the courtroom. We lost our pool feed. Looks like they have powered that down for the moment with things being in recess. So we'll try to get that live picture for you back up as soon as we get it back from the pool camera. But we are continuing to monitor developments with that verdict watch in Brevard County. But I want to play for you a news conference this afternoon on Capitol Hill, where we heard from Congressman Randy Fine, one of Florida's two newest congressmen. He represents the 6th district, the seat replacing Michael Walt, who is the outgoing national security advisor and has been nominated for UN ambassador. It was about anti-Semitism, and specifically an upcoming congressional hearing about it, and also about anti-Semitism on campus, and that was on college campuses. That was the main focus of what Congressman Fine had to talk about. Here's his remarks from just a little bit ago, earlier this afternoon on Capitol Hill.
Well, thank you all for being here. There's a lot of things where people could be spending this time this afternoon, but to be in a room like this, which is standing room only, is incredibly encouraging to me. My name is Randy Fine. I'm the newest congressman. I got elected 1 month ago, and I am many things in my life. I'm an American, I'm a father, I'm a proud Floridian. But among all of those things, there's one thing that I am most proud of, and that is that I am a Jew. And as a Jew, I have personally experienced the scourge of anti-Semitism. I experienced it my entire life, particularly as I grew up. And I made a solemn vow when my oldest son, who's now 17, was born, that he would not have to go through what his father did. And it is a vow that I have failed to live up to. You see, anti-Semitism today is as bad as it ever was when I was a kid. In fact, some can argue that it is even worse. So when I got elected to the Florida legislature 8 years ago, I said I was going to solve that problem. And if you look at the anti-Semitism you see around the country, we don't have as much of it in Florida because I was willing to fight that fight, often alone. So imagine my surprise. Imagine my joy and my gratitude and my appreciation that when I showed up here 4 weeks ago, for the first time, I had leaders that were as committed, if not more committed, to fight for this issue as I did. The two chairs that are right here, as well as our vice chair. Because the fact of the matter is, Jewish kids today are afraid. It's never been easy to be a kid going to college. Ask anyone. But no child should walk through campus today and wonder if they will make it from their dorm room to their classroom, or their classroom to the library, or the library to the dining hall, and they will be attacked. And that is not only happening, it is excused. And I would say encouraged at many of our institutions around the country. There are children that are scared to go to school, and in America, that is unacceptable. But for those of us that are Jewish, it is even more unacceptable because core to our faith and who we are is a belief in the power of education to take us from where we were to where we want to be. So I will say this to every Jewish student that is here. I am here, and I will fight for you. And I will fight along these amazing leaders every day to make sure that we solve this problem. And I will do it for one simple reason. My son is going to be going to college in a year, and I'll be damned if he's going to be afraid to walk through that campus. Thank you all very, very much for being here. But it is now my privilege to talk about the horrors, to make it real, to talk about what actually does happen. This is not esoteric. This isn't something that you read on a page. Michael, who's going to speak, can show you the physical wound, the scar that he has, that he got not in a war on the other side of the world, a scar that he got on his college campus where his wrist was broken and he had to go to the hospital. Not because he was being attacked because they wanted to mug him or any other reason. He was attacked and he was hurt for one reason, because he was Jewish.
That was Congressman Fine speaking at that news conference just a little bit ago on Capitol Hill. Well, that's going to do it for us here on Fox 35 News Plus today. Get ready to send you out to Studio B for Fox 35 News at 5, which begins in just a couple of minutes right here on our live stream of Fox Local. I want to let you know of one of the things that you're going to see. Fox 35's Marie Ettinger going to have new details in this DeLand shooting, the McCabe's Bar shooting that happened over the weekend. As we had on breaking news yesterday at Fox 35 News Plus at 4 p.m., Avante Williams is charged with second-degree murder in that shooting. What we have learned is that Avante Williams, here's the details on fox35orlando.com, he was a former DeLand High School football standout and a U-Miami football player as well. So we've got all those details right now on fox35orlando.com. This is something that Marie Ettinger has been looking into today. She'll have the latest details coming up on Fox 35 News at 5 here in just a couple of minutes. We also have the latest on what we know about that shooting. Still some questions about it, but we did have that news conference yesterday afternoon that we brought you live here on Fox 35 News Plus. We are also still on verdict watch in the trial in Brevard County, Carly Anderson, that we've been bringing to you live throughout the day, trying to get that pool feed back up. The camera shot had gone down, and so we're trying to get that back up. So we at least have a live picture, something to watch inside the courtroom while we wait on that. One jury question already, but we have now surpassed 2 hours, about 2 hours and 15 minutes that the jury has been deliberating now. So we'll see how much longer things take with that. We are monitoring that, and we'll have updates for you as well. So we appreciate you joining us. We've been a long day. We've been on since a little after 9 this morning, close to 9:30 when the opening statements began in that trial. So let's go ahead and send things out to Studio B for the start of Fox 35 News at 5. John and Luann getting ready for that newscast, which begins in just seconds right here on Fox Local.